The following video is based upon true crime content. Therefore, it may contain images and/or language that some find disturbing. For this reason, viewer discretion is advised. Good morning. Good morning, everyone. I'm having some technical difficulties this morning. I don't know if I've got them fixed, but give me just a moment.
Presiding.
You may be seated. Good morning. Yes, hang on just a second. My computer is black. That's not a good sign. It has been one of those mornings. Present with both his lawyers, Mr. Levine is here for the state. The jury is on the way up. Mr. Hertel tells me, but before that, do either of you have any authority on the issue that we were discussing yesterday?
I do, Your Honor. I found a couple of cases that seem quite illuminating. Your Honor, beginning with Tallman v. State, for the record, that's 120 Southern 3rd, 593. Tallman is spelled Tallman. And on page 1 and 2, it mentions that a juvenile does not have the right to exclude a parent from access or control over his or her personal belongings. To hold as such would undermine the inherent authority of a parent. The second case, State v. SB. And for the record, that is 758 Southern 2nd, 1253. Has a similar holding, including, we hold that by virtue of his parental authority, the father's consent overrides the juvenile's objection. And then it talks about some of the rationale behind that, including a father has the responsibility and authority for the discipline, training, and control of his children. In the exercise of his parental authority, a father has full access to the room set aside for his son for purposes of fulfilling his right and duty to control his son's social behavior and obtain obedience. When a parent, basically, the parent can, like the first case said, can do as they see fit. The parent is exercising his or her parental authority and control over the unemancipated minor child. So I would submit that those two cases coincide with one of the court's inquiry regarding that subject matter, Your Honor, that would further support the finding that the text message in conjunction with the attorney-client privilege law and argument and subject matter we've discussed, that should be admissible, Your Honor.
And did you place the case names on the record yet?
Yes, Your Honor.
You did? All right. Ms. Thornhill?
I have a response, as well as some cases, but I'll get to them if that's all right.
All right.
First, I found no authority that talks about a parent's unlimited right to go through everything. I understand the cases that Mr. Levine cited in connection with the Fourth Amendment issue, but of course, we're dealing with a different issue slightly. So, parental rights assume that the parent is acting in the best interest of the child. I think that's the foundation. But the child also has rights vis-a-vis the parents, and those rights change over time with the age of the child, right? So a 2-year-old or a 4-year-old, obviously a parent has much more control and much more ability and authority to intervene in their child's behavior, their belongings. As the child gets older, the child's rights increase in relation to their parents. At any rate, even if you find that this mother, Kathy Griffith, had the right to snoop or right to go through Collin's cell phone, I still have arguments that relate to his right under the Fifth Amendment and his Sixth Amendment and his privilege to communicate privately with his attorney. So first, the privilege is only waived if at the time the communication was made, Collin intended it to be disclosed. And you mentioned, should he known or should have known that his mom might look. That's possible, but we still have to look at his intent and then what the mother did with her, I'm gonna call it snooping, looking. When we talk about people who are in jail, inmates, even though they have very restricted liberties and their right to privacy is severely curtailed, there is still a means by which they can communicate privately with their lawyer, right? So we have attorney booths at our jail that are private, are not monitored. So they have that ability to exercise their privilege. if an inmate makes a choice to call their attorney from the monitored line, say just call on the phone, they are warned at the outset. This is being recorded and monitored. Anything you say is not private. And if they choose to use that phone, then shame on them and the privilege is waived. But the important thing is that they have a feasible option to exercise their confidentiality privilege. But what choice did Collin have? We talked about this. Could he have made a phone call? As you pointed out, there are surveillance cameras everywhere in the house that could have picked it up. Could he have gone to his attorney's office? He didn't drive, he didn't have a license. Could he have called his grandmother in another county? Possibly, but is that reasonable? A child has restricted agency by virtue of them being a child. He didn't have any other feasible options. And I don't think a child should have to give up a privilege because they are a child, which is essentially what the state's wanting you to find, is that unless the child can somehow on their own, or if their parent's not willing to cooperate, can get to their attorney's office and go inside the office without their parent, then they can't exercise their privilege. It's like putting the burden on the child to do something extra to preserve a privilege that other people have easier access to, which seems unfair. But in addition to that, Judge, I may have been wrong in how I deal with parents who want to be present in privileged conversations. Because the case law indicates that due to parental authority, but that also includes duty, because parents are close advisors, and it's natural that a child would seek advice from a parent, and that a parent would want to be involved to some extent in making sure that their child is represented adequately, also to facilitate the communications, so driving the child to the office, providing the phone by which the child could call their attorney. There is a case that I found, nothing in Florida that's directly on point with this particular issue. It's Doe versus Town of Greenwich. It's 473 Federal Supplement 54. It's from the District of Connecticut from 2020. A brief rundown of the facts. Two minors had an interaction where the female alleged that the male had attacked her, had sexually assaulted her. It's not a criminal case. The girl's family, on her behalf, sued the town of Greenwich, saying that they had not provided adequate supervision and investigated the criminal case adequately. So that's kind of neither here nor there. At any rate, the suit was between the girl and her family and the town. The girl's family, and it's unclear how they got these emails, but they obtained emails between the boy, now he was a non-party, but the boy and his lawyer, and the boy and his headmaster from his school, that discussed what he had discussed with his lawyer. All right, so the kid himself actually disclosed to a third person, his headmaster, communications between him and his lawyer. And the federal district court held that even though the other side already had them, and even though the child had purposely, so very different than what we have here, purposely told somebody about those communications and shared them, that the attorney-client privilege still existed, and that those communications were not admissible in court. So a couple things with this case. The court found, they talk about how minors are treated differently than adults out of a recognition that they do not always know, due to lack of maturity and world experience, what it is they should be doing or not doing. And given the various protections afforded minors in the law, it seems particularly harsh to summarily find that Roe, the boy, waived his attorney-client privilege when he shared privileged communications with his headmaster. During the investigation, Roe, the boy, was 16 years old. There was an investigation into his behaviors that left him scared and anxious, and it's clear that he considered his headmaster to be a friend and source of guidance and support. It goes on to say that under the circumstances presented, the court concludes that Roe did not waive his attorney-client privilege by virtue of his disclosures to the headmaster. So it talks about the protection of children and their rights, given their unique positions as sort of subservient to adults in their life. I would argue that the headmaster is analogous to Kathy Griffith. It's not a completely on point analogy, but Collin communicating with his lawyer and knowing that his mom might find it doesn't excuse, and this is something that this case also discusses, doesn't excuse what the mom does with it later. And that's my second point. That's that, okay, so maybe you find she had an absolute right to look through his communications with his lawyer. Or maybe, as her duty as a parent, once she realized they were privileged communications, she has a duty to act in the best interests of the child and not go sharing those with other people. And certainly that shouldn't translate to, if she does make the bad decision to breach the attorney-client privilege, to allow it to be admissible in a court of law against her child. She also was the alleged victim in that particular case. So she bears some responsibility in doing what's best for Collin. I think she violated that duty by sending it on. And even though the cat's out of the bag now, I don't think that her maybe having a right to go through clearly privileged communications gives the state the right to use that in this criminal case. She was the parent has to act in the child's best interest, as I said. But even if you're engaging in some weighing of the rights and responsibilities and duties and, you know, the duty of a child to obey their parent, it doesn't wipe away the privilege that exists. I provided RLR 116 Southern 3rd 570 from the 3rd District Court of Appeal in 2013.
You have not given me that yet.
No, I gave it to you at the hearing.
Oh.
But I'll give it to you again. It basically talks about, even if it would be in the best interest of the child to deem the privilege waived, and in this case, it was for the protection of the child, it still means you can't violate the attorney-client privilege. Additionally, under Florida statute section 90.502 1C2, talks about that disclosures to third persons who are necessary to the communication between the defendant and the lawyer, or between the client and the lawyer, are not waived from the privilege. So if you accept the state's position that the mom had every right to do everything she wanted with her kid, but she is the only way or the sole way that can facilitate the communication between Collin and his lawyer, and she's the one who controls the phone, apparently, then even if she found the message rightfully, it still doesn't mean that it's waived. And she doesn't have the right to waive his privilege, even if she is in a position of authority over him. The privilege belongs to Collin. I'm almost done, I promise. Then we also, sort of as a logical argument or an overarching view, if you decide that Collin waived his attorney-client privilege by using a phone that his mother controlled and had the right to look into, if you take that to the logical extension of it, then how is a kid ever supposed to communicate privately with their lawyer unless their parent can facilitate it, in which case then they would never have the right because their parent would be the third person that was involved, which I think completely vitiates the purpose of the attorney-client privilege and should not be a rule.
Right, so Thornhill, I had essentially come to a very similar conclusion as yours, agreeing with you. First of all, recognizing I believe the law is clear that a parent has the absolute right to determine what extent the child will have privacy in that relationship. But I agree with you that there's an overarching duty of the parent to act in the child's best interest. And when a child is facing legal jeopardy, that would, and that's recognized across divisions of court, dependency court, family court, criminal court, a parent has a duty to act in the best interest of their child. And that's probably, in fact, why that absolute right of surveillance exists, so that you know what your child is getting into. Or is being exposed to, so that you can make the decisions about guiding that child, providing the appropriate services, and so forth. So the right and the responsibility go hand in hand. And I think that's something that we fail to recognize across the penumbra of rights that we have these days, that they come with responsibilities. So I agree fundamentally that a parent, when it comes to an evidentiary privilege, meaning those secrets that they find in the locked box being what would otherwise be subject to a claim of privilege, that parent has a duty to act in the child's best interest with respect to those secrets, even when the parent is at odds with the child with respect to those secrets. Now, that's not to say I don't believe the parent cannot act on those secrets. For instance, call law enforcement, separate herself from the child, even initiate a Baker Act, file criminal charges. But what I have a hard time with is that once that child is sitting here in front of a judge and a jury, whether that circumstance could ever operate to waive the claim of privilege, when it is just the parent who it was exposed to. But Mr. Levine presented me this case, and I need you to tell me how it's different, because although it's a Fourth Amendment case, that evidence would have been suppressed. Otherwise, that evidence would have been suppressed if the parent did not have a right to consent to a waiver of an important constitutional right, which is to be free from unreasonable searches and seizures and have that evidence used against you in court. How is this different? Because in essence, it's sort of the same. And that's the law in Florida. A parent can consent to the search of a child's bedroom, and that had not even crossed my mind during our discussion. So what is the difference here? It's evidence being used against a child in court. One, it's okay. And one, you're saying, and I initially threw my thought process overnight, agree, but what do we do with that case?
I think that those situations are distinguishable because the government is acting, right? Your Fourth Amendment right is against the government from engaging in unreasonable searches and seizures. And when the government comes and says, I want to search your kid's room, the parent, as the parent with rights and responsibilities, and maybe not knowing what's in the room, because if the parent had snooped and known what was in the room, then they would have a duty to do with it what they thought was best for their child, right? But here we're dealing with a government actor intruding on a private place that the parent pays for, that, you know, the kid is, has some duties towards the parent too. And the parent can say, all right, government, come into my house and search, right? That's very different than a mother who on her own has the duty to protect her child, the duty to act in the child's best interest, who goes looking through their private communications and then shares it with people, okay? It's another thing, even if Collin knew his mom was gonna look at it, if she's facilitating the communications, that doesn't mean he intended it to be disclosed to everyone and be used against him. So I think that because
It's a specific privilege, it's not directly on point.
because the government wasn't acting at the time here, and mom took it upon herself to totally destroy his attorney-client privilege by sending it to Susan, and then Susan, maybe by accident or not knowing the implications, then turned her phone over to law enforcement. I think that's too many steps removed from a government actor coming to a home that the parent owns and controls and says, can we search your kid's room?
So what about the circumstance where the state issues an investigative subpoena to mom and says, tell me what's in that phone, and the mom willingly complies? How is that different? And says, yeah, in his phone he said he was gonna stab me in the neck, to his lawyer. And then
I
we
still
talk.
think it would be privileged.
But how is it different?
Hold on.
They're both essentially at their core evidentiary privileges. I mean, I think unreasonable search and seizure is broader and protects individuals' privacy as well, but it also is subject to the rule of exclusion if there is an unreasonable search and seizure. So at its core, it's an evidentiary
Well, but
issue.
we're also dealing with something a little bit different in that we're dealing with a privilege of confidentiality, which is different than living in your bedroom, right? So for instance, with the psychotherapy patient privilege, a parent can't waive that on behalf of their child, even if they know what happens in those therapy sessions, because it's the child's right to confidentiality in certain things. And there are very few
So it's
privileges.
because the child doesn't own the bedroom, that it's different, is what you're saying?
No,
Because
not
it's
entirely.
the parent's right to determine who has access to what they own.
No, the law doesn't provide a child an absolute privilege like it does in their bedroom, like it does between a lawyer and the child as a client. We have to start from that place, not the backpack he's carrying, the room he lives in, where a government actor is trying to find something. We're dealing with the privilege exists. Very few privileges exist that keep things completely confidential. This is one of them.
And so, Mr. Levine, you have a response to that, the consent to search a bedroom is different than consent to give up confidential attorney-client communications.
Yes, it's not, Your Honor. I mean, both are evidentiary issues at their core because ultimately the state is trying to use evidence, however it was obtained, and I submit that it was obtained lawfully. What Kathy did was not illegal or diabolical. It was Susan Detman, which I think is beside the point, but nonetheless, it was Susan Detman who consented to giving her phone and that information to law enforcement. It wasn't like Kathy, who would have been within her right to go to law enforcement and say, look at this, my son is saying he's gonna stabbed me in the neck and he's already killed his dad in Oklahoma. And the only reason I say that is because obviously the jury's not here. So it's not like.
Now remember, I didn't say she couldn't use it, like for purposes of protecting herself, getting him services, whatever it may be. I didn't say she couldn't use attorney-client communications for other purposes. The issue is whether that means she can consent to waive the confidential nature of the communication in a court of law.
No, nobody's waiving the communication for him.
Well, that's essentially what I would be doing. It's saying because a parent's absolute right to surveil their child exists, that every child knows or should have known their parent can find it, and thus it's waived.
No, I don't think it's that broad, John. But in terms of the admissibility, there's reasons and court findings, including some of the cases I gave you, the general topic matter, where the attorney-client privilege, the evidence comes in court. If it was such an absolute right, then there wouldn't be any case law and there wouldn't be instances where a court has the discretion to allow it in. So this is not earth-shattering or groundbreaking if Your Honor lets it in terms of it happens under certain circumstances. The circumstances being such as the case law and the issues that Your Honor is weighing. But in terms of whether it's the attorney-client privilege or it's the right for unreasonable searches and seizures, at the heart of it is the court being the gatekeeper. Both are governmental action. It's no different because the ultimate thing that can be helpful to the prosecution of a case or hurtful in terms of evidence against the defense is if that evidence comes into court. So both are evidentiary issues. They're not these different things. The end result is the same. The state is acting. The state is trying to get both evidence in, whether the question is suppression for an illegal search and seizure or suppression because of the legitimate attorney-client privilege protected statement, which I've mentioned many reasons why it's not. So the end result is the same. The court has to determine, should it be admissible or should it not? Was it an unreasonable search and seizure? Was it legitimately an attorney-client privilege? And based upon the case law and the inquiry about should the defendant have known or reasonably known that his mom was going to see it, and was the statement when he made, was he thinking it was attorney-client privilege? Obviously, he could simply walk outside and take one of his walks that he so much loved to do, make a phone call, we wouldn't be here. When he made that statement too, he wasn't thinking about it being protected or it not being protected. He was just saying it. So at the risk of repeating everything I've been saying, I have nothing else to say.
All right. Anything else, Ms. Lauren?
No, sir,
All right.
I think you understand our position.
I think the difference lies in the fact that the law has said a parent can consent to the search of a bedroom of a child, and the child has no exclusionary claim under the Fourth Amendment for not consenting himself. When we're talking about the attorney-client privilege, I have not seen a case, and you have not presented one to me that says point blank a parent can give up a child's attorney-client communications to law enforcement. And that right has always been personal to the client. And until and unless the court decides otherwise, that it's personal to the individual, I don't think this case is analogous. And finding that a parent's absolute right to surveil their child serves as a tool for their responsibility to act in the best interest of the child in this case and under these circumstances means that when it is just the parent who the child might have reason to believe will see what's in the phone, there could be circumstances where this wouldn't apply. If he knows that he's sharing communications in an environment that others are going to be aware of that don't have a duty to protect him, that's a different story. But even when a child's interests, legal interests, a child in legal jeopardy, even when those interests are contrary to the parent's personal interests, that doesn't vitiate the parent's duty to act in that child's best interest. And I think we see that in court downstairs in dependency when the parent is the victim of a domestic violence incident, for instance, in juvenile court. The parent still has a duty under those circumstances. It doesn't vitiate that responsibility. So that being said, I do not find that in this case, even though Mr. Griffith knew or should have known his mom was going to look through his phone, that in and of itself, with respect to her and her alone, in any way would have waived the confidential nature of the communication. Again, finding that the state, while the actual communication itself was unusual, eerie, it was also apparently in the context of some discussion about self-defense, and there were no other facts elicited at the hearing, no other context provided where I could say that the crime fraud exception applies. So in that respect, I'm going to exclude it.
Of course you are.
I can inquire, and of course I respect the court's ruling. Could I just inquire, is it also your finding that when the defendant made that text to Jeffrey Ratkin, that he intended at the time he made it, that it be privileged and a confidential attorney-client privilege, as opposed to now he wants to keep it out because it's going to hurt him?
Mr. Lemie, you keep saying a person has to say in their head, oh, I'm typing this message. It is attorney-client privilege. I don't think that's the thought process someone has to go through. I think the thought process is, I'm sending this to my lawyer and my lawyer alone. I'm not sharing it with anyone. And especially when we're talking about a child, that the law should not require that child to even understand that the attorney-client privilege exists. Per se, word for word. I mean, the child's right to confidential communications with their lawyer, when the communication itself indicates that it's about seeking advice from a lawyer, especially in this context when Mr. Griffith was currently accused of a crime. That burden should not be placed on a child to have to make that mental connection. And I'm not even certain anyone goes through that particular process in their mind when they're talking with their lawyer. So I'm not going to answer your question because I don't think it's necessary under the circumstances.
Of course you don't. You're absolutely right, Patty. I don't know
All
if
right.
walk is the word.
Anything
but
else we need to take up before the jury comes in?
Can I make a call downstairs to tell my assistant that Jeffrey Ratkin will not be needed for these proceedings? He was waiting on standby should the court rule that it was a miss.
Yes.
Thank you.
And I have no objection to him being released.
All right.
There's clearly something going on with this judge and the defense attorney. They're too in cahoots with each other on stuff. I'm not saying, I don't know why we lost audio, but we did. Come on, line crime. What happened? There's I guess they're taking a break before the jury comes in. There's obviously a relationship, I'm talking about a friendship, co-workers between this judge and this defense attorney, because it just seems way too coincidental that every time there's something that is questionable or whatever, and even in some of his cues with her, some of the things he says with her, the prosecutor is an outsider in this case. In the courtroom with the three of them discussing, or four of them, because she's got two people over there. The prosecutor is an outsider. And this is so obvious. This is why we should have video in the courtrooms for things like this, to call people out when it's... Was it a questionable thing for him to put those text messages in? The text messages were him basically telling his attorney, this is what I want to do. And his attorney said, well, hold up now. There's certain ways you can do that, and it could be called self-defense. In what I read yesterday in the testimony, in the evidentiary hearing, the attorney was almost coaching him on how to do it and get away with it, and it'd be shown as self-defense. I just don't understand how. And this was his attorney for the other case, not for this case. That's the other thing that is bothering me. Legally, because it's dealing with a case with his father and not a case with his mother, what he said to that attorney, how could that be confidential when it was about a different crime? I guess if he retains the attorney, anything he says is confidential. I get that. I just feel like, why do we go on and wear this out like it was yesterday's news and then come back this morning and decide no on it? It just... this... Shelly said, this kid has one heck of a lucky streak. People need to take him to Vegas. I know, right? Oh, my goodness. Why is it that somebody like this gets a good defense attorney, and then the people that we question don't? The people that we feel like maybe they're guilty, maybe they're not. Why don't they get a good defense attorney? Oh, yeah, that's a good point. He was checking into law. He was studying, and brings up that he was already studying criminal law. He had an interest in it. Laura says, I hope the state's attorney challenges this right away, which they can do during a trial. As it continues, another judge reviews it. Okay. Will somebody get that started, please? Can we can we make a phone call to the... I know I keep saying that, and I am kidding. Nobody call the courthouse, please. But I guess an email could be sent. You could send an email to the DA's office if you wanted to. But still, it's like, it's just not... It's something... It's... The fairness in this case is not right. Like, we're supposed to be looking at the scales of justice. And this kid just happened to get an attorney who's buds with the judge. Kai Mahilani. Did I say that right? Thank you for your kind comment. Kai Mahilani. I think I said that. That's a long one for me. It's pretty, though. Anything that comes up in question, this guy is going to let it go through towards the offense. Yes, and they are. Michelle, they're wasting way too much time on this one topic. And then for him to come around and rule against it. That's what irritates me. And I apologize. I was running late this morning because I was having a problem with one of my devices. My computer's running hot, but I kind of feel like if he was that on the fence about it, how was he so eager to go say no this morning? I don't know. Did y'all hear exactly what she said? Was it a good argument? Honestly, in all honesty, even though we don't like the whole side of that, but Can anyone tell me? Because I was probably still, I was distracted. I think the state's overworked. I think that this guy probably has way too many cases on his plate. And because, and it seems like, now remember, this area of Florida is a very small town area. So the resources aren't there like they would be in Miami or Naples or Tampa. So you're kind of seeing some of that. I'm ready for them to get the family up to testify. Let's hear what the family members say, because based upon everything that's happened, it could be that the family members come in and it makes all of this a wash, like it doesn't even matter. And honestly, if I was on the jury at this point, I would still be pissed. I'm like, hopefully the judge told the jury to come in a little late this morning because they were having this discussion. And that might be why they took a break, because the jury's not there yet. Yeah, Nana, they can still go back and charge him for his father in Oklahoma, which we do feel like, just because of the, I mean, with this happening now with his mother, anybody that was doing that case in Oklahoma is going to be like, okay, yeah, we need to revisit this. So I have a feeling that he will definitely go on trial there too. So if this Florida doesn't come through for us, we still have Oklahoma who can serve the right justice. All right, we have audio.
All right, are we ready for the jury?
Yes, sir.
All right, for the
Oh,
record,
before that, Your Honor.
for the record, Mr. Griffith is present with both lawyers, Mr. Levine.
I prepared a stipulation that I shared with the defense. If it still makes their approval, I would request that you read both 1 and 2 when the jury comes back into the courtroom, Your Honor.
All right, Mr. Griffith, listen carefully. I've been provided a document entitled Stipulations, and it reads, when parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. This is something that I would be reading to the jury. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are: 1, Catherine Griffith is dead, and 2, John Robida, senior crime laboratory analyst in the biology section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Parent, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Have you discussed, you can put your hand down, have you discussed this stipulation with your lawyers?
Not in detail, Judge.
No, Your Honor.
Do you want to? Because I'm going to tell you, one of these stipulations is an element of first-degree murder and the lesser included offenses of first-degree murder that the state would have to prove beyond a reasonable doubt with evidence absent this stipulation. So that's an important thing that I think you should discuss with your lawyers before you stipulate to it. They may have very good reasons as to why they think it's a good idea, but you need to know why they think it's a good idea. The other things are evidentiary matters that could have some impact on the state's proof in this case, affirmative proof in this case, and perhaps any defense that you might have in this case. So I think you should talk to your lawyers about this for a few minutes.
Yep.
But yes, I was shaking my head no to,
And can you tell him, can you take, well, how long do you think you need?
a few minutes.
All right. We just need a couple minutes. He needs to go back there and talk with his lawyers. All right.
See, I still can't get over what the judge said yesterday. And he didn't just say it one time, he said it twice. He gave his opinion on her mothering or her parenting him. He said that she had, well, first of all, I don't think she did have Ring cameras in his room. I think she had them in the home. But he made comments twice about her having Ring cameras watching him in the house and that he didn't agree with. I don't remember exactly the way he said it, but he said it twice. And I was like, you are not that blew me away. Did anybody else like do a double take when he said that? Is it just me? Well, they're not going for self-defense though. That's not their call here. They're not saying this is self-defense. They're trying to say mom was crazy. Shit, I don't know what the hell she's trying to prove. They're talking way too much about parenting. Okay, you're saying that you want to try this kid as an adult, right? And I mean, he's 18 now. He is an adult technically. He was 17 a couple of months ago when he committed the crime. Now he's 18. It's a couple of months ago, you guys. But everything that they're doing in the trial is still treating him like a minor. So that part confuses me. Is how can you say we're going to try somebody as an adult and then treat every single thing with hand gloves of him being a minor? It is bias. And the thing too is that what has come out in trial so far, if you guys are just now tuning in, multiple people, now it's just mostly been law enforcement that has testified thus far, but multiple people said that he had said in front of them months prior to this happening, that he was going to unalive his mother. And somebody said in a comment, they're like, oh my gosh, this kid was screaming for help. He was screaming that he was going to do this. Why didn't somebody stop him? Part of the problem with that is that the mother had already said, it doesn't matter to me. I'll risk my life to be with my child. I've been away from him for 3 years because of his father not giving me visitations. I'll do whatever it takes. So mom was fighting that.
Griffith, did you just have a discussion with your lawyers about this stipulation?
I did, Your Honor.
Did they explain to you what the purpose of agreeing to that stipulation was?
Yes, Your Honor.
And did they give you some advice on what they thought about stipulating to it and why you should stipulate to it?
Yes, Your Honor.
Did they answer any questions you had about it?
Yes, Your Honor.
Addressed all your concerns?
Yes, Your Honor.
And do you agree with their proposal to stipulate to these particular facts?
Yes, Your Honor.
All right. And you understand the pros and cons of stipulating to those facts?
I do.
All right. Do you have any questions of me about the stipulation?
No, Your Honor.
And has anyone promised you anything or threatened you to get you to stipulate to these facts?
No, Your Honor.
Including your lawyers?
No, Your Honor.
And you're not currently under the influence of anything, are you?
No, Your Honor.
No medications today, correct?
No, Your Honor.
You're satisfied with the advice and counsel you've received from your lawyers on whether or not you should stipulate to these facts?
I am.
And you understand the jury will be told, these facts are proven beyond a reasonable doubt, essentially. They don't need any other proof of those facts, and they must accept these facts as true. You understand that?
I do, Your Honor.
And of course, it's for them to decide what to do with those facts and how significant they are, but I will be telling them they have to consider it. You understand that?
Yes, Your Honor.
Anything else you want on the record?
No, sir.
Oh, Your Honor.
All right. I find that your choice to enter into this stipulation is freely, knowingly, and intelligently made upon the advice of competent counsel. You want me to read this first thing, Mr. Levine?
Yes, please, Your Honor.
All right.
And then Dr. Garavan will be the first witness of the morning.
All right.
I agree, Gabrielle. I'm just baffled. I don't understand what the stipulation is either. This kid thinks he's going to get away with it. Court-appointed attorney. He just got lucky. She's with the public defender's office. Exactly. The mom had every right to be doing what she was doing because he had already done something against one parent. She was doing what she could and still trying to be there to be his mom for him. And yet, the phone that she bought him, they're now saying cannot be used. And the phone that she was paying for service, cannot be used to help defend or cannot be helped to give her a voice after her death. Mind-blowing. Yeah, and he made comments, and he's made several comments to several different people that he's done it once and he'll do it again, and he got away with it before and he'll get away with it again. We're just all, yeah, Laura might have to take some of the comments down, you guys, because we have to be super duper careful. YouTube is on everybody like white on rice right now about every little thing. They are flagging videos, demonetizing them left and right these days. So I apologize, and she apologizes if anything has to get, just reword what you say. Certain words, say unaliving instead of those other words. Say red rum instead of the other word. No, try not to cuss. Of course, that I have to follow that too, and I have a hard time with it, so I don't blame you. Yesterday, Laura was about ready to mute me because I was getting so mad. How long is the trial expected to last? Claudette has asked. Well, they said that the state would rest around Monday. So probably mid next week.
You may be seated. Good
morning, ladies and gentlemen.
Hey, Myron.
Welcome back. Thank you for your service. I want to apologize for the delay. I assure you we have all been here at the appointed time working to resolve a legal issue that has arisen in this case. That has been resolved, and we are ready to proceed. I want to advise you that when parties and lawyers agree that certain facts are true, that is called a stipulation of fact. Now, you must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts you must accept as true are as follows. 1, Catherine Griffith is dead. 2, John Robida, Senior Crime Laboratory Analyst, and let me stop you for a moment. I see you writing furiously. This is going to become part of your final instructions, and you will receive a written version of these instructions, and this will be in there word for word. 2, John Robida, Senior Crime Laboratory Analyst in the Biology Section at the Florida Department of Law Enforcement, performed DNA analysis on fingernail swabbings from Catherine Griffith's right hand and left hand. No DNA results foreign to Catherine Griffith were obtained from the right hand fingernail swabbings from Catherine Griffith. No DNA results foreign to Catherine Griffith were obtained from the left hand fingernail swabbings from Catherine Griffith. Mr. Levine?
Thank you, Your Honor. The state calls Dr. Garavan. Dr. Garavan.
A doctor?
Sergeant Hunter. Raise right hand, the clerk has written.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing
I do.
but the truth?
Good morning.
Good morning. Good morning.
Mr. Levine.
Good morning, Dr. Garavan. May you please introduce yourself to the jury and spell your name for the record?
My full name is Dr. David Fentan, Fintan, Garavan, G for golf, A, V for Victor, AM.
Tell the jury about your profession.
So I'm currently working in District 10, which is this area, as a medical examiner. A medical examiner is a forensic pathologist. My qualifications start back. I completed my PhD in medical toxicology in 1994 in Trinity College, Dublin, Ireland. I completed medical school in Trinity College, Dublin, Ireland in 1999. I completed mandatory internal medicine and surgical rotations, which is required by our country, before entering into a pathology training program as a specialty, which was 5 years. I completed that in 2006. I started my fellowship in forensic pathology in Miami in 2006. I came here for 1 year, and that was 17 years ago. I completed 3 years in different specialties within forensics in Miami, including cardiac, neuropathology, and pediatric. I worked in Liverpool, England for 2 years as a forensic pathologist. I took my professional examinations in the Royal College of London in forensic pathology 2010. I then worked in New Zealand and the Pacific Islands for 5 years, traveling around the large country of New Zealand, but I was based in Auckland as a forensic pathologist. I returned to Miami in 2015 as a forensic pathologist. I was there for another 6 or 7 years. I was the deputy chief there for a period. And then I came to Polk County in 3 years ago, I think next month, where I'm working as a forensic pathologist. My other specialties are drugs or toxicology, in addition to forensic pathology.
Doctor, what does forensic pathology deal with?
So there are two types of pathologists. So if you have a lump or a bump or some part that needs to come off you, a biopsy or surgery, that will go to a pathologist, a surgical pathologist, and they will look at that under a microscope and make a tissue diagnosis, which will determine what treatment you have to, if any, that you will have to undergo after. A forensic pathologist will have done that, but we then move on to additional training where we're not looking at parts or biopsies, we're looking at the whole body. And our interest is to determine the cause of death, keeping in mind how natural disease or illnesses affect the human body, how that may cause death or impair the human body, how injuries affect the human body, either on their own or in combination with injury that may cause death or to a person, or drugs, the scene, depending on the environment where the body is found, and then the circumstances to a case, whether or not the person was involved in an altercation or not, or whether they were doing drugs or not, or a bit of both, or they were drinking, or they have some disease or illness that may have participated in the injury, the drinking, the drugs, that may provide an explanation to the police. Our purpose is to help police, our jury, or families to understand how somebody has died, or the mechanism, or what were the factors involved. We, in addition to determining the cause of death, we will determine the manner of death. The manner of death is the context within which the death has occurred. It can be natural, accident, suicide, homicide, or undetermined.
What is the definition of a homicide?
From our point of view, the medical point of view is different from a legal point of view. We do not make legal decisions. Our determinations are not the law. The law is a separate matter. But under the medical determination of homicide, it means that death has occurred as a result of a violation of some other action. So somebody has done something or made an action, or have made a series of decisions in an action which have resulted in the death of somebody else. That their action, any reasonable person would know or should have known that action could or should cause the death of another. So homicide is the death result of the actions of another.
Dr. Caravan, as a medical examiner, what are some of your responsibilities here in the 10th Judicial Circuit?
Similar to any other jurisdiction that I work, so our job as medical examiners here, so there are no coroners in Florida. Florida is one of the progressive states. We deal with just medical examiners who are highly trained professional medical doctors who review or are involved in making the decisions if someone needs to undergo an autopsy or not. It is not a decision taken lightly. There's a lot of work done before that decision is made. Autopsies, they're a lot of work. It's not something we do lightly. So there are many ways to do it. We may be contacted by police. We may be contacted by a hospital. We may be contacted by family members because death has occurred. By law, all deaths will be referred to us, but the vast majority will not fall under our jurisdiction. They are natural deaths. Somebody has died peacefully at home. It's not unexpected. They're of older age, or they had some condition which is understood that would or could lead to their death. Police have no suspicions, families have no concerns, and that's maybe 95%, 90% of deaths will go down that route. In the other percentage of cases, there's some issue. The death is unexpected. The death was unwitnessed, and there's no particularly obvious reason why they would have died in that moment, in that location. Police may have concerns that the person may have been involved in some incident, altercation, interaction in the days, hours prior to the death, and are wondering if there's some connection. If there's a belief that perhaps some drug or drugs may have been involved, that will fall under our jurisdiction. So if there's issues, particularly legal outstanding issues or concerns from a family, doesn't always mean that somebody has done something bad. It just means that there's an unanswered question. And if we feel that an autopsy would be helpful in answering that question, we will take jurisdiction of the case. And then we will perform So that's background information, first of all. Once we decide we're going to do the autopsy, then there's this broken into several parts. The information review is no different than if you go to your doctor and they have a chart and they have all your medical information in it. They review that information before they examine you. We do exactly the same thing, it's just that you're deceased. So we'll get all that information. I can't ask you questions, but your body can tell me what's been going on. So we'll do an external examination first of all. The external examination will involve looking at you from top to toe, looking for evidence of natural disease or injuries or some clue to tell us that something happened in the environment. It might be electrical burn marks, there could be evidence of drowning, something like that. Then we'll move to the internal examination, where we examine all organs, all major systems, brain, nervous tissue, heart, lungs, and so on. We may choose to take biopsies of all of those tissues to look under the microscope for the presence of natural disease that might provide an explanation as to what's happened. We will take samples for toxicology or biochemistry or microbiology, depending on what's more appropriate for each case, and send them off for testing. When we have all that information back, and it often takes weeks, nothing got to do with us, it just takes weeks for laboratories to do what they have to do. We will then pull all that information together, taking into account the narrative, the scene, medical examination, the various results. We will then form an opinion as to what was the cause of death and under what context that death took place. So each case takes many hours. I would do approximately 300 cases a year, autopsies, and I will do external examinations only on probably another 200, and I will review another 600 or 700 that I would decide that I'm not doing anything with. So that's how many cases we would be constantly dealing with.
The external examination of a deceased individual sounds pretty obvious, but how do you do the internal examination?
The internal examination it's an intrusive procedure, and we're aware of that. That's why we don't make the decision lightly. It requires that we have to open the body. You have to open the chest, the abdomen, the head, look into the pelvis, which is part of the abdomen examination. And if we need to do, there are many other specialist tests that we can do if we need to, which would require further intrusive methods, but they're done with as much skill as we can, so that when the bodies are returned to the families, that all of that's hidden, that's out of view. We try to close it up so that you wouldn't know the difference. But it is a very involved procedure. It's manual, it's not easy work, and it's tiring.
Now, in the normal course of an autopsy, are photographs taken of the deceased victim both internally and externally?
Yes.
And in this particular case, I'm going to have the opportunity to show you state exhibits 125 to 155 a little bit later. Will that be helpful for you to be able to point out and explain some of the injuries and some of your findings that Kathy Griffith suffered?
Yes.
Now, in this particular case, the death happened on a Sunday, September 8th. Describe to the jury the process by which you receive the body and when you typically conduct an autopsy.
So the only reason why this case is with me is because that was my week. There's no other reason. We work on rotations. So I would have first met this case on Monday morning. I would not necessarily have heard about it on the Sunday. I don't remember, to be honest with you. I just don't. So when I went in on Monday morning, her name plus other names were on that list that morning, and that's the first time I would get to read the police report to find out that's the beginning of the narrative. In all homicide cases, police do attend those cases, the investigating detectives, which is very useful because then I can have a much more one-to-one conversation. So that's where I would have got my information.
Do you work for the state attorney's office? Do you work for me?
I do not.
Do you work for law enforcement?
I do not.
Who do you work for?
I work for the public.
All right, Dr. Garvin, the autopsy that you performed on Catherine Griffith. Describe to the jury a little bit about the room or operating location where you do your autopsy.
So our autopsy suite is it's a custom built place. It's got two stations where we can conduct our examinations. We tend to use one. It's an open. It's no different from an operating area. We don't have to have the high clean room specifications of an operating theater, but it's no different. There's a table and there's ventilation and there's instruments and they're all laid out and so on and so forth. So it would look quite similar to an operating table.
Now, before we get to the cause of death and the manner of death towards the end of your testimony, I want to ask you about your autopsy findings. What can you tell the jury about the injuries that Kathy Griffith suffered?
Do you want me to go through all of them in detail or just a summary?
First, we can start with a summary.
So the autopsy findings, a sharp force injury to the right side of the neck, bruising to her lower limbs, bruising to the posterior right shoulder, left elbow, back of both hands. There was an incised wound, and I'm going to explain the difference between an incised wound and a stab wound in a second, between her thumb and index finger of the right hand. So here, there's an incised wound that was 1.5 centimeters. It was gaping if you open the hand, so 1 centimeter. A stab wound is a wound that is deeper than it is longer on the surface. An incised wound is a sharp force injury as well, that's longer on the surface than it is deeper. They're the opposite. So in an incised wound, the sharp blade or the sharp surface has come across the skin, but has not gone deep into it. A stab wound is the opposite. It's penetrated and gone into the actual tissue.
Was that gaping incised wound, was that a fresh wound?
Yes.
And describe to the jury why that is.
Because it's there's no evidence of healing. It's gaping, it's opened, and it had dry blood in it.
Now, is that gaping incised wound consistent with being a defensive wound?
It's possible that, defensive wounds are, so that's a term that's used, and I know it's thrown around a lot. We personally don't write down classic for defensive wound because we don't know precisely what the circumstances of it happened. But let me explain what the greater points of a defensive wound are. Defensive wounds is a term that's used when there's a series of injuries that can be bruises, can be incised wounds, it can be any other cuts or abrasions that are present on certain locations. And the reason why there's certain locations is that you have to understand that fundamentally the human will or the human body is designed to survive. Everything about us when we're under attack, when we're in a fight or flight situation, regardless of the circumstance, that if the human person is conscious enough to understand that they're in a struggle for their life for whatever reason, they will engage in activities which will try to help them survive. If you're under attack from an assailant, it is quite typical if the person is swinging something at you, baseball bat, fist, whatever, you will tend to try and protect yourself. And in doing so, certain parts of your body become exposed to that force that's coming at you as you try to defend yourself. In the arms is typically here. If it's a bat or a stick or something that's coming at you. They may also be on the legs. Typically, if and it's more common in women if they're being attacked, but it happens in men too. They will tend to offer the outside of the leg as they're trying to protect their sexual organs or they're trying to protect themselves if they're under attack. So we will often find wounds on the outside of the legs, not the inside. In knife injuries, when someone is under attack, where there's a knife or a sharp implement involved, it's common that the person, unfortunately, mistakenly, will try to grab that knife thinking that this is somehow going to be of help to them. It isn't really, generally, but in doing so, if they grab that blade and then that blade is pulled, you'll often find incised wounds across the palm of the hand, or it can be here, depending on how the knife is grabbed. Or it could very well be that as the hand goes up to defend against the oncoming blade, that blade just comes through here and then cuts as it comes through. because I don't know
fine.
specifically, we don't have a video of how exactly those injuries occurred. We tend not to use that term, defensive injuries, but that is what's meant by them. They're present in certain locations under certain circumstances that may indicate that the person who is now deceased was trying to defend themselves at the time of the assault.
Now, you
Yeah.
mentioned that
makes
Kathy had bruises on her upper and lower limbs. Does that mean arms and legs?
Yeah, so again, I know it seems a bit impersonal, but we say the lower limbs and the upper limbs because we're talking about the whole arm. When we want to talk more specifically, we tend to use the anatomical location, whether or not it's the anterior elbow or the posterior forearm or whatever it might be. But upper limb is the entire limb from here to the fingers.
What were you able to determine about the bruises on Kathy regarding whether they were old bruises or new bruises or a combination?
Yeah, so so dating of bruises is not it's not an exact science. We do not, TV shows I know do that all the time. That's not reality. What I can say is that these bruises, there were quite a number of them present. All we can say about bruises is that if the color yellow is present, we can say that it's definitely not, there wasn't an immediate before death bruise, because yellow would suggest that at least 15, 16, 17 hours has passed since that bruise was present. It could be weeks, but at least 17 or 18 hours has passed. That's the best we can do in reality. But all these bruises in this particular case did look fresh in that there was no color change. It doesn't look like they had gone or had the opportunity. The person wasn't alive long enough for the body to try and heal or start healing a bruise. So that's the best I can say to you.
Dr. Garavan, before we get to the photographs, what can you describe? How can you describe Kathy's neck wound to the right side of her neck?
So the wound on the right side of the neck is a large stab wound. It's gaping, and gaping means that it's an obvious. Once you see it, it can't be anything else. It's an open wound. It was 4.3 centimeters long and 1 centimeter apart. It's 2.5 centimeters right off the midline, so approximately here, and 23 centimeters from the top of her head. So we do that just to give you an anatomical location. So approximately here on her neck is what it was. The wound is in the 9 to 3 o'clock orientation, meaning that if you look at a clock, 9 to 3 means it's kind of looking straight when the body's in the right. So it's coming straight across here. And there's a square edge to the 9 o'clock margin. That's important because the square edge suggests to me that it's a single blade, not a double blade. That is the knife or the blade that's been used to cause. So there are characteristics of a knife wound which help us determine if it's a single blade or a double blade. And in this case, in this case, it would suggest the blade was single bladed. So the wound then goes into the neck. It travels from a front to back. So it's coming in from the front and heading towards the back. It's traveling right to left. And in doing so, and it has gone through, so the esophagus, the food pipe, has gone through the trachea, the windpipe, and it's just above the vocal cord. So it's transected the trachea right across and the food pipe. And the blade continues so that the top of the blade came out the other side. So there's a small sharp force injury on this side. It's 0.6 by 0.2, so quite small, but it shows that the tip of the blade made it all the way across and poked out this side.
What type of force is necessary for the knife not to just enter the body, but to do all that traveling that you mentioned and actually go out the other side of her neck?
We often get asked this question. In fact, we always get asked this question: how much force is required? We don't know, right? We don't have the ability to be there to measure newtons, pounds per square inch or whatever. But what we can tell you is that one of the major qualities, the most influential quality of how easy a knife will penetrate the human body is the tip of the knife. The tip of the knife, once it punctures or penetrates the human skin, it's relatively easy for the knife to then enter because our organs and our tissue they don't offer much resistance. So I can't tell you how much force was used, but I can tell you it can be surprisingly not as much required as you might think. However, in this case, it's gone through the trachea. The trachea is a tougher organ or tissue. It's got cartilage in it, so it would require the application of some pressure for it to continue to the other side. But I can't tell you in pounds per square inch how much that pressure is.
Now, have you had the opportunity to conduct autopsies on multiple stab wound victims over your years?
I've done many hundreds.
And do you see any consistencies amongst those in terms of the nature of the injury or the cause of the injury?
Well, I've seen all kinds, homicides. I've seen suicides. I don't believe I've come across any accidents, but I've seen suicides. Certainly, people have used knives to take their own life, but the vast majority would be homicides.
All right, so the vast majority are homicides. You've seen some suicides, but no accidents, correct?
Not to my knowledge, no.
All right, Dr. Garavan, I'm going to show you some photographs, and hopefully it shows up on your screen. And if I have some questions about them, of course, I'll be asking you some questions. So,
Obviously,
starting with
they're not
126, is this how the body comes to you?
Yes.
127, 128. During your autopsy, were you able to determine the victim's weight and height?
Yes.
What were those stats?
She was 5'2" and 126 pounds.
Is that a picture of the stab wound?
Yes, as the body arrived before it's cleaned, yes. That's the same wound after it's been cleaned.
Now, you mentioned the gaping wound and the definition being wide open. What is it that we're actually seeing once you get past into the hole there?
You're looking at the internal structures of the neck. So the head is back, so it obviously pulls up to make it gape more, but there are other reasons. It's a lot more details to it. So there are things called the lines of Langerhans. When you're all young and pretty, of course, you won't know about these lines of Langerhans because your skin is nice and tight and there's no wrinkles. But as we get older, the lines of Langerhans begin to take over. And they are a natural tension line that's present in all our skin. And if we cut across the lines of Langerhans, you may be familiar with the grain of meat, then the wound are gaping. But if we cut in the same direction of the lines, which surgeons will always try and do, because then the scar will be a lot less obvious. In the neck, they are roughly coming down the neck in a straight line. So this wound has gone across them. So those lines are now apart, and that makes it gape more than if the wound was the other direction, between 12 and 6.
So in this picture,
I would like for you to know, if you need it, that mouse over there operates as a pointer.
Oh, yeah, thank you. Actually, I didn't know that, but thank you.
could you please point with the mouse and the red arrow? Where's the visible organ within her neck?
So in here, you can see that there's a structure present here. This is probably part of the larynx, probably part of it, but clearly it's a gaping wound, and you can see that there is a structure inside here. I think it's part of the larynx from looking straight in, but I'm not entirely sure. That's part of where the voice box or the larynx has been transected, so it's cut open. That should be a whole piece. It shouldn't be separated like that.
Now, in order for the end result to be the death, what happens physiologically after that knife does all that damage?
Yeah, there's a couple of things. So the neck, the human neck is extremely vulnerable. It's probably the most vulnerable part of our body. So once a knife goes in, not only are there your windpipe, your food pipe, there's also a lot of arteries which conduct a lot of blood, but there are also several nerves that are traveling through the neck, the vagus nerve, the phrenic nerve, and so on, and they're coming down. If you transect them, there's immediate implications, clearly. The vagus nerve supplies the heart, and the phrenic nerve supplies the diaphragm to which you need to breathe. It has to have that bellow effect. So if they're transected, then they're not available to you anymore. So you have a combination of bleeding and severing of nerves combined will bring a rapid death.
Is the bleeding both external and internal?
I would expect this to be a bloody scene, yes.
(132). Is there any different parts of the organ visible in this picture?
No.
All right, now we continue 133. What's that there?
So that's the exit of the tip of the knife. So the tip of the knife has come all the way across the neck and has poked out here.
Is that a close-up of the exit wound?
Yes.
Now, there's a metal rod there. Describe to us what you were doing here.
So in all gunshot wounds and in stab wounds where possible, we will put in probes to show the direction that the wound is traveling in. So in this case, it's traveling right to left, upwards, front to back, and that probe is following the path, the same path that the knife followed.
What can you tell us about 137, Dr. Garvin?
So this is the internal examination. I've taken out the neck structures. You are looking at the neck from behind. So here is the epiglottis. This is the tongue. And this is the esophagus that's open, and the trachea is underneath. It will be, this is the epiglottis. This is the posterior surface of the larynx. And here the blade has gone through the upper part of the esophagus, as I'm pointing out there. So this fold and this fold connect. So this would be a tube. The lumen here is your food pipe. I've opened it to show you that the blade traveled through the esophagus, which is transected the esophagus, or perforated, I should say, the esophagus.
138. What do we begin to see here?
So this is the right hand, and you can see there's a bruise here, and it's not well shown in this picture, but this is where the incised wound between the thumb and the index finger is. There's some bruising down here also at the bottom. This is the index, this is the thumb and the index finger of the right hand, and this is that incised wound that I talked about. So it is longer on the surface than it is penetrating. And it's from a sharp force injury, I suspect, from a blade.
Going back to, you mentioned the bruising. So due to the color of that bruising, does that coincide with what you were saying are more fresh bruises on Kathy?
Yeah, these do not look as if they have had time to heal or undergo the healing process.
Ask about the
Can you
fourth.
tell us about 141, Doctor?
This is her left upper arm, and there's some bruising here. There's some bruising on the elbows. These are abrasions, but they are not injuries. These are post-mortem. There are differences. They happen after death, and it's got to do with many other things, but they're commonly often misinterpreted as injuries. They are not, due to their yellow, parchment-like color. And I understand, I can appreciate if you don't see it, but there are actually small veins running through the bottom there, and that's quintessential of post-mortem, not an injury. But there are injuries, and the injuries are here, the elbow, and up here on just at the biceps and down here.
continue on with the close-up, and we continue with some additional photos. Now we have 143. What appears to be on the wrist area and the hand?
Yeah, so this is the left, it looks like the left upper arm. So there's that bicep bruise, and this is heavy enough bruising present on the posterior wrist and hand. Some small bruising here also.
Is that another view of it, different angle?
Yeah, and there's also just another bruise there on the back of the little finger. That's the left hand also, and the left arm, and there's some bruising here.
Can bruising be caused by if somebody grabs somebody real tightly?
Bruises, by definition, I mean, it's better to just go with the definition, and then you can work it out thereafter. So in our forensic pathology, a bruise is where blood has escaped into the soft tissue due to blunt force trauma, not due to a sharp force injury, not due to a bullet wound. It's due to blunt force trauma. What the blunt force trauma is can be a whole range of things. It could be grabbing, it could be punching, it could be falling, it could be kicking, but it's blunt force trauma.
All right, thank you, Doctor. What do we see here?
This is the other arm. That's the right arm. There's a bruise across the triceps here. Right elbow, more bruising. Back of the right hand. I think that's the right hand. It is, yeah. And there's some bruising there on the back of it. And up here on the back of the index finger of the right hand. That's a small abrasion, minor abrasion on the right shin by the look. Yes, the right shin. You can see bruising here at the back of the left. This is the left calf. There's some bruising here on the anterior shin, here, here, here. This is an abrasion along here. So an abrasion is just for your definition. So a bruising is the escape of blood into surrounding tissue. An abrasion is due to blunt force trauma, but is confined to the epidermis. So the outer layer of skin is the epidermis. So as something rubs across that for whatever reason, blunt force comes across the skin and pulls or rips or tears that epidermis, that's an abrasion. Okay, and they're only due to blunt force trauma typically.
And the last few photographs, Doctor.
This is an abrasion, but I suspect that's post-mortem. I would not probably call that an injury. That's an injury. That's an abrasion. That's a skipped-like abrasion, incomplete abrasion. So something, whatever has caused this, either it has skipped along the skin or it itself was not fully in contact with the skin as it was rubbed across the skin, causing the abrasion. Bruising is present on the forearm, here and here.
Now, from your conducting the autopsy and your training and experience, what was the cause of death?
So the cause of death is stab wound of the right neck.
And what was the manner of death?
In this case, the manner of death is homicide.
And when you say the manner of death is homicide, what does that mean?
So with the information that would have been provided to me at the time, and with the examination and what I've viewed and witnessed and reviewed, the explanation for this death is that this wound was inflicted by another person.
So is it a fair statement that it is not consistent with somebody accidentally falling on a knife?
I haven't been given that explanation before, but I think that would be rather extraordinary. No, I don't believe so.
So your end result was that the manner of death was a homicide, a killing caused by somebody else, correct?
Correct. Yeah.
All right, Dr. Garavan, I have no further questions.
Cross?
Good morning, Doctor.
Morning.
Dr. Garabin, I want to talk about injuries that can result from mutual combat or a fight where two people are mutually involved in a struggle, whatever. They can be very messy, correct?
Well, I suppose mutual combat, mortal combat could very well be messy depending on the circumstance, yes.
Well, if any two people, regardless of size, strength, etc., are involved in a fight, both can receive injuries, correct?
Yes.
And both can receive what you termed defensive wounds, even though that's not a term of art, it's sort of a vague term.
Yes.
You would agree that both could receive those types of wounds.
Yes.
And you would agree that both could also suffer offensive wounds in such mutual combat.
Yes.
And even if somebody suffers a wound that ends up leading to their death, you don't know from your evaluation what happened leading up to that wound, correct?
So depending on the information provided by police, so I am given some information, but it depends in each case. Sometimes we know nothing, but in this case I knew something.
Right, and then the information that you get from police is their interpretation of things, correct?
Yeah, I rely upon them. I'm that's how it works. I rely on the information they give me. Yes, that's correct.
And so if they don't give you all of the information that they have, then you might be lacking some critical piece of information in making your determination.
I'd be very disappointed if that happened, but yes, you're technically correct if I'm not given all the information.
Do you also look at media accounts of what allegedly occurred?
I do not watch the news. I have no media. I have no social media. God, no. I have better things to do with my time.
So this is a weird question then. Why does the medical examiner's file in this case contain multiple media reports?
The secretaries in the office will do that as part of the thing, but I only saw them yesterday for the first time, and I don't read them. But it's common practice around the world. I've been in other offices. People do that, but it's nothing got to do with me.
Okay, I'm just checking.
Yeah.
But basically, you cannot say what happened in the kitchen where Catherine Griffith suffered this wound, can you?
Well, I can certainly say that she suffered a fatal stab wound or has suffered fatal injuries, and based on the information provided to me at the time, that the most likely determination, excuse me, is that she's died from the action of another person, therefore a homicide.
But you can't say, for example, whether Catherine Griffith attacked the other person with a knife first, right?
No.
Okay. And you don't know how everybody was positioned or whether there was a struggle over the knife or anything like that?
Not in this case. Sometimes we do, but not in this case. I did not have that detail of information.
Speaking about the bruises that you've shown the jury, those could be up to several days old, couldn't they?
So dating of bruises is tricky. There's no argument there. But in this case, I wouldn't say days, but could they have been present a couple of hours before the incident? I can't tell you.
Okay. And bruises such as we saw on the photos could happen from somebody bumping into something?
Yeah, absolutely. I mean, people can bruise very easily. You always get a bit concerned when there's a lot of them. And there are a lot of them. And I wasn't provided with an explanation other than a confrontation that might provide an explanation for them.
What about from doing innocuous activities like housework or things like that?
Also, yeah, it's entirely possible. And again, you would take that into account if it's as you are now, and that's perfectly fine. And yes, people can get bruises doing innocuous things. But the thing about innocuous things is that they tend to be very few bruises. They tend to be confined to one particular place, depending on what they were doing. And in this case, there's a lot of bruises and they're in a lot of locations. So if you can give me the innocuous thing they were doing, I would consider it. But otherwise, for me, it more likely than not would be better explained being received during a confrontation.
A confrontation that could have been mutual combat.
Yeah, absolutely. A violent confrontation for whatever reason.
Do you, can you say whether somebody who has rheumatoid arthritis might bruise more easily than someone who doesn't?
It's not something I'm aware of as being a thing. But if they're taking very, if they're on a lot of steroids as part of the treatment, people on steroids do bruise easier.
Was there any way for you to determine whether Catherine Griffith was taking steroids for rheumatoid arthritis?
So wasn't aware that she was taking steroids, wasn't asked about that. And even if it was, the test for steroids is extraordinarily difficult. They're very few places in the world that do it. And even if you do it and you find steroids is present and you know she's taking it, I haven't proved anything. So if somebody tells me she's taking it, that's fine. But I wasn't told that.
Right, and I'm not suggesting that that's something that you normally would have been aware of, given the fact that the autopsy happened the day after she died, and you spoke with law enforcement, not family members, right?
Correct.
Right. I'm just asking about that possibility.
Sure. Yeah.
In your training and experience, have you ever observed bruises that are clearly made from, say, a hand or fingers?
Yes.
So if somebody's grabbing somebody's arm,
Yes.
like I'm showing, so fingers around the arm, you would expect to see bruising that resembles the shape of the fingers.
It can do. They have a name. They're called discoid bruises, meaning looks like the pads of your finger. It can happen, and certainly I have seen them, particularly in young women that have died by strangulation. You can see, not in every case, but you can see the hallmarks of what looked like fingertips or somebody was grabbed by the neck by their fingers. It's also possible that if a person is strong enough and the other person is small enough, you can get similar discoid-like bruises. There's nothing about the bruise that screams at you, this is a fingertip. But what you can do is that if somebody says, could that be a fingertip? Then you can say, yes, that could be a fingertip.
Did you notice any of those types of bruises on Catherine Griffith?
Nothing that would have jumped out at me as specifically that. Yeah.
You've mentioned that the neck is a particularly vulnerable spot on the human body. There was no bone involved in this stab wound, was there?
It did not go through the cervical spine, no.
Okay, so it went through soft tissue, basically.
Soft tissue and trachea, which is cartilage. It's a little firmer, but yeah, it's not a whole lot, but it's a little firmer.
And so far as you know, there was no clothing or any object over the Catherine Griffith's neck to also provide, say, a layer of protection beyond her own skin.
I'm not aware if there was. Yeah, I didn't see any or wasn't told about it.
You mentioned that the cartilage is a little bit tougher than some of the other soft tissue that the knife went through. And maybe this is crazy, but explain what a tracheotomy is.
So tracheotomy, you're talking about in emergency situations, I'm not trying to be facetious, but a cricoid tracheotomy, a cricoid thoracic tracheotomy. If you're in an emergency situation, the person's airway is compromised for whatever reason, a crushing injury or something is blocking the airway, and you need to get air into the airway, so you bypass the blockage. So you find the Adam's apple,
Which is the trachea, right?
which is the voice box. It's the front of the voice box, more prominent in males than females. But then you come down approximately 1 finger, but as you rub there, you feel a little dip. It's very subtle, but you'll feel it. And that's where you want to make your incision. But that's not going through cartilage. It's going through this soft tissue in between.
My mistake. You mentioned in your direct testimony that you can't say with any certainty what level of force was necessary to make this wound.
No, I can't give you a number. No.
And you said that but you are aware that there are some variables that can give us some information about the level of force.
Yep.
If you're looking at a spectrum from very little to a whole lot.
Yeah, they are, but from my point of view, it's the tip of the blade that really, once the tip of the blade overcomes the skin, the greatest resistance is from the skin.
Correct.
And once you get over that, you'd be surprised how little actually is involved. But that doesn't mean that the person wasn't using a lot of force. It just means I can't tell you.
Right, I understand. And in this particular case, the tip of the knife that that caused this wound was triangular in shape. Are you aware of that?
I don't believe the knife was shown to me. I wasn't brought the knife from memory, at least. Look, I've seen so many cases since in between. I might be missed, but I don't think. But I think I may have seen a photograph of the knife.
So what is it your understanding that it was a triangular tip?
Yeah, like a typical kitchen large carving knife, I guess is what I would call it. Yeah.
And would you agree that that type of tip is actually geometrically speaking, is the easiest to penetrate the skin with?
Yeah, so that's a sharp tip, and that once it penetrates the skin, you don't anticipate much more force being required for it to continue in.
I want to ask you a question about the toxicology in this case. I know you personally did not perform the toxicology tests, but you received the results of the toxicology tests on Catherine Griffith's blood, right?
Yes, correct. We take the samples, they're sent to a toxicology laboratory. It's a whole different world. They live in a different place, but they're the ones who do the testing. It's up to us to do the interpretation.
Right, and in this particular case, while you didn't find that the toxicology results contributed to Catherine Griffith's death, there were some drugs in her system that you were at least concerned enough to note in your report, right?
Yeah, I wouldn't say I use the word concern. I'm kind of obligated to tell the truth, and if they're in the report, I've got to report that. I can't hide it. But there were 2 drugs present. That is correct.
Okay, what were the drugs?
One drug is called alprazolam. You might know it as Xanax, and the other drug is amphetamine.
Okay, tell the jury about alprazolam.
So I'm sure I'd be surprised if you haven't heard about Xanax. It's a drug which is given, is widely abused by many people, but it's a legitimate drug. It's prescribed. Typically, it's belong to a class of drugs similar to Valium. It's a benzodiazepine, and it's used typically for anxiety. People who are prone to anxiety or have anxiety. It can be used for other reasons, but that's the main reason. People who require, who have symptoms or signs of anxiety. There might be, heartbeat, racing heartbeat, chest palpitations, whatever the case may be, not sleeping well. Typically, Xanax can be prescribed for that.
As far as some of the side effects that could occur from alprazolam, do some of those side effects, although they might be rare, include racing thoughts?
Yeah, it's like any drug. No drug is perfect. Some drugs, they can have strange side effects. It's true. Can Xanax cause the opposite almost of what it's designed to do? Like any drug, that can happen. It would be very rare, but it can happen.
What about agitation? Can Xanax cause agitation?
And oddly enough, it's paradoxical. It's given for agitation, so why would it be causing that? In very rare cases, it's been known to happen.
And what about risk-taking behavior? Can it also cause that?
Risk-taking behavior. What do you mean by risk-taking behavior?
That's just what the literature said. That's the term I'm asking about. It can be interpreted many different ways.
Yeah, it can. Yeah. It is a drug. It is a drug that's commonly abused, I suppose. So if people are using it in an abusive manner, that's not the medical reason why they were taking it or the reason why they're prescribed it. So I'm not sure what risk-taking behavior is, but it can be abused or misused.
You have no idea whether Catherine Griffith had a valid prescription for Xanax.
I do not.
The amount that was in her blood could have been well above a therapeutic dose that a doctor would prescribed, correct?
Tricky one to answer,
Yes.
because Xanax is, like most other benzodiazepines, is a drug that's subject to what's called tolerance. What does that mean? Simply put, if any of you drink alcohol, you probably noticed that the first time you drank alcohol, it had a certain effect on you. But as you continue to drink, get older, you seem to need more of the alcohol to get the same effect. That's tolerance. So you need more of the drug for it to do the same thing. Xanax is certainly prone to that. So looking at a blood level in a post-mortem setting doesn't tell you a lot about whether that person was taking too much or it's had an effect on them, or this could be her normal. This could be just the amount she needs to have to be on a steady keel. Maybe it was a lot higher in the day. This is just a snapshot of what we caught. There's also another reason to make it complicated for you. I mean, it does take a while to get through all of this. There's a thing called post-mortem redistribution, okay? And that is a circumstance where if you take a certain drug or certain drugs for long enough in your life, you would think that they go in, circulate around your blood, and then the body gets rid of them. Not true, right? If you take certain drugs long enough, the body goes in, circulate around the blood, and then there's part of them are stored, sequestered, like a jury is sequestered in a room, and they're not available to the body, but they've dissolved into fatty tissues, or they've dissolved in other compartments of our body, which is water, fat, protein, and so on. And then after death, when you die, those stores are released and they go back into the blood. Some of them do. So sometimes the blood result you're looking at is actually higher than it would have been when she was alive, or anybody was alive. So it's another factor we have to take into account. And Xanax is one of those drugs. So depending on how long and how much she was taken, this 27 could be a little higher than what it would have been at the time of her death. But in any event, it is not at a level that would concern me that it participated in her death, that it would have impaired her beyond some extraordinary means. It's almost, if you're doing enough of these cases long enough, 27 is not high, and it wouldn't concern me personally.
Okay. But it could be above a therapeutic dose that a doctor prescribed to her.
Yeah, so again, for the same reason I've just explained,
Yeah.
therapeutic, we can't use the terms therapeutic because we're not dealing with a therapeutic situation because it's post-mortem. And secondly, I don't know how much she's been prescribed or how
Or
much
if
she's
she's
taken.
been prescribed.
Or even if she is
Right.
being prescribed. Correct. I don't know that.
Okay, so then let's go to the amphetamine. What is amphetamine?
So amphetamine is a stimulant drug. It's belonged to the amphetamine class. It's a subclass of another division of drugs called the phenylethylamines, of which that's an entirely large family. But the amphetamines have been around for quite a while, maybe late 1800s, early 1900s. They really became into their own in probably World War II, when the German army figured out that by giving them to the soldiers, that they needed less food and they could stay awake longer because they were running out of men. So they needed the few men to have. So they were given, Hitler famously was partly one of the many drugs he was taking was an amphetamine. So they've been around a long time.
So basically it's what some people refer to as speed or an upper.
It's an upper, it's a stimulant. It activates the nervous system to reduce tiredness or appetite and to stimulate the sensation of being awake.
Which is sort of the opposite of what a benzodiazepine or alprazolam is designed to do.
Yes.
Okay. Amphetamines can cause side effects such as erratic behavior
Yes.
and sometimes even violence.
Any stimulant can be associated with violent behavior in certain people at certain times, yes.
And Catherine Griffith had both amphetamines and alprazolam in her blood.
Yep, the amphetamine is reported at less than 0.1 milligram per liter, which is about 100 nanograms per mil. It's a very, very low amount, but it's there.
Do you know if she had been prescribed amphetamines?
I do not know that.
I don't have any other questions.
Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Doctor, could you tell the jury about amphetamines being prescribed for like a legal prescription? What would be an example of that to treat what?
Yeah, so amphetamines are prescribed, can be prescribed. The more common one is ADHD. So typically, there are several formulas available on the commercial market. So that's one. And the other one that I know of is narcolepsy. People who suffer from sudden bouts of falling asleep can be prescribed amphetamines. So there are genuine, legitimate reasons why somebody may have it in their bloodstream.
The two substances in Kathy Griffith's toxicology results, is it a fair statement they have nothing to do with their cause of death or manner of death?
I don't believe so, no.
All right, I have no further questions for you, Doctor.
Thank you.
Thank you. Is he released?
Yes, sir.
Yes, sir.
Thank you,
Thank you,
Doctor.
Your Honor. Thank you. Thank you.
And I think the jury will see through that. Don't you guys? Could have been cough medicine. Could have been. And some people are prescribed Xanax for antidepressant for depression. So yeah, I'm not.
Ladies and gentlemen, it's just past 10:30. We'll go ahead and take our mid-morning recess of 15 minutes.
All right, please. May be seated.
Thank you for the break, Mr. Levine.
Your Honor, I have, the next witness is going to be Robert Volantis. I have instructed him that he is pursuant to the court's ruling and order that he is not to mention in any way, shape, or form that the defendant killed his dad. So that will not be elicited from me. He understands that. But in an abundance of caution, if perhaps Your Honor could instruct him outside the presence of the jury.
Mr. Levine, do you mean you're not even gonna ask him about that incident at all, or he just needs to know he can't say it was the defendant's father or
He
relative?
just needs to know he can't
Well,
say
if
it.
I remember correctly, Your Honor.
I don't know what you intend to present, is why I'm asking.
Yes, if I remember correctly, and please correct me if I'm wrong, but I believe Your Honor ruled that he could not mention that the defendant told him that the killing in Oklahoma was not an accident, that it was planned, even without mentioning that it was the defendant's dad that he killed. That's my understanding of your ruling. So that if that wasn't your ruling, then I would ask him that.
I think that was my ruling, but I didn't know what other
Correct.
information he might have that's adjacent to that.
Gotcha. No, I will not be asking him anything about the killing in Oklahoma, and he understands that. But once again, where we are in the trial, which is coming in the home stretch of the state's case, and to ensure the integrity of not getting a mistrial, I would request that you order to not discuss that.
And I wholeheartedly agree with Mr. Levine's suggestion to speak with him outside the presence of the jury.
Let's do that when I get back, so it's as fresh in his mind before he's called to the stand.
Very good, thank you.
Fair enough. That's a good idea. I'm hoping that this piece coming now here, we're going to get into the family, you guys. First, we're going to start with grandfather. Then we're probably going to go to grandmother, the brothers and sisters of the victim. We're fixing to get into the good stuff here. And I'm hoping that the prosecution, we've been wrong about him this whole time. And that after all these people's testimony, it's going to be clear. I'm hoping. I don't know for sure. I want to show you guys something really quick while we're on break. Let me share this tab with you guys. So, do you guys remember me telling you about this gentleman right here? You all right, Frank? Coughing up a fur ball? This guy right here, he has a channel that he does cruise ship stuff. He basically vlogs on his cruise ship. He dated Kathy for a short time prior to all this, and so I reached out to him yesterday, or it might have been the first day of trial, and this is what I said to him. I said, "Hi, Richard. I'm streaming the trial and would like to invite you on panel if you would like to join us. My email channel is in my channel description, or you could just come in and join the chat if you're interested. I'm very frustrated over the way the trial is playing out with the prosecution allowing the defense to call the shots, and they're making Kathy out to be a basket case. Thanks, Carrie." And he responded back and said, "I loved Kathy, really did. I knew this was going to happen, so I walked away. Nothing could stop this. I have watched every second of the trial and have heard no lies. I hope justice is served, but what is justice? ? Happy to join once a verdict, but not going to chance it before that. Did the kid first degree murder Red Rum her, or did she welcome the unaliving by first degree Red Rum? One may never know." That's all I have to say on this now. Sorry. See, I think the reason he said that first degree thing, because they broke up because of this issue. He says it in this video that he did. The name of his channel, if you guys want to watch his video on this, is No Pants Profits. No Pants Profits. There it is right there. He has one video so far that I've seen on this specific. Everything else is regarding his cruise line or whatever. But I just thought it was very interesting that his frustration in it, that he feels like she knew what she was getting into, kind of, but he sounds a little frustrated in it too, which I could get that. I don't know. That's, the thing with Kathy was that Collin had been kept away from her for 3 years by the father with their custody battle. And she told many around her that I want my son back, and I don't care what kind of danger it puts me in. I don't care if this is self-harm or whatever. I want to put myself with my son. I want my son to come live with me. I want to have our lives back. And she definitely did that. And I think that's a lot of what we're going to hear from the grandparents, that where Kathy was coming from. Now, if you'll remember early on, the defense attorney has already brought up different cruises that they all went on, which I'm assuming one of these is where he met her. And they tried to paint Kathy as this spastic person who was estranged from her family. She got in fights with her family, a lot of fights. So I'm just going to give you guys a warning. I see a lot of this coming with the defense. I see them trying to, but let's see what they can get away with. I don't know. I just wanted to show you guys that. And then let's look at this really quick too. This was how long is this? It's 4 minutes. I think we got enough time to watch this.
So why did she hit you in the face?
I don't know.
So I know just before that you were saying, like, basically she told you to shut up, and you're like, I didn't shut up, and then so she hit you in the face. Was it like a slap in the face, or was it a punch, like with a fist? Okay.
I didn't really feel anything. It was just kind of adrenaline after that. So I don't know, like, if it did any real damage.
Gotcha. And then say again, right after she hit you in the face, what happened?
I kind of jumped up. That's when she grabbed onto me. I grabbed back, and kind of instinctively, I felt a lot. My knee went up and hit her. I don't know where exactly it hit her. I think like in the stomach area. And then we tussled, and then she got thrown on the ground.
Yeah.
Okay.
Hello.
Hello.
Hey, how you guys doing?
Good. Is Collin home?
Yeah, you guys can come on in. He's doing standing marches. He's not a happy camper right now.
Collin, right?
Yes, sir.
So what's going on, man?
Last night, me and my mom went to a physical altercation. I got arrested for domestic battery, but going in front of a judge today. I have a right to public defender, and we'll see how that goes.
Okay. So how's the situation with you and mom right now?
Um,
Are things calmed down? Are
no,
you guys
no,
able
no,
to
sir,
get
no,
along?
no, sir.
Where are we at?
No, sir, it's not good. She thinks that I did her. I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her. I want to kill her, or that I want to beat the shit out of her.
Do you?
No, sir.
Okay.
I don't want to hurt anyone, let alone my mom, even despite this happening. But I'm not gonna take what I consider abuse when someone's attacking me. And
How is she attacking you? What kind of abuse are we talking?
when she attacked me, when she threw a punch at me and grabbed on me, I grabbed onto her back. I got her off of me. She hit the ground, and then I fled and called Rentis, and then he sent someone out.
You called who?
Rentis, Detective Rentis.
Okay. So basically, why we came back is when the jail was releasing you to your mom this morning. Was there anything said then?
Yeah, I said that I didn't really feel safe there with myself and with her, and that I didn't know what was going to happen. I still don't know what's going to happen.
As far as what?
Her attacking me or her doing something to herself or me.
Okay. What about you doing something to her? Are you able to control yourself?
I'm in a constant state of fight or flight, and I don't know. If I think she's going to do something, even if she's not, I might act. I'm not going to like go crazy or anything, but I'm not sure, honestly.
Okay.
You're not sure if you're going to hurt?
Only if she tries to hurt me.
Okay. Did you make any statement saying that you were going to kill
No,
your
sir.
mom
No, sir.
if you got in a car with her?
No, sir.
I'm trying to figure out why we would have a corporal at the jail that took you out, that dropped you off to your mom and telling us that you said, "Don't put me in the car with her. I'm going to kill her."
Yeah.
Was that said?
I did not say I was going to kill her. I did not say kill. I don't know why he sent me back here. I asked him not to, but he said he didn't like my attitude and that I had to just work on it. And he sent me back.
Who are you, son?
Okay. So right now, I mean,
We're just going to place you in cuffs, all right?
Cuffs for what?
Yeah. Just for right now, all right?
This is the second time.
It's okay.
I'll still make my court appearance, though.
should. If not, they'll definitely know. Make sure they
Maybe
know
Zoom or something.
where you are.
But that's super nice, right? Is this an arrest or a big round?
This is a bigger act.
That was it on that. Yeah, so hang on. They've managed to keep that out of court. The defense has, and it's unbelievable to me that that can't be shown. Unbelievable. They can show the mom yelling and screaming at the kid, but they can't show that. I'm at a loss for words. For 3 days, this third day, we've been sitting here yelling and screaming through the TV, and computer, and phones at this judge, and it's just, wow. I've never seen anything so one-sided. So anyway, let's hope the family does come through here for us. And hopefully the jury will get to see everything without having to look at these videos. I've got some updates on some other people when we go on lunch later on, you guys. I want to look at some stuff that happened here recently. And I know it's going to be some convicts that you guys are familiar with. So we're going to look at some updates. Thought you might enjoy that. Kind of get us away from this trial for a minute. We probably will need a breather. And it does look like we're going to be back on Monday morning. According to the, I gotta let Frankie out, let him get some water. According to the prosecution, they probably will be arresting either today or tomorrow, or I mean on Monday. So they called about, how many witnesses did they call yesterday? They called 9 witnesses yesterday. So that's a lot in one day. So I guess they could get enough, they could get all the family members in today and still rest today. Trying to think of who the prosecution would call. I really wonder about that. What do y'all think? Do you think the prosecution, who, if you were the prosecution, who would you call? Thank you, Miss Barbara. I know I had to, my coffee helps with that a little bit, but my coffee is really working slow today. I do think though that the medical examiner, the way he explained it, the fact that the knife went all the way through is insane, you guys. Don't you think that the jury looks at that and goes, "Wow"? I don't care if the ME said you'd be surprised it doesn't take that much for. I don't care. That was an anger. That was a thrust out of anger. If you're on the jury, put it in the chat, you guys. I want you guys to. How do you feel like, based upon what we've seen? Try to be neutral on this. Based upon what we've seen, do you feel like the jury's seen everything that is enough to say guilty or not guilty? Which way do you think they're leaning right now? Thank you so much for your super chat, Barbara. I appreciate you. Oh, and Nana said, so he is saying that she consented to being. Oh, Nana, you were mentioning that about what the video or the gentleman that we were just talking about that had dated Kathy. I thought that at first, like, here's my thought process on this. You guys, there may have been a lot more than we even are aware of between her and her son that she put up with. And it sounds like this guy was, they were dating long distance. And if he knew about all of that, like if there's so much that he finally held his hands up from a long distance relationship and said, yeah, it's not a good time for us to date. That says something to me. So you need to look, you could look at it both ways, really. Bama said word of the day is exhaustipated. Too exhausted to give a crap. I like the what was the other one? The Humperdinkle? No, what was the one you what was the one you used yesterday? Ann says, I think the medical examiner won this case, being he hasn't been doing autopsies this long and had no interest in the case either way. He was I like the way he kept the defense in line. I knew it from the beginning. I loved his accent. Hearing Dr. Garvin, Bama says guilty. Crime Junkie 83, I would say guilty if on the jury. Baba says not guilty. Shelly says hung. Nana says guilty. So Louise is asking, what if the defense crosses the grandfather and he says the dad's name? It would be a mistrial. No. It's if the dad's relationship with him is revealed. Wait, if it's revealed that his dad was his victim, that's the way they're saying it. So you could say his dad's name. I mean, even the defense has thrown his dad out there several times. Talked about how mom fought against dad and all that. So they're still talking about the dad. It's just they can't bring a reference to the fact that that is his first victim. Zippity is gone from my doodah. That's it. Yeah, that's the way I like. All right, let's see. The bruises also speak to the fact that he did hit her first, and the cuts on her hands were guilty. Yeah, I think that one cut on her hand that was in the webbing area, it's definitely a defensive wound. And he called it, what did he call it? Like a slash or something? Anne says guilty. Yeah, if the defense brings up the dad's death, then and that Collin was the one that did it, then the door's completely open. I don't think she's going to do that, though. I think she's smart enough. I think the prosecutor, though, is kind of waiting for that to happen. Do you think the prosecutor, that's why he's been so quiet? He keeps waiting for her to cross that line. And it's amazing how he keeps, before he even brings anything in or anybody in, he's asking the judge permission and kind of laying it out there what he plans on doing. And the prosecution and the defense is definitely not doing that. So, Kamahiliani says that she was probably embarrassed and afraid. She probably was. I don't know what it's like to have a child, though, and I just the love of for the child and to go through something like that. She's not the first parent that's been through something like this. It's just this is just a dynamic case. They're fixing to turn the audio back on, and when they do, I'll put myself on mute. Oh, what if they do it and the judge shuts it down? That would make me so mad. Wouldn't that be telling?
Right there at the podium, if you like. Would you raise your right hand, please? Do you solemnly swear or affirm that any testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
All right. You are Robert Willantis, correct?
Yes, Judge.
All right, Mr. Willantis, the parties have asked me to speak with you a moment to make sure you understand the limits of your testimony. Mr. Levine apparently has already discussed this with you, but I do not believe, and it's been represented to me, that neither party will be asking you anything about Charles Griffith's killing in Oklahoma. You understand that, correct?
Yes, Judge.
And that is correct, Mr. Levine. You are not going to.
Hey, what happened? They froze up. Come on, Law and Crime. Come on, guys. Let me refresh. Yeah, they're just frozen for a second, y'all. It's not us. A heavenly power shut him up. So true. I think if the jury has any common sense, they will come together and find guilty on the common ground. Yeah. Yes, Cass, that's exactly what's going on. They're making the boy as the real victim, and the mom was off her head, without knowing of what happened to the dad. This could go sideways. Yeah, that's what we're afraid of. All right, come on, Law and Crime. What's going on? Just having a little bit of a technical difficulty. Thank goodness it's in the form of them being on sidebar, because they're basically what they're doing right now, y'all. What we're missing is the judge is just explaining to the victim to the witness that he cannot bring up the dad's death and how the dad died. So hopefully they'll get us back in there before the actual testimony starts, because they still have to bring the jury back in. Huckleberry says hi to everybody. My cat, Huckleberry, is very vocal this morning. This is the grandfather of Collin and the mother of Kathy. Well, he is a victim. Yeah, you're right. You mean the grandfather's a victim? He is. He lost his daughter, right? They've already said that the grandfather was told by Collin that that his mother made him so angry sometimes he went into like detail of what he could do to her to unalive her. No, Cass, you're good, honey. I'm agreeing with you. There's a lot here. It's just so. Oh, he says he's confused. Yeah, so Kathy Griffith, the victim, it's her father, and Collin Griffith, the defendant, it's his grandfather. The defense is going to try to twist his words. Absolutely, she is. You know she is. That. It'll be interesting to see how the family reacts to the defense attorney. Because I think just their reaction to the defense attorney herself will kind of give a feel to the jury about what that person testifying feels about what Collin did or feels about Collin. Because, in some cases, they don't want nothing to do with him anymore, right? In some cases, when this happens in a family, there's family members that are still there by their
Thank
side.
you if you'd step outside.
Oh, good. They didn't, we didn't miss anything.
Judge, it occurs to me before Mr. Melendez leaves
Yes.
that if there is going to be a question such as while Collin was living with his dad in Oklahoma, it sounds like the rest of that question might be, did Kathy have much contact with him? And the basis of that objection to that would be hearsay, because he doesn't know that. He would have been told that by Kathy. So, like I said, I'm guessing at what the second part of that possible question might be, but I'm worried that.
Levine, is that where you were going?
No, Your Honor. My question will be something to the effect of, did the defendant live with his father in Oklahoma for a few years while Kathy remained in Florida?
All right. Thank you, sir.
All right, we're ready for the jury.
Oh, yeah, Shelley. She's going to be. I'm so worried about how she's going to do this. I hope the family shuts her down. But you know what I mean? Like in some of these trials where there is a family member involved, or especially a child, you have like one or two family members that might be adamant on their defense. And then you have several other family members that just have broken apart from all of it and said, no, he did what he did and he was wrong and he needs to go and serve his time or whatever. And I'm just really curious to see how this all plays out with this family. It sounds to me like, just based upon that guy, No Pants Profits said, is that there's a lot there's a lot that's happened over that 1 year term. And we've only seen pieces of it. We've only seen the cops, some pieces of the cops' body cam. But it seems like there's a lot more that went on that nobody knows about except for the family members. And this is going to bring it all out and put it on the table. We hope. Normally I'm not so I don't know. I feel like I'm trying to stay even keel with this one, but I'm so irritated at how it's been so one-sided that I can't get over how the defense and the judge are like teaming up here. It's just blowing my mind. It makes me want to fight even harder for the victim, I have 2 sons and a daughter, and I can't imagine being afraid of one of them. My sons are taller than me. He seems socially awkward and psychotic. Well, you're not talking about your son. You're talking about this kid, right? Yeah. Yeah, that was frustrating us yesterday, JPC, was that, and the day before, that the prosecution doesn't object enough.
You may be seated. Mr. Levine, state's next witness.
Your Honor, the state calls Robert Wolantis.
Kranick, oh, I would love to have Kranick on this trial.
Stand this way, please. Can you read your right hand?
Do you solemnly swear or affirm that the testimony given in this case will be the truth, the whole truth, and nothing but the truth?
Good morning, sir.
Good morning, Judge.
Mr. Levine.
Thank you, Your Honor. Good morning, Mr. Wolantis. May you please introduce yourself to the jury and spell your name for the record?
Good morning, ladies and gentlemen of the jury. My name is Robert Wolantis. Robert, R-O-B-E-R-T, Wolantis, W-A-L-A-N-T-A-S.
Oh, not again. Come on, guys. Fix it, fix it, fix it. Hurry up. This is an important witness.
Not again. Come on, guys.
Oh, this is so wrong. We've been sitting here waiting for this for so long.
Oh, this is so
Let me turn myself off over here.
We've been sitting here waiting.
Oh, come on. Whoever's doing it's, I guess it would be probably like a local media station. Michelle, are you the one that sent me the image of your cats, your kittens? Did you Gmail it? Did you send that to my Gmail? I got to put that picture up. I had it pulled up and I forgot about it. Come on, you guys. Okay, I'll put that picture up. Let me check background something real quick. See if there's not another stream that's got it. I have not found another stream that has it live. Nope. Law and Crime's the only one that's streaming it. Shit. There's no. It could be that Court TV might get it. I don't know. And we'll have to go back and look at it again later. Are they doing this on purpose? No, they're not doing this on purpose. They're going to need to go back and somebody's going to have to replay this. Okay, I'll show them on lunch break, Michelle.
181 says Continental Divide.
It is. That's in eastern New Mexico.
And then,
I'm holding up the other side of the sign.
all right. Did the sign fall down or not?
We held it in place. Kathy and I did a good job that day.
All right. What about 183?
That is Kathy with a huge log of petrified forest. And that is the largest meteorite or a piece of a meteor that impacted in Arizona.
And then final photograph?
That is my birth mother, and Kathy and I. So we have 3 generations there. That was for her 90th birthday.
All right. Now, Mr. Lantis, when the defendant moved back to Florida to live with Kathy, was Kathy happy about that?
She was thrilled.
Now, during the time period when, like, since then, when he moved back to Florida and lived with her, did she try to make up for lost time?
She did.
And what were some of the activities that she and your grandson would do?
They had to catch up on 3 years of school. Collin was 3 years behind. And then they also caught up on the 4th year. So he got 4 years of education done in a single year. That's a huge accomplishment. They went to Australia, Central America, the Caribbean. She wanted to give him.
Now, Mr. Willantis, what was your daughter's profession?
She was a teacher.
And what subject matter did she teach?
Mainly English, but she would do other humanities as well.
Now, tell briefly to the jury about your relationship with your grandson. Did you have a relationship with the defendant?
We would talk on the phone, but I'm not a helicopter parent. I was there to support him and to support Kathy and to love them and be there for them.
Based upon your personal observations, did it appear that the defendant trusted you and would talk to you and confide in you about certain things, grandfather, grandson topics?
Yes.
Did there come a time when the defendant said something to you that was very disturbing to you?
Yes.
Tell the jury about what the defendant said to you.
My grandson was very aggravated at his grandmother and his mother. He said, "I am so tired of these 2 bitches. I'm disgusted." He said, "My mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life and the blood leaving her body."
Now, when he said that, what went through your mind?
I needed to take a deep breath and do what I could to discourage that thought, because thoughts become words, words become actions.
What did you say to him in response?
I said, "Collin, I love you, buddy, but you can't have those kinds of thoughts and focus on them and then speak them, because you will cause them to become reality. Please think positive things about your mom, about yourself, and about a good future together."
Now, at any point, did you warn your daughter about what the defendant was wanting to do to her?
I did, but I did not use the exact words because there was so much malice.
Objection, Judge.
Now, explain to the jury, were you concerned that if you used the exact words the defendant said that he wanted to do to his mom, that might negatively affect their mother-son relationship?
It would, and I was afraid it would actually give her nightmares.
Did you tell her a clean version or a more vanilla version, if you will?
Yes, I did.
What was her response?
That he's been threatening her and he's been threatening Susan. multiple times with killing both of them.
Now, knowing that though, did she still want him in the household and wanted to keep having the relationship with him?
Yes.
Mr. Wolantis, I don't have any other questions for you.
Thank you, Cross.
Good morning, sir.
Good morning.
Mr. Wolantis, you didn't come to Kathy's funeral, did you?
No.
Can you explain why?
The funeral for a person is for those left behind. I will see Kathy in my thoughts, in my mind. That's where I want to keep her. Attending a funeral where her body is placed in the ground, that's not Kathy. Kathy's spirit is elsewhere. The essence of Kathy is elsewhere. She's with me. She's here in this room today with each of you. She can speak to you. She can speak to me.
Mr. Wolantis,
Ma'am?
I asked whether you went to the funeral and why. Just answer that question, please.
You interrupted me as I was explaining why. That you don't like my response, ma'am, that's your problem.
Judge, would you please?
If you would avoid the commentary and you've asked the question.
I did ask the question, but then he's talking about her being present and speaking to the jury, which is non-responsive.
Sustained as to non-responsive, that portion.
Mr. Wolantis, the pictures showed a trip that you took with Kathy. That was one trip, right?
That's correct.
Have you taken any such trips with any of your other children?
No.
Do you have memory problems, Mr. Wolantis?
With what, ma'am?
Just in general.
Oh, sometimes I might think it was something that occurred a week ago, and it's actually a week and a half ago.
Okay. But that's the extent of your memory problems?
Usually, yes.
When was it that you say Collin told you that he wanted to slit his mother's throat?
I believe it was 4 months before she was murdered. It may have been before that.
And Judge, I'm going to ask that he be instructed not to use terms like that. That's for the jury to decide.
All right. Ladies and gentlemen, it is up to you to decide whether or not there was a murder in this case. You'll disregard that, the use of that word.
Mr. Wolantis, please tell us the month, if you remember, that Collin supposedly told you the things that you've shared with the jury today.
May
May of what year?
2024.
Okay. And how did he tell you? Was it over the phone or by text?
Over the phone.
Okay. And what's your phone number?
505. This is being broadcast. I really don't want everybody calling me.
Would you shut the feed off, please, for just a moment?
She's going to pull up his phone records and say that he's lying. Yeah, the state does need to object.
It's on. It's on. All right.
Mr. Wolantis, do you have any other phone numbers that Collin would have talked to you on?
No.
And you're certain that the phone call happened in May of 2024, aren't you? Because you said it happened shortly before the presidential debate where Joseph Biden had to later withdraw from the presidential race, correct?
It was before that. How much before that? Was it a month? Was it a month and a half? Could it have been 2 months? Sure.
irrelevant. When it was said, he said it.
You came to court here in Florida back on January 14th of 2025, correct?
Yes.
And you rose your right hand, swore to tell the truth.
Yes.
Do you remember being asked this question and giving this answer? Question. Now, did your grandson, Collin Griffith, then at some later time make some very disturbing statements to you about what he wanted to do to your daughter, his mom? Answer. A few weeks before the disappointing presidential debate in June, which we can all snicker about, Collin was telling me, and then it goes on to repeat what you said earlier, but
Yes.
you remember saying it was a few weeks before the debate.
Yes.
That's consistent with what he just said, right?
Did you ever call the police about this statement that you claim Collin made to you?
I called the police here. Yes.
Oh, I meant at the time that he made it to you. So in May of 2024, or a few weeks before the debate.
No.
So let's talk about your call to the police in September of 2024. You found out from your son, John, that Kathy died, correct?
Yes.
He called you.
Yes.
At some point after John called you and told you that, you watched a press conference that was put on by Sheriff Grady Judd, correct?
Yes.
And you watched it in its entirety, right?
Yes.
And it was about 20 minutes long, if you remember.
About, yes.
And Sheriff Judd described in detail how Kathy died, right?
Yes.
And it was only after you watched that press conference that you took the initiative to call the police here.
Yes.
They didn't contact you as a close member of Kathy's family to get any information from you, did they?
Initially, no.
Right, you contacted them.
Correct.
So you inserted yourself into the situation.
Yes.
I don't think she has anything more. Unless there's something controversial that she's going to get close to the dad situation.
Oh, I know what I was going to ask. Sorry.
I don't trust this lady as far as I can spit.
Mr. Walantis, how often would you say that you talk to your grandson Collin on the phone?
I don't know. Somewhere between once a week, every 2 weeks.
For what
4
period
weeks.
of time?
It's up to him.
No, I mean, up until when? Like over the months since he had been living in Florida with his mom? Every week, every 2 weeks from...
Things dramatically decreased after we spoke at that time.
So you say that it decreased after you spoke with him in probably May of 2024 and he made this supposed statement to you.
Yes.
Did you text with him still or no?
There may have been some. I don't recall every text, every phone call exactly.
So, Mr. Walantis, can you explain why in Collin's phone records there are a total of 3 phone calls between you two from mid-2023 till September of 2024?
Yes, I can explain why.
Okay. Why?
Well, there's Collin's phone. Collin had an initial phone that his mom got for him. Then he got another phone number. And then often when Kathy would talk, she would then hand her phone to Collin and we'd talk from there. So you have 3 different phones.
Oh, do you know what phone you talked to him on every week up until September of 2024?
On my phone, I know
Right,
that
the
much.
phone- the
Which
phone
one?
that he was using,
He was on one of the 3.
but only 3 calls on the phone that we are all aware of.
No, there's 3 phones, ma'am, not just one.
The records we have. Sorry.
Objection, how do you know what the records?
Sustained.
And you said that there may have been some text messages. So the text messages that are shown by the records indicate that there have been no text messages between you and Collin since Father's Day of 2023 when he texted you Happy Father's Day. Does that make sense?
Most everything was phone calls. There were some texts since then between one of the 2 of Collin's phones.
Do you know where Collin kept this mysterious other phone?
I don't know about a mysterious phone, ma'am. I said there were 2 different phones he had. He had one phone number, and then he got another phone number. And that was something that he and Kathy arranged.
And this is something that Kathy told you.
No, he had one phone number, and I put it in for Collin Griffith. Then he told me that he had another phone number. His mom got him a different phone. So I put that phone number in, and then Kathy's phone. So that's the 3 phones.
I don't have any other questions.
Yeah, just read.
She couldn't flip it. She couldn't make him look bad. I love it.
Mr. Volantis, the defense said that you inserted yourself into this situation. Do you recall that?
Yes.
You are the deceased victim's father, correct?
Yes, I am.
Did you insert yourself into anything voluntarily?
When Collin and I spoke about that disturbing phone call, I told him that if anything happened, I would be talking with people officially instead of being quiet.
And does it make sense that the murdered victim's father calls law enforcement?
Sustained.
Excuse me. Does it make sense that
Objection is calling for speculation.
Let me hear the question. Don't answer the question until I say so.
Yes, sir.
did it make sense that the deceased victim's father would contact law enforcement with important information as you did?
Sustained. It's for the jury to decide, Mr. Levine.
Now, when you called law enforcement on September 23rd of 2024, you told law enforcement the disturbing violent statement that the defendant made, correct?
I did.
I have nothing further.
Thank you. Is the witness released?
He is, Your Honor.
Ms. Thornhill?
I have no problem with it being released.
Thank you, sir.
Thank you, Judge.
Yes, he did a great job. That's awesome.
Mr. Levine, is there a witness that we can call up before a reasonable lunch hour?
Your Honor, there's going to be a witness from out of county that's available at 1 o'clock. The only other witness for today is Detective Peters, which will be lengthy testimony.
Oh, God.
That witness is not due till 1, or might that witness be here at 12:30? Do you know?
The out of county witness from Charlotte County Sheriff's Office won't be here until 1 hour.
All right, ladies and gentlemen, you're going to have a more leisurely lunch today of about an hour and a half. It sounds like we have 2 more witnesses for the day and cannot start that until 1 o'clock. So please enjoy your lunch and leave your notepads in the chair. It occurred to me, by the way, yesterday that I think I forgot to tell you during the preliminary instructions, in case you're worried about it. No one's ever going to read your notes, including me. You'll be allowed to take them with you to the deliberations room so that you have your notes there when you're discussing the case. And when your deliberations are over, they'll be delivered to me and promptly destroyed in the shredder in my office. And I will not be reading them. So just so that you can rest assured of that. So please enjoy your lunch and report back at 1 o'clock.
All rise, please. May be seated.
Anything before the lunch hour and a half?
No, Your Honor. The first witness will be relatively short. There'll be one video clip played, and then Detective Peters will be longer, Your Honor.
All right, we're going to be finishing watching the rain clips through
Yes, Your
Detective
Honor.
Peters. All right. Plus, I'm assuming there's some other.
Yes, Your Honor. There's a number of text messages as well and some other things.
He's not your last witness, is he?
For today, he is, Your Honor.
So, but you're not resting today.
I'm not resting today, but as I was telling Ms. Thornhill earlier, on Monday, the state will be resting at some point.
All right. If you think you're going to be resting super early, it might be good to know that. While we'll have to take up whatever motion there may be and other matters, it may be that Ms. Thornhill could get started with her case on Monday.
Yes, we discussed that, and she'll probably have witnesses available first thing in the morning in case there's not much presented by me.
Okay.
Yep, we've already taken care of it mostly.
All right. I like lawyers who think ahead.
All right, Judge, thank you.
All right, I'll see you after lunch.
Wow. I think that the prosecution is not helping himself there. I think I would be a little frustrated too if I were the judge and he keeps not having enough witnesses to fill the day. And it's supposed to be his time to bring in the witnesses. I mean, come on, dude. Laura said, and I like judges who do their jobs properly. Yeah. Yes. Okay. Grandpa did a great job. He didn't mess up. I was worried he was going to say something wrong that, and mess it up. He didn't. She didn't discredit him at all on the stand. I don't think she tried to. And the jury saw through that and he kept going and it was great. It was great. So if that is the only, I hope that's why. Okay. Just really quickly. The prosecution just said, if I'm hearing things correctly, that he's 2 more witnesses for the day. It sounds like that he will not be the one calling grandma and the other family members, which really troubles me. That means that he's going to be calling that the defense is going to be calling those witnesses, which is not good, you guys. Is grandpa going to be the only one that's going to step up and speak for her? Because I'm kind of feeling like it's leaning that way. But I'm frustrated too with the prosecution because we've what was it? Both Monday or not Monday? Was it Monday? The first 2 days of trial, they shut down early because of this prosecution not having enough witnesses. I mean, if they hadn't gotten into those arguments and sat there and gone back and forth on those other issues they had, I mean, we would have been done by 1 o'clock every day. So what is this prosecution? It's just, Wednesday was the first day. Yeah, thank you. Grandma could be a rebuttal witness. Okay, good thought, Prissy. Very good thought. I didn't think about that. But he does. This prosecution, he needs somebody there to help him. This is just, why don't they have 2 people on this? With it being a speedy trial like this, where there's less time to prep and everything. Anne says that she thinks the prosecutor was prepared, but the problem is that he had to think of this defense attorney dragging out everything. I don't know. I mean, he hasn't had enough people freaking it there to testify. The biggest thing you missed, Patty, really the only thing you've missed is that grandfather just testified. So if you go back and watch that, I think you'll be caught up. His main evidence was thrown out. That's true. That's true, Name. You're right there. He did have some stuff that he was expecting to be able to play, and at the last minute, because he wanted to play that body cam that we just watched while they were on break, and they're not letting him do it. But we still don't know. We know that they're watching the ring cameras. They're going to bring back Detective Peters again, and they're going to finish watching those ring cameras. But I just wonder if there's not going to be some more. He said something about text messages, and then also he was discussing, I guess, some footage. So we'll see. Yeah, Laura, that's a good point. Laura said it may be a very small county with limited staff. And I do think it is a small county. And this is why guilty people want a speedy trial. Yesterday was bad. Yesterday was him playing the footage of her in the house cleaning. And there was so much of it that could have been trimmed down. And we were all just like, why is he playing? Why is he playing all this? It seemed like everybody in the courtroom was kind of like looking around like, why is this going on? All right. We need to do something. People, family, don't go nowhere. I have a very important announcement to make. And I'm going to do it right here and now. We have a special birthday today.
Hey, Laura, this one is for you, baby girl. Because you're the best. I sing to make you happy because you deserve nothing less. Let's go. Happy birthday, Laura. Happy birthday, Laura. Happy birthday, happy birthday, happy birthday to you. Happy birthday, Laura. Happy birthday, Laura. Happy birthday, happy birthday, happy birthday to you. Happy birthday, Laura. Happy birthday, Laura. Happy birthday, happy birthday, happy birthday to you. Happy birthday, Laura. Happy birthday, Laura. Happy birthday, happy birthday, happy birthday to you.
That was cool, huh? That was pretty cool. I found that on. Oh, wait. Oh, there's a bunch of them. Baby girl. I got to hang on. This one's for you, baby girl. Happy birthday, Ms. Laura. Thank you for always being such a great moderator on my channel and also a wonderful friend. We love you so, so much. Go ahead. You can cry. We don't mind. We won't see you. All right. So I've got some other things I want to talk about today during the lunch break. Do you guys remember? Okay, hang on. I bet they're not going to let me access this. Oh, they're not going to let me access it. Hang on. If you guys watch Trials, I know you watch it. We watch it. I know you watched this. Courtney Bell, remember her baby? Remember this trial with her crazy husband who had the tattoos all over his face? What was the baby's name? Christopher McNabb. Kalia. Kalia was the baby's name. She faced charges involving the 2017 unaliving of her infant daughter. And on the night of October 6th of 2017, Bell and her then boyfriend, Christopher McNabb, who lived together at the time, reportedly smoked meth and the next morning, Belle awoke and Kalia was missing from her crib with only her pajamas remaining on the bathroom floor. Belle reportedly called the police, alerting them that her daughter was missing. A day later, the infant's body was found in a wooded area nearby. I'm trying to get a better picture of her because she didn't really look like that in court. But guess what? She's wanted again. I think this is her now. So now she's wanted back. The Jasper County Sheriff's Office is currently seeking help locating Courtney Bell, who may be in the Covington area. They posted a bolo for Bell on Facebook on Monday evening that stated she is wanted on multiple charges. The Covington News reached out to Jasper County Sheriff's Office, and a spokesperson said that she is wanted on drug charges, though it is not clear the specifics of those drug charges. Yeah, but you know what? It's probably meth. So why is she even out? Well, it looks like they were ultimately convicted for the unaliving for the homicide, along with several other charges. Christopher McNabb is still in prison where he's serving life. But Courtney Bell, the mom, was originally sentenced to 30 years with 15 years to serve in prison. However, Bell's sentencing was eventually overturned. The Court of Appeals of Georgia reversed the first two convictions of homicide, red rum, in the second degree, cruelty to children in the second degree, but upheld the third charge of felony contributing to the dependency of a minor. The appeals court determined that Bell's acts of neglect were not the sole proximate cause of the victim's death, and the evidence played a substantial part in the victim's death, and that the death was a reasonably probable consequences of that neglect. Okay, I'm not. In 2023, the Georgia Supreme Court ruled that in Bell versus the state that there was not enough sufficient evidence to prove that she was guilty of contributing to her daughter's death. BS. She was a guardian for that child and she did not take care of it. She was on drugs. Her husband was on, or boyfriend was on drugs. And then she helped cover it up. So what'd they do? They let her out. Name here says, did they try looking for her at another male relative that she shacked up with, or is she out of cousins? Oh, that's right. I forgot they were cousins. Oh my goodness. Totally forgot that. Bama said husband, cousin. Yep. That's horrible, right? Let me get a better. I want to show the picture of her when she was in court. So that you guys, if you watched it, I'm sure you already recognize them, but let me share this tab with you. There she is. And there he is. And then that was her mother. Remember her mother who didn't really raise her was right there. And that was her crying in court. This was the more realistic looking. This was the ones that were, yeah, where you would recognize it in court. Horrible. Absolutely horrible. So, yeah, that was one update I wanted to show you guys. Yeah, that would have been that was a hard one to watch. I don't even think I had my YouTube channel up at the time when that came out. And I just remember watching it and was just, I don't know, I was floored. I was so floored over that case. And remember, he went running around like he was trying to evade the police and everything. And it was just craziness. There was something else I was going to show you guys. Hang on. Oh, we got to watch this. Oh, we're not going to have enough time, but we might have to. Oh, we got to watch this. Hang on. Jennifer Crumbley was in court on her appeal this morning. I totally forgot about that.
I'm giving you my check. I'm not monitoring, but I'll give you my check. Make sure you mic. So we got
I'll put up a banner. Let me put up a banner so everybody know what we're doing.
All rise, the court is now in session. The Honorable Shirley Matthews presiding. Good morning, you may be seated. Your Honor, calling People versus Jennifer Crumbley, case number 222799990 FH.
Good morning.
Thank you. Good morning, Mark Keith on behalf of people.
Joseph Shada on behalf of the people.
Good morning, Your Honor. Michael Desi, P64530, appearing on behalf of defendant Jennifer Crumbley, who sits at counsel table to my left. Also, Your Honor, by way of introductions, I have 3 law students from the University of Detroit Mercy School of Law who have been assisting me as interns, and I'd like to introduce them. Jackson Moore, who will be assisting at counsel table with the court's permission.
Sure, so I should direct all my questions to him.
Please do, please. I asked him if he wanted to take it this morning, and he said yes. So Jackson Moore will be assisting, and then of course Paul Brochet, who's also going to be assisting me.
Good morning, Judge. Good to see you.
And then I also have my law student Nick Priolo, who's also here from the University of Detroit Mercy School of Law, and then my paralegal Beth Bentley. Thank you, Your Honor.
Good morning. Today's the date time set for defendant Jennifer Crumbley's motion for a judgment of acquittal, or in the alternative, a new trial. As you're well aware, I have read everything frontwards and backwards and all the cases that you cited. I read the motion filed by the defense as well as the response by the prosecutor. The court also allowed for the defense to file a reply. The reply of the defense is partially responsive to the response that was filed by the prosecutor, but also contains allegations not supported by the original motion filed by the defense. The reply references a public relations firm allegedly hired by the prosecutor, as well as media outlets shadowing trial preparation at the prosecutor's office. Any argument about PR firms or alleged gag order violations aren't the subject of the motion filed and aren't relevant to the motion filed. Although these topics are undoubtedly of great interest to my long-term friends who are from the press and may have some future potential relevance, they do not help me decide this motion. Therefore, I don't want oral arguments on these topics. I am, however, very, very interested in hearing arguments about the proffer. All right, Mr. Huzzy?
Sure. Thank you, Your Honor. Your Honor, if I may, just before we begin, housekeeping matter, I would ask that if the court, with the court's indulgence, Mrs. Crumbley has a very serious medical condition, a substantial hernia that is quite large. It's aiming from her stomach. And I would ask, with the court's permission, that if the belly chains could be removed from her, because those are putting a lot of pressure on her midsection where that hernia is, and you can see it visibly from her body.
I don't have an issue with that. Several issues with regard to Mrs. Crumbley were raised with the court last night, and we tried to take care of those with the jail. In addition, the deputies approached me this morning. I've been in the courthouse 33 years, and none of these deputies tell me how to try a case, and I also don't tell them how to keep me safe. So I would ask if it's possible to make Mrs. Crumbley as comfortable as possible, and as well allow her to participate in her hearing today. I don't really know what that involves. I don't think anyone thinks Ms. Crumbley's gonna make a run for it or anything like that. But I have to defer to the deputies. Can her belly chains come on?
Your Honor, I did speak with our jail director. I can't confirm nor deny whether their medical condition exists, nor can she. However, I will allow her belly chains to be removed for the sake that she does have this medical condition. However, the leg shackles will remain secure.
Thank you, Captain.
Thank you so much.
All right, we're gonna ask them to do that. All right. Mr. Desi, the court is likely in agreement with you that there's been a discovery violation pursuant to MCR 6.201. I guess my real question is, what's the remedy?
Sure. All right. Well, if Your Honor is inclined to, if you're agreeing with my position.
Well, I said likely, you know.
Okay. Well, I guess what
My
I'm.
job's to have an open mind, right?
Sure. Well, the reason I'm asking is because the prosecution has made arguments that the proffer agreements were not cooperation agreements, did not confer any sort of immunity, and did not require or offer anything in exchange for these witnesses' testimony. I believe each of those assertions are false, and if the court would like, I would like to walk through the language of the proffer agreement to the extent that the court would like to hear that.
Sure. That's what I'm interested in. And the 9-page opinion we issued yesterday, I think we discarded some issues that we already felt strongly about after spending an incredible amount of time analyzing them. But I am concerned about the proffer.
Sure, I understand, and
I know it's not something that I've dealt with a lot before. So.
Sure. If we could put the screen up, I'd like to show the proffer agreements. That way it would be a little easier for me to walk through the language.
Okay.
And I'm going to ask Mr. Moore to put up Defendant's Exhibit A, which is one of the proffer agreements. And Your Honor, just for the record, the two proffer agreements are identical, so it doesn't matter if we show one or the other. They're the same, all right? They have
First, Mr. Ejak and Mr. Hopkins.
That's correct, for the two school officials. So, all right, just reading from the prosecution's brief, this is their response brief on page 3. This is what the prosecution says. Nowhere is in the agreements is there a grant of immunity or other agreement for testimony. They say there's no consideration in exchange for testimony. And the prosecution also says that it is a gross mischaracterization of the proffer agreements to call them cooperation agreements. So let's just start first by looking at the proffer agreement, just so we can be clear about what the facts are. This is section 2 of the proffer agreement, and it clearly tells us that the purpose of the proffer agreement is to receive truthful information from your client, including information about possible criminal activity by your client and others, to evaluate your client's credibility as a source of information and potential witness. So as soon as the prosecution tells us that this proffer agreement has no effect and was not offered in exchange for any testimony, and it didn't even seek out testimony from them as witnesses, the proffer agreement directly contradicts that by virtue of the language that we can see right there in paragraph 2. So that would be the first thing I would say is the proffer agreement makes clear that it is for the point of evaluating the testimony for these witnesses.
Whether or not they were going to call them as a witness.
Of course, yes.
So do you agree that they could have taken the stand? Mr. Ejak and Mr. Hopkins both could have taken the fifth.
Absolutely, Your Honor.
And violated the order.
They could have. Well, yes. And more importantly, now we're jumping a little bit forward to the issue of materiality. But as to the materiality, which we'll get to, the prosecution could not have secured the assistance of these witnesses, period, without the proffer agreements, because these individuals, by their able-bodied counsels, sought out and negotiated these proffer agreements so that they could go in with some assurance or protection that whatever they said couldn't be used against them. Use immunity, that's exactly correct, Your Honor. If Mr. Moore can move down on this. So the prosecution has continued to say the agreement doesn't confer any sort of immunity. I mean, it is completely puzzling how they could make that assertion, because right here in 6A paragraph, it says this office will not offer any proper statement made by you or your client in this office's case in chief in any criminal prosecution of your client. What does that mean? It means that those school officials who sat down with the prosecutor's office could say anything they wanted to in that room, knowing whatever they said could not be used against them at any later time. That is a grant of use immunity.
Only if it was true.
Only if it was true. You're correct, Your Honor. Only if it was true.
If they lied, that's wrong. Right?
That's correct. If they lied, then it doesn't. But the point I'm making is the prosecution has gone to great lengths to, in my opinion, gaslight us to tell us this isn't immunity. This is use immunity. I attached to my reply brief, Your Honor, a DOJ manual, a prosecution manual by the Department of Justice that describes in detail what these use immunity agreements are and proffer agreements. In federal court, we call them castigar letters with a K. In state court and federal court, we see them called proffer agreements. You've also heard them perhaps referred to as queen for a day letters. Okay, I don't know where that came from. I don't know who coined the phrase queen for a day.
I Googled it, now I don't remember.
Well, I Googled gaslight, Your Honor. So I want to talk about
a movie from
1944. That's correct. It was a movie from 1944, Your Honor. And in that movie, if I could, and I just please, if you could indulge me for just a minute. In the movie, a husband married a woman who's had a famous aunt who had
Wait, that was it Betty Davis?
I don't think it was Betty Davis. The wife's name in the movie was Paula. But the man married Paula because her aunt had lost jewels. And he wanted to get the lost jewels. He was trying to find her lost jewels. So he married this woman, Paula, so he could try to figure out what happened to the aunt's lost jewels. After they got married, he was searching around the house, creeping around like a cat. He was in the attic and he was walking. And the wife said, "I'm hearing footsteps." He said, no, you don't hear anything, honey. You're making it up. Because he wanted to tell her, to convince her she was crazy and needed to be institutionalized. And then he dimmed the gas lights. He was dimming the gas lights and flickering the gas lights. And she said, "Honey, the lights, something's wrong with the lights." And he said, no, it's in your head. The point is, now the term gaslight, I don't think we heard it before about 3 years ago, like 2 years ago, but we hear it all the time now. So I did take the time to figure out what it meant, but essentially stands for the idea that when someone's trying to tell you not to believe something that your eyes can see, they're gaslighting you. And that's what the prosecution is doing in this case by telling us that this agreement does not provide for use immunity. So why is it so important? Why do we care if this provides for immunity or not? Because MCR 6.201, if Mr. Moore could bring that up for a second. MCR 6.201, which is our discovery rule, which is the embodiment of the constitutional due process principles of both the Supreme Court's decision in Brady versus Maryland and Giglio. Those cases have decided that the prosecution has to turn over favorable evidence. So what happened? Perhaps the Michigan Supreme Court adopted this rule, MCR 6.201, that says upon request, the prosecuting attorney must provide each defendant, and then 5, any plea agreement, grant of immunity, or other agreement. So why is this important? Because we have now established that the proffer agreement, if you could go back to that, please. The proffer agreement provides for limited use immunity. So it is I don't even want to say it's my position. It's clear in the black letter of the rule that they had a duty to produce those proffer agreements upon request of counsel. Was there a request by counsel, Your Honor? Yes, there was. Mr. Jackson, could you put the request up, please?
They don't dispute there was a discovery request. They don't dispute that.
Well, I just want to make clear for the record how we link together the proffer agreement to use immunity to MCR 6.201 B5. So here is Ms. Shannon Smith's written formal discovery seeking all discovery pursuant to MCR 6.201. So what does that tell us? Where are we now? We know that they offered use immunity to these 2 witnesses. We know that there was a formal request for that discovery, and we know that the prosecution failed to produce those agreements either before or anytime during the trial. They came out after, and that was due to, I guess, some public reporting by the Free Press. I believe it was Ms. Baldwin's article who first disclosed the existence of the proffer agreement. So we could go back to the proffer agreement, please. That's Exhibit A. So we now know that the proffer agreement actually provides for immunity. If we can move down to 7. It tells us how they can, the cross-examination and rebuttal of inconsistencies. This office may use your client's proffer statement in any proceeding to cross-examine your client. Why is it important? Again, because the prosecution is arguing that this proffer agreement did not provide for any assurances and that it didn't even contemplate that these school officials would testify as witnesses. That, Your Honor, respectfully, is gaslighting, because we can see what the proffer agreement says.
I don't think they said that.
Well, I respectfully disagree. They say right here, there's no promises of favorable consideration. Your client's not entitled to any consideration regarding the charges. It's a gross mischaracterization of the proffer agreements to call them cooperation agreements. They actually do say cooperation agreement. It says cooperation in here. And
It doesn't require them to testify. They could still have not testified.
That's
They
correct.
refused to testify.
That's
right?
correct. They could have not. But here's the point. Here's how they brought these witnesses to the table, to get them into court and to sit in that box to testify. But for the proffer agreements, those individuals could have asserted their Fifth Amendment. And as Your Honor knows, because you said it several times during the trial when there was a dispute about Ms. Crumbley's son testifying, and you told the defense, you're not going to put him up here so he can assert the Fifth Amendment, which is the law in Michigan and always has been. And of course, Your Honor is aware of that because you already made that ruling. The same thing applies here. The prosecution couldn't have brought these witnesses in to testify if they were going to assert the Fifth Amendment. And they had every right to do so, especially considering the overt interest of their deficiencies and failures and whether those deficiencies and failures rose to the level of criminal liability. So if they would have asserted the—
You mean the of Ejek and Hopkins?
Yes. If they would have asserted the Fifth Amendment, Your Honor, they wouldn't even have been here.
Right.
Okay?
Mm-hmm.
And without them, we wouldn't have had any of this testimony about this meeting, this key meeting that this whole case was about, a couple hours before the shooting started, the meeting at the school.
There would have, it's not that there would have been no testimony. There would have been no testimony about what specifically was said at the meeting.
That's correct.
The meeting was 12 minutes long. So there's a video of Mr. and Mrs. Crumbley coming in. There are numerous texts and emails showing that Ms. Crumbley got the picture, that defendant James Crumbley got the picture. Mrs. Crumbley showed the picture to someone she worked with. There's videotapes that show that Mr. and Mrs. Crumbley were at the school for a total of 12 minutes, and then they left without their son.
Sure.
Right? So
That's
there's
correct.
testimony about whether or not, from Ejek and Hopkins, about whether or not they were asked to take him home, whether or not there was discussion about checking the backpack, anything like that, right?
It wouldn't have come in.
There would have been a hole in the testimony.
That's right.
But there would have been other testimony that supported the fact that the meeting happened, that the meeting was brought about by that disturbing picture, text back and forth from Mr. and Mrs. Crumbley to Mrs. Crumbley's friend. There was a lot of evidence surrounding that meeting.
There was, but Your Honor, most importantly, the school officials offered testimony, very specific testimony about their subjective descriptions about Mrs. Crumbley's actions during the meeting. That could not have come from anywhere else, and that is, in my opinion, thank you. I like when judges say they agree with me.
I know, it really does something for you, doesn't it?
It really doesn't, only if at the end of the day it means something. But
I have read everything 1,000 times, believe me, and I can't unremember these trials.
I believe and understand you, Your Honor. But the point I'm making is it's not cumulative. So for instance, in the Chanel case, the People versus Chanel, the 2014 Michigan Supreme Court case.
That's the McDade, right? Chanel 495, Michigan 142.
That's correct.
So assuming for the sake of argument, I haven't heard from the prosecutor yet today, assuming for the sake of argument that I agree with you that the prosecutor violated the rules of discovery, right?
Yeah.
I need to know what you say the remedy is.
Well,
I agree that credibility is always at issue. If I had $1 for every time I said that, I could retire right now. Credibility is always at issue, and it's clear that the statements of Mr. Ejek and Mr. Hopkins would potentially be used in charging decisions with regard to that. That's clear. But if you go further and reach Chanel, the difficulty is for the court to find there's a Brady violation, I would need to find not only that the prosecution suppressed the evidence and that it was favorable to the accused, but viewed in its totality, its material, right?
Yep,
And it's material, it's exculpatory or impeaching.
that's correct. So that's correct. I agree with that. But in the Cheneau case, let's just be clear about why the Cheneau case is not a good template to decide this issue. In Cheneau, the Michigan Supreme Court said that there was a suppression, there was a violation, but that it wasn't material. Why was it not material in Cheneau? Because that witness did not have any sort of cooperation or immunity agreement. And so that witness, there was no basis to attack that witness for bias or motive for what she was saying. I see you want to ask me a question.
Well, if you knew how many times I read this, it would, okay, so.
And it was also cumulative in Cheneau, and it's not cumulative here because they couldn't get those subjective descriptions from anywhere else except these two school officials.
Okay, but what part, what would be missing? That she came to the school and she left without Hopkins,
Yeah.
Mr. Hopkins, and Mr. Ejek. You still have, she came to the school, she left
Yeah.
the school.
So
Wasn't with her son. Obviously, no one searched the backpack. Everyone was very disturbed by that picture.
yeah,
And minutes later, right?
yeah. So here's why it's
And
material.
minutes later, when the shooting starts,
Well, it's hours.
2 hours.
Yeah.
She doesn't think to herself, oh, I'm so worried about the safety of my son. That's not what she thinks.
Well, we don't know. That's what
She says, Ethan, don't do it.
Well, that's after the fact. But I want to back up to the meeting because you asked me why is that testimony so important and material. It's not just the time people arrived and that they left. Here's what they said. Okay, this is Mr. Ejek testifying that he had an expectation that they would be leaving from the meeting with their son. He said, it seems a little odd based on my experiences. So they were trying to lay a predicate that would satisfy the gross negligence standard that didn't come from anywhere else in the trial, because that meeting is where the prosecutors say Mrs. Crumbley should have done something or taken her son.
Okay, but how is the testimony? There's a difference between the credibility of the witness. I agree with you that the credibility of the witness is always an issue. And, so there would have been robust cross-examination by Ms. Smith, right?
Mm-hmm.
But the problem is, the defense could attack the credibility of Mr. Hopkins or Mr. Ejek based on the proffer and the fact that they knew the proffers would be used in a charging decision, right? But the prosecutor says the problem with that is that the testimony of Mr. Hopkins and Mr. Ejek about the 12 minutes your client was at the school is consistent with what your client said happened at the meeting and still would have been even after robust cross-examination. In other words, that the jury didn't have to believe Mr. Hopkins or Mr. Ejek over your client to convict her. They could believe all three as well as the rest of the evidence and still convict.
I disagree with that, Your Honor, because the prosecution is essentially trying to put us in the box that says the only way we could have impeached those witnesses was with a prior inconsistent statement from the proffer. That's not my argument. That's not my position.
No, I get it. No, it's not a prior inconsistent statement.
I don't.
It's you went and talked to the prosecutor's office and you knew whatever you said could be potentially used in a charging decision, right?
Yes.
Yeah, I get it.
Oh, right.
Yeah.
But it affected their credibility as to these subjective descriptions about, well, it was odd to me. She was in a hurry. She just wanted to leave. She said she had to go to work. Those are all subjective.
She testified, she said, are we done here?
No, she testified, Your Honor. I'm sorry to respectfully, just to correct the court. Mrs. Crumbley testified that.
The transcript, by the way, I
Yeah.
got this doorstop, but this is the guidepost report.
Yeah, I know. I'm sorry. I gave you so much papers. Mrs. Crumbley testified, page 223 of her testimony. She was asked, did you mean to be abrupt about ending the meeting? I didn't think I was abrupt. Did you think you ended the meeting? I think it just automatically ended. So this is the dispute between those witnesses and Mrs. Crumbley. She couldn't refute.
That's not your brief. Your brief doesn't say.
It's right here.
That if we knew about the proffer, the testimony would have been vastly different.
Well, actually, to be honest, Your Honor, I think without the proffers, if they wouldn't have secured the proffers, if those witnesses would have asserted the Fifth Amendment and they hadn't testified at all, Mrs. Crumbley wouldn't even have needed to testify, because she wouldn't even have needed to try to rebut these subjective descriptions from the
She
witnesses.
wasn't called to rebut them.
Well, I disagree, Your Honor.
I think she was called to humanize her.
Well, perhaps, but there's a twin purpose of it, because Ms. Smith, trial counsel, certainly asked, well, did you mean to be abrupt? She says, I don't think I was abrupt. Why is that important?
Okay, but you're arguing that she couldn't have been convicted without EJAC and Hopkins.
Yeah, I believe she could not have been convicted without EJAC and Hopkins. That meeting was key. Let's not forget, the prosecution's theory is that Mrs. Crumbley should have and could have done something at that meeting, and so they portrayed that meeting in a certain light, which was she was uninterested, she was in a hurry, she had to get back to work, she didn't seem to, it was very odd to me. We had other meetings before, but this one was odd, this one was different. Those are subjective descriptions that they can't run from that, and how could the defense contest that? I don't believe Ms. Crumbley could have been convicted without the testimony of EJAC and Hopkins, because that meeting was the linchpin of the gross negligence, insofar as the prosecution's theory was she should have done something then.
Okay, wasn't the linchpin of the conviction the fact that there was that picture, it was sent to her, there's things all over Facebook about the gun that he got for Christmas.
I don't disagree that some of those things.
Don't get caught looking for bullets on your phone.
Your Honor, I believe that those things in part could contribute, but we cannot now parse out after the fact the import of those two individuals' testimony juxtaposed against the other things that Your Honor is pointing out. So why would they have called those witnesses? What was the reason? Let's just think about it for a second. What was the reason for calling these witnesses to begin with? Because they could not establish the basis of what happened in that meeting in order to then say to the jury, she could have taken them at the meeting, she could have went and got counseling, and we already know, Your Honor knows, they did not require the parents to take their son. They said, no, he can stay in school.
Okay, but how does that matter? Any parent could come and pick up your child at any time, right?
How does that matter? Well, because
you're
because ultimately the jury was being asked to decide, do you think?
taking him home regardless.
Sure, she could have, but they told her she didn't have to, and that there was the plan that he should be around his peers. So they made it optional. But this is where they tried to sway their testimony to help the prosecution, or say, well, but we thought they would take them. Okay, so you either thought you would take them or you were going to require them to take them. Which one is it? And it's my argument, Your Honor, that the prosecution was unhappy with what some of the statements of those witnesses. So they got up on redirect to try to bolster them by saying, well, what did you think was going to happen? Well, I thought they were going to take it. It was my expectation. That's substantively different. So the reason they called them was because they wanted the jury to hear this moment in time, 2 hours before the shooting. They wanted to focus on what the Crumbleys could have done. And what they ended up saying was, well, we thought they should take them, and it was odd. And she ended it abruptly. She didn't hug her son. Did they hug her son? No, she didn't hug her son. Those are subjective descriptions that wouldn't have come in from anywhere else. The jury was left thinking, well, these two school officials are noble and selfless, and they're just here to tell us what happened, without knowing that they were under the threat of prosecution. Let's not forget the prosecution.
They were still under the threat of prosecution.
Sure.
Part of the problem is, in your brief, is you assume that or think that if Mr. EJAC and Mr. Hopkins were charged, then that exculpates your client. All four of them could have been charged.
Yeah.
In theory.
Sure.
In theory.
Sure. And the jury also could have said, well, if these guys are facing criminal prosecution, then we should be thinking more about what their failures were. And maybe it wasn't that she was grossly negligent. They didn't know that. So back to my point, the school officials could come in and look noble and say, oh, we're just doing this. And Your Honor, just to remind the court, the prosecutor announced the date after James's verdict that they wouldn't charge the school officials. So Why is that important? Because they dangled that carrot over those witnesses to get them to cooperate and to come in.
They were probably never going to charge them.
I agree. I agree they were never. I agree they were never going to charge them, but they had to keep that in place until after the trial. They had to keep that threat of prosecution in place until after the second trial, and they obtained their guilty verdict. You don't like that?
I don't know.
Well,
I think they had their hands full with the 2 trials that we did.
If this isn't materiality, that I don't know what could be materiality. And the Chanel case, the suppressed video statement, the suppressed witness statements, as the Supreme Court said, a couple of things that are markedly distinguishable from this case, Your Honor. One, they said it was cumulative. This isn't cumulative, as I've already described to the court. What they said about their subjective descriptions was not cumulative of anything else. That's number one. So it wasn't cumulative. Number two, in the Chanel case, they said, well, there were only minor inconsistencies, nothing substantial between the statements of the witness and the recorded statements that were not produced. So fine, they had marginal value. As Your Honor said, well, their proffer statements weren't really inconsistent. I agree with that. The proffer statements weren't inconsistent, but that only assumes the only way to impeach the witness is by a prior inconsistent statement. That's simply not true. You can also impeach the witness by motive and bias, and that's what the purpose was.
I agree.
So let's not accept the idea that if the proffer statements themselves were not inconsistent with the trial testimony, there's nothing to be done here. That's false. That is an incorrect assumption, because it has nothing to say about the actual motive and bias of those witnesses, which was absent in the Chanel case because that witness didn't have any proffer agreement or cooperation agreement.
All right, what else?
What else? They wouldn't have testified without the proffers. So back to the point.
Okay, but
then they wouldn't have had that description, the damaging testimony. She was in a hurry. She didn't care. She wanted to get to work.
They have a video.
But not of what was said. We don't have a video of those. Those were subjective descriptions. It couldn't have come from anywhere else except the 2 witnesses.
What specifically? That's a very small part of the evidence presented.
Oh, I don't think it's
happened that day.
Well, but that's the key evidence. It's the last interaction between the parents and the school officials and the son.
Why is that the key evidence?
Because when they argued,
she goes to the school and she leaves the school. Her and Mr. Crumbley.
Because they said it seemed a little odd based on my experience. That's page 45 of EJAC's testimony. Typically, he says, he's trying to help the prosecution. Typically, parents follow the direction. He says, I did think it was strange they didn't take their son out. That's page 71. My expectation was that he would be leaving with his parents. Those are all subjective descriptions that only could have come from those witnesses. That your Honor's, your point is, well, we know what time they got there. We know what time he left. Sure, we know there was a meeting.
We know what happened before that, and we know what happened after that.
But the prosecution's theory was, in closing, they were at the meeting and they could have taken these steps at that time, but they weren't interested. They were in a hurry. She wanted to go back to work.
Okay, but
so
they don't need EJAC and Hopkins for that.
I think they do. Because, well, how could they make that argument and say she was in a hurry, she wanted to go back to work without their testimony?
Well, she obviously did not tell them that they gave him a gun for Christmas, and that it was all over Facebook, and that she had heard about the bullets the day before, and that there was that horrendous picture, right? That picture that should be disturbing to any parent that was sent to her. She was so disturbed by it, she showed it to someone she worked with, right? And then she goes there, and did EJAC and Hopkins check the backpack? No. But she didn't check the backpack either, right? She didn't check the backpack either.
Well, as we know from at least the Guidepost report, the Guidepost investigation found that they should have checked the backpack.
Don't be hurt when I tell you we didn't read it.
I won't be hurt because
it's not relevant to
it is 560 pages.
It's not relevant to these proceedings. And sadly, I know most of what's in there firsthand.
It may not be relevant per se, other than to show the context that these individuals were facing. If the parents were grossly negligent, then the school officials could have been grossly negligent. And
Probably.
And the jury could have decided where they wanted to place that amount of blame, whether to reach guilty on the gross negligence.
It's like a comparative negligence civil theory or something.
No, Your Honor, it's
like, okay, do you think that you were gonna tell the jury, okay, these three all messed up, pick one?
the standard is beyond reasonable doubt, Your Honor. I don't need to tell you that. I know you know. That's all they needed to do was create some doubt, and they shored up any doubt that may have existed by virtue of bringing in those two schools. Like, I mean, I feel like what I'm hearing from the court is that this meeting was inconsequential, and I'm reading this.
It wasn't inconsequential, but you're telling me that if there wasn't testimony about what happened at the meeting, or if their credibility was in doubt, which it would have been, their credibility would have been in doubt based on this property. You're telling me that if all that happened in the meeting was not presented to the jury, your client wouldn't have been convicted. That's what you're telling me, and I think that's a big leap.
Well, hold on, Your Honor. Let's back up. The Chenot case in the Michigan Supreme Court, they made clear, I don't have to prove to you that we would have won an acquittal. I only have to prove there's a reasonable probability that the outcome could have been different. And then Justice McCormick goes on to write what that means. And it means that there's a lack of confidence now, because looking back, we have to say, and Your Honor's pointing out this. Fine, that's fine. We have all these things. But how can you take out that damning testimony from those two individuals, their subjective damning testimony about what they say, oh, she's in a hurry, this was odd, this was unlike other meetings. That's damaging testimony. So you might be ready to say, well, you had 8 other pieces of evidence, and you're telling me, Mr. Desi, you want to remove the 2 pieces, but isn't 8 enough?
But
no, it's not a sufficiency of the evidence standard.
Whether it undermines the confidence of the outcome.
It absolutely undermines the confidence of the outcome, because they could not have received that testimony of that nature from anybody other than those school officials. But this is, and I've said it a few times, and you're probably going to tell me to stop saying it. These were these were highly subjective descriptions of what they believed was Mrs. Crumbley's mindset. And that is what the jury heard, with it being unchallenged by the fact that they were highly incentivized to say that to help the prosecution. And as we know, soon as they
were highly incentivized to not get charged, right?
Yeah, absolutely. So, look, we all know how this works. When you have situation like this, these witnesses are going to do what they need to do. They're going to say, oh, I think they want me to be a little bit more helpful. I think they want me to establish this fact a little better. So
I'm back to, there's no evidence contradicting what they said, and your client's testimony matches what they said.
I don't agree it matches, because.
Well, you didn't tell me you agreed with it match.
Well, I'm telling you right now, it's on page 220.
I don't have the transcript of the trial. It's in my brain permanently, but
I have it if you like it. Your Honor, my brief was 35 pages long. The court roll's only 20 pages. I mean, can I tell you something? My brief was actually closer to 45 pages at first.
It wasn't a brief.
Yeah, it's a oxymoron, isn't it? I'm not looking for praise for my brief. What I'm telling you is, this, now that we're drilled down on this issue of how it could have been contested, right here, Mrs. Crumbley's testimony on page 223, she disputes in principle and in character the testimony that she ended the meeting abruptly. Well, that's important. The jury said, oh, she didn't care. She just wanted to get out of there. She was in a hurry. That's damaging testimony. And if they didn't have any of that testimony from that meeting, then we're left with, he saw something 8 months earlier, and Mrs. Crumbley explained that and said, look, we tell jokes and stuff about this and ghosts. So the jury could have said, yeah, we believe that part. But now that we understand that these school officials are under the threat of prosecution, we're thinking very seriously about whether to accept their subjective descriptions about what occurred. It's that simple. I mean, this is materiality. If ever there was materiality, this is it. The Chenot case isn't even come close to the facts in this case, because it was minor inconsistencies, it was cumulative, and there was no agreement by which to challenge the witness as being biased or having a motive.
There's other cases that say similar. right? There's other cases.
That say
besides
similar-
Chanel about materiality.
Oh, sure. There's more cases than we probably even need on the law books about materiality, Your Honor.
Yeah.
Right?
It's,
If you want, we'll file all of them.
I run them.
Well, then you've done more reading than me, because I can't say that I've read them all. You asked me when we started about the remedy.
Is there a remedy if it's not a Brady violation?
Well, just before we get to that, if I could, please. I would ask the court to consider People versus Mumford. This is on page 9 of my motion, Court of Appeals case from 1990. It is axiomatic that the credibility of a witness is an issue of the utmost importance. It is also axiomatic that evidence of a witness's bias or interest in a case is highly relevant to his credibility.
I agree with that.
And that's the controlling standard. So it is impossible to say that these two witnesses' subjective descriptions were cumulative. It's not cumulative. It didn't come from anywhere else. So I would ask the court to view that testimony and what happened through the lens of what the Court of Appeals said in the Mumford case, number one. But back to your question now about the remedy. The remedy I'm asking for, Your Honor, is an acquittal. And I have a case cited in my brief. That's the Causey case. It is an unpublished decision from the Michigan Court of Appeals.
Do you really think I'm going to do that?
No.
Okay.
But I want you to, because I think you should. And I think the most important reason why I think that you should is because the violation of the discovery rule in this case was intentional. This wasn't an oversight. And Chanel, it was an oversight, Your Honor, right? You agree?
There's other cases. There's a case that talks about a constitutional violation should be viewed by the quality of the evidence, not by something about the character of the prosecutor.
Well, you did say you've read more cases than me, so maybe that's why I didn't read. But can I just make a point about this my request for the dismissal? The remedies generally under Brady generally is a new trial. But in Michigan, we have the specific rule MCR 6.201, which also provides that the court can take any action just to correct.
Oh, I found it.
Yeah.
If the suppression of evidence results in constitutional error, it's because of the character of the evidence, not the character of the prosecutor.
Oh, I haven't said anything. You've told me I can't talk about the character of the prosecutor. I haven't talked anything about the character of the prosecutor.
You said they intentionally violated the discovery rule. That's what I'm.
But this is why I was making a distinction between MCR 6.201 and the federal cases about Brady. Okay. Because in Michigan, so Your Honor, Brady and Giglio set the floor as to what the constitutional floor of rights is, okay? Brady was decided in 1963, and it has been the law in the land since that date that the prosecution has to turn over favorable evidence. Michigan can decide that they want to offer greater protections than what Brady offers. So that's
why they get rid of Lester.
Huh? That's right. That's exactly right. That's why they get rid of Lester. Your Honor, it's almost so much fun that we're debating these cases. I
don't think so.
You don't? Okay. That's why they overruled Lester. The point is the Michigan courts can always decide to offer greater protections than those offered under the federal case law for Brady and Giglio, which I believe that was what you were reading from. Isn't it?
I think it is from Giglio.
See? So that proves my point, Judge. You're reading from the
it's from Chanel.
Oh, shoot. Well, either way, we're back to I'm not challenging the character of the prosecutor as much as I'm trying to explain that this was intentional and it wasn't an oversight. And Chanel, the detective, was on the stand and he said, oh, wait, the defense doesn't have these videos? I thought they had the videos. So that was an unintentional or inadvertent suppression.
Okay, but what case says that?
What case is what?
I've had plenty of cases, actually in the past year, 2 different cases, where the prosecutor inadvertently did not provide some evidence. One was ballistics. Guess what? Brady violation. It's over. There isn't a case that says intentional or unintentional, right?
No,
Guys,
but
I'd like to know what it is.
okay, but in Michigan, in the Causey case that you don't like,
I don't like it. Why?
well, you said you don't think I'm going to do that, do you? In Causey, they said that you could do it. In Causey, they said that dismissal is an available remedy.
Oh, you said acquittal. I mean, I guess it's the same.
I think it's the same. So in Causey, the court said that if you're going to consider it, if you're going to consider a dismissal, we have to consider certain factors. And these are listed on page 5 of my brief. That is not brief, as you've indicated. And starting with People versus Al Hiswani, I won't go through these, but there's a number of factors that the court has to consider whether it wants to grant as to the appropriate remedy. If Your Honor doesn't accept the notion that a dismissal,
It's unpublished, right? And
yeah, it's unpublished.
And non-binding.
Yeah, you're right about that. We're all going to agree on that too, Your Honor. It's one thing. Before we leave here, that will be something we agree on. But these cases, and Leo is also cited in my brief, People versus Leo on page 6, same thing. These cases make clear, People versus Clark also, these cases make clear that the court should balance a number of factors when determining what the appropriate remedy is for a discovery violation. And Causey makes clear that the court can do so independent of whether it finds a Brady violation. Causey says, you know what, we don't have to concern ourselves with finding a technical violation of Brady because in Michigan law, we can rely on MCR 6.201 to offer an additional remedy above the floor that's offered by Brady and Giglio. You like it? You don't like it?
I'm gonna read it more thoroughly.
Okay. Would you like to hear anything else from me about the materiality and the proffer
Not at the
agreements?
moment. If I think of it, I'll let you know.
Okay.
All right.
Thank you, Your Honor. Oh, and you never did grant my motion to exceed that 20-page limit, although you told me my brief was.
I stopped reading it.
Oh my, well then, I'm in trouble, I'm sorry. But if we could just for housekeeping purposes at some point, make clear that the motion has been accepted.
Mr. Pease.
Judge, there were so many fundamental misstatements of law and fact there.
Okay.
I'm gonna need some time to reply. I will answer any questions you have. Thank you.
Do you concede that there was a discovery violation?
No, absolutely not. And I want to start off with a few things. And I'd call it gaslighting just now, but this isn't a game, Judge. It's not a game, okay? Number one, the prosecuting attorney made it clear as early as February 2022 that the evidence that she had reviewed did not support charges of either Nick Ejack or Sean Hopkins as early as February 22. Number two, we can't go back in time to manufacture a new defense when one is not supported by either facts or evidence. I'll get to that later, Judge. Number three, those witnesses were subpoenaed to court. They didn't show up because of a proffer agreement. They were subpoenaed. And the plain language of the proffer agreement supports that.
But you didn't say that they had to testify, but they could have still taken the fifth, right? Yeah.
Any witness can attempt to take the fifth for any reason, Judge. Any witness can. There's nothing regarding the proffer agreements that indicates that the only reason they showed up to court was because of that.
Okay, but why didn't the prosecution provide that information? Maybe we wouldn't be here. I'm positive that decision wasn't an offhand decision by an APA or a Bates stamping.
I want to read the rest of the court rule that counsel didn't read through. And that's 6.201B5, the entire sentence, Judge.
Yeah.
Any plea agreement, grant of immunity, or other agreement for testimony.
Comma.
There was no grant of immunity, Judge.
It's not use immunity?
It is not, Judge. The only way to grant immunity is to petition the court for immunity. It's to contain a verified statement to what these witnesses could be immune from. And the statutes on immunity, that's 767.A7 and 780.701, specify that. They also specify that immunity is regarding testimony. There was no agreement for testimony. I want to give the court a little bit of background.
There was an agreement not to use it in a case in chief if they were charged, right?
Anything they said in that meeting, yes. Yes, Judge. No agreement for testimony, no discussion of testimony. I want to go through the background of that, Judge. First, I want to talk about.
I'm going to let you say everything you want to say.
Thank you, Judge. Jennifer Crumbley was convicted based upon her level of gross negligence because she was the cause of these 4 deaths and because what her son did was reasonably foreseeable to her. Nobody else heard, Judge. That's why she was convicted. Now, the defendant claims.
Well, that's what the Court of Appeals talked about.
Yes, Judge. But she wasn't charged or convicted based upon anything that Hopkins or EJAC did. Okay, I want to go through the uncontested evidence, and that underscores that point. On November the 30th of 2021, and I'll be brief.
Well, I hate to interrupt you, but I'm not. Okay, so you've skipped to the Brady violation.
No, I haven't. I'm still in discovery.
Okay, well, I have a quote for you.
Should I continue, or would you like to ask a question?
I have a question for you.
Okay.
Because you said you didn't violate the discovery rules.
Correct.
Right? And this quote stood out to me. Unless indeed the adversary system of prosecution is to descend to a gladiatorial level unmitigated by any prosecutorial obligation for the sake of the truth, the government simply cannot avoid responsibility for knowing when the suppression of evidence has come to portend such an effect on trial's outcome as to destroy confidence in its result. This means naturally that a prosecutor anxious about tacking too close to the wind will disclose a favorable piece of evidence. Didn't the prosecutor tack too close to the wind?
No, and I'll tell you why, Judge.
All right, good.
This prosecution was not premised upon either Crumbley or school liability. That is fundamentally false, Judge. And defense counsel.
About a discovery violation.
Yeah, Judge, it's part and parcel of that, okay?
But you're telling me why EJAC Hopkins, Mr. and Mrs. Crumbley could have all been charged and all had their own level of culpability. That's what that goes to materiality. I'm concerned about is the prosecutor allowed to take off the white hat for you in 1 minute?
The prosecutor should follow the law, Judge, and that's what we did.
Yeah.
That's what we did. The plain language law. That's Sanford v. State from 2020. That's a Michigan Supreme Court case.
Yeah.
For testimony, that's a trailing modifier that applies equally to all three phrases, Judge. There was no immunity. That's the statute. No immunity, Judge. And nothing was offered for testimony. Now, again, I want to go through some uncontested facts. I want to talk about the background of how those proffers came to be. November the 30th of 21, the defendant's son committed the deadliest mass shooting in school shooting in Michigan history, where he killed Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. He used the gun given to him as an early Christmas present and the ammunition the defendant bought for just a few days before. The defendant's son, only friend that this defendant had ever seen around, was taken from him a month before the shooting, and she knew that. The defendant knew her son's proficiency with that firearm. In fact, he showed her how to use it just a few days before the shooting. The day before the shooting, she was called by the school and told that her son was looking up ammunition in school. That's November 29th. November 30th, the day of the shooting, she was called to the school, which all agreed took a great degree of concern, and shown that math worksheet where her son wrote the words, "The world is dead, help, my life is useless." He drew an identical handgun to the gun given to him just a few days before, a picture of a body with a bullet hole and blood. When she was shown that picture, her words, that she talked about her son was distraught the night before. Her words, she said she was very concerned. At the meeting, she was given a list of mental health resources, told to contact that day. She didn't. In that meeting, she only confirmed information that either Hopkins or EJAC gave her. She didn't add any information. She didn't hug or attempt to hug her son. She didn't take him home. All agreed that there was never, you need to take your son home right now. You're forced to take your son home. Everybody agreed to that, Judge. That was never in dispute.
Well, Mr. Kelsey said they went on to testify that they thought it was strange.
Their subjective thoughts and views of that meeting have zero bearing on this case, Judge. Zero bearing. She didn't go home after the meeting to look for the gun. She knew that he couldn't be home alone that day. In fact, she texted her friend just that. And when news of the shooting broke, she knew it was him. Judge, that little snapshot is what is uncontested from November the 30th, that meeting, uncontested from those 12 minutes. Not just proven at trial with the evidence, because that would include a whole lot more. That would include the fact that that firearm was left unsecured and he had unfettered access to it. That would include the fact that she was adamantly aware of her son's tearing mental crisis that had occurred some months before. Those facts were proven at trial. But we're talking about just the meeting and what's not in dispute. Because the fact of the matter is that the majority of this case came through text messages, Facebook returns, GPS pings, phone tower records, and surveillance video. That's the bulk of the case. That what happened in that meeting, not in dispute at all. This is not a case of mistaken identity where witnesses had an incentive to identify a shooter as opposed to somebody else, like in Chanel. This is not that case, Judge. The fact of the sheer volume of uncontested evidence underscores that fact. So I want to talk about the proffer agreements themselves.
Do you agree that at the time of the proffer, Mr. Ejak and Mr. Hopkins were subject to potential criminal prosecution and knew it? They were incentivized.
No, I don't agree with that, Judge. I don't agree with that. No.
You don't think they knew?
They could, I don't know what was in their minds, and it doesn't matter. That's the point. There was intense.
If you had gone in there that day, wouldn't you have thought, geez, I could be subject to criminal prosecution?
I think even Mr. Hopkins testified he wished everything went different. He was the only one to testify that he wished that day had gone differently, Judge, and would have done something differently. Now, the fact of the matter is, after the shooting, in the wake of the shooting, there was intense media speculation, locally, nationally, and internationally, whether anybody in that school would be charged. Some of those individuals were afraid, Judge, I'm sure of it. That's why they retained attorneys. And our job before the preliminary examination is try to meet with everybody we can in those 30 days from the time of the shooting to the time where we had to charge our case and start to organize our proofs. That included individuals at the school. Two of those individuals who retained attorneys, their attorneys reached out to us. And although they were adamant whether their clients wished to cooperate and sit down and speak with us, for the attorney's own sake, they requested the first meeting to be in a proper setting, and we agreed. There was no promise. There was no threat. There was no discussion about testimony. We talked about what they did, what happened November the 30th. And that was entirely consistent with what they told the police on November 30th, 2021.
Wait, let me ask you that because I think I sent an email to both sides. I was a little confused. So the video of Ejak during the proper statement was not provided, but there was an initial police investigation.
Correct.
And the police talked to Ejak, Mr. Ejak and Mr. Hopkins initially, and the police report was generated, correct?
Yes, they were interviewed November the 30th, 2021.
Right.
That was recorded by the police. Narrative reports from the sheriff's office were generated regarding those.
Okay, and then when the proper happened, like, who interviewed them? Did that end up being a police report?
No, it was our office, Judge.
And you just talked to them?
Correct.
Were the police there?
No. I want to talk about that Nick Ejak statement. I will in just a second.
Okay. All right.
Okay. So there was never any agreement or promise for testimony. It plainly does not fit the court rule. And again, that's Sanford v. State. And we'll skip to this part in a second. But even if you were to find that violation, you would still need to find prejudice, which some of the questions you were asking the defense counsel.
Well, don't you think that credibility is always at issue when the defendant is not allowed to cross-examine about the circumstances surrounding the proffer? Doesn't that limit the information the jury may have about the credibility of the witness?
Their credibility didn't matter, Judge. It didn't matter what Sean Hopkins or Nick Ejak did or said. What matters is that Jennifer Crumbley knew all of this. She had 15 years experience with her son, and she got him a gun, and she knew it was unsecured, and she didn't tell anybody. That's not in dispute. And I have gone through that transcript, Judge, and there is no material dispute between Jennifer Crumbley, Sean Hopkins, or Nick Ejak in that meeting.
There's a disconnect. You keep talking about materiality, which is really important, and I'm back on 6.201. Isn't the prosecutor under duty to disclose any information that would affect the credibility of the witness?
6.201, we're talking about the proffer statements themselves. They don't meet that definition, Judge. They don't meet that definition.
All right.
And I don't agree with the point that these proffer statements would affect the credibility of the witnesses. I don't agree with that, Judge. I want to talk about that statement from Nick Ejak. When this underscores the point that it was not for testimony. We didn't call him at preliminary examination. In fact, we hadn't intended.
You didn't call Ejak.
Correct. We didn't intend to call him at all until defense counsel put Nick Ejak on her witness list in December of 2023 and indicated that she was going to call him. We decided we were better off to put him on in our case in chief as opposed to cross-examination. When we made that determination, we should have gone back through the case file and noted that interview instead of work product is now discovery, because that now would have met 6.201, because that would be a statement by a witness, Judge, under the 1999 Court of Appeals case. I forget the name right now. We should have done that.
Ejak wasn't on your original witness list.
He was on the arrest just that witness list. We didn't intend to call him at trial. We didn't need him. We didn't need him in an exam, Judge. Again, because the bulk of what happened on November the 30th at the meeting was uncontested. But before this court even find a discovery violation, this court must find prejudice. And that's where we come back to this faulty misconception that this case was positioned as either Crumbley or the school for liability. The fact of the matter is, any line of questioning, any cross-examination of these witnesses to highlight their own perceived or real culpability would only serve to highlight the negligence on Jennifer Crumbley. Because all agreed what was conveyed to her on that meeting. All agreed. All agreed what she did not convey back to those officials.
Yeah, but Mr. Desi, you put a black robe on, you can read people's minds. Mr. Desi is sitting there thinking, well, we wouldn't even have called her that, right? Because you're saying that her testimony confirmed what Mr. Hopkins and Mr. Ejak said. But Mr. Desi would say that Ms. Smith potentially would not have called Mrs. Crumbley if they did.
The bulk of the uncontested evidence doesn't come from her testimony. She spoke to police as well, Judge. These officers or these individuals spoke to police as well. They testified. They were sued civilly. They testified at civil depositions. Defense counsel trial had that. In fact, she used those questions during cross-examination, and they testified later on in trial. They were consistent all along the way. The uncontested evidence doesn't come from her testimony alone, Judge.
I forgot about the civil depositions. When were they chronologically?
After exam, before trial. I couldn't tell you the date.
Okay.
But we know with certainty that counsel had those because she referred to a page of the deposition during cross-examination. Judge, there can be no. I disagree fundamentally with counsel. This is not cumulative evidence. There can be no prejudice, especially the Nick Ejak statement. It only supports the prosecution theory. It only bolsters it, Judge. There's no inconsistencies there. Now, when we get to Brady, when we talk about favorability and materiality, because the court is correct. Before a Brady violation is found, you need to show that this evidence is either impeaching or exculpatory, and that a materiality is a reasonable probability that the evidence, had it been disclosed, would result in a different outcome. That is not here. That is not the case here, Judge. There can be no showing of materiality.
Different outcome is the confidence in the outcome.
Can you say that again?
I don't know. When we were talking about these cases, this case, like it's not my job to say, oh, I think the jury verdict would have been different. That's not my job, right? But my job is to say, do we now lack confidence about the verdict?
Right.
It's a different thing, right?
The standard is reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Kyle's talks about, in essence, is this a verdict worthy of confidence? Mm-hmm. I agree with that. It absolutely is, Judge. Again, this has never been the case. Our prosecution never hinged upon any perceived or real liability on behalf of Sean Hopkins and Nick Ejak. Should they be successfully sued or successfully prosecuted at some point in the future, that would have zero impact on Jennifer Crumbley's convictions, because she was convicted based upon what she didn't tell anybody, what she knew, what she didn't do. The level of uncontested evidence there, that's what speaks volumes. That's what shows and underscores the level of confidence in this verdict. Does the judge have any further questions on this topic?
Not at this exact moment. I'm going to let Mr. Desi respond. And you would like, I'm going to let you respond. I'm going to let everybody say whatever they want. In the end, one side or the other won't be happy that they won't say they listen. So
that's fine, Judge. Thank you, Judge.
Mr. Desi?
Your Honor, just a brief detour from the substance of this. I would be remiss if I also didn't tell the court I have a third law student who isn't here, and I forgot to mention her, and it's important to me that I want to tell you that I also have a third student by the name of Stefania Ilievska, who's also assisted and been working on the case. She's not here today. She couldn't be here, but I don't want that to be unsaid. So with that, Your Honor, I'd skip back to getting into what Mr. Keith said. You know, he just said, well, we didn't even need Ejak. We were going to call him. Well, then why did you call him? I'll tell you why. Because, well,
Ms. Smith was gonna call him.
Well, we're adversarials. We're adversaries, so I don't have to accept his assertion as to why he called him or didn't call
Well,
him.
it would make sense because it was chronology, because Mr. Hopkins talked about what happened in the office and then Mr. Ejek came back, so
You're not gonna,
chronologically.
you're not gonna like what I'm gonna say, but they called him because they wanted him to say that it seemed a little odd. Typically, parents follow the direction. They called him to get those back to this subjective descriptions that they could then use as the basis for gross negligence. Okay, so the prosecution is just being absolutely recalcitrant about even acknowledging what MCR 6.201 says, even though we talked about gaslighting and what the husband was trying to do with his wife. They're still saying it's not an immunity agreement. Well, then they don't understand what a use immunity is. If that's the case, respectfully, they're just telling us not to believe something we can see with our own eyes. The subjective testimony is the key. And I know you said you read everything. I don't want to get caught up in my papers. But Mr. Hopkins also provided a wealth of subjective testimony. He had concerns of suicide. That was on, of course, you already know that. I don't have to tell you.
Yes.
He didn't want him left alone. He wanted him to be seen as soon as possible. I wasn't expecting them not to follow through page 138 of Mr. Hopkins. Why am I telling you this? Because this is subjective testimony that went to the core of gross negligence. But here's my other real dispute with the prosecution and what they're arguing. They're arguing that there's sufficient evidence notwithstanding. That is not the standard. Materiality is not a standard of sufficiency of the evidence. Sufficiency of the evidence just says, well, there's other stuff that would support the conviction. That's not what we're doing here.
Well, that's about the confidence. That goes to whether or not you have confidence in the result, but it also goes to whether or not there's a difference between credibility and teaching of the testimony. So they also say that
sure,
other evidence provided in the trial supports what Mr. Ejek and Mr. Hopkins said.
Well, yes and no, because the prosecutor also said, oh, there was this, there was this, there was this, there was all of these other things. So what he's suggesting to you is you should find that there was sufficient evidence to support the conviction. And there's just, there's case law. I know I stopped at 35 pages. I told you I already edited out about 10 pages. But I had a lot of case law in there about this exact point. And I took it out because I didn't think we were going to fight about it, or just, I shouldn't say fight. We're not fighting. We're debating the issue of it. But there's lots of case law that says materiality is not dependent on a sufficiency of the evidence. And it's back to what Your Honor said with Chanel. We have to ask, can we have confidence verdict, not given the fact that they withheld and suppressed this information? I understand why the prosecutor wants to tell you they didn't have to give the agreements, because it's so obvious the materiality is met in this case. So they're going to go back to square one and say, well, we didn't have to give the agreements. We don't think we needed to provide them under 6.21. We're not going to go back through it because we can read it for our own eyes. So I would suggest that the materiality in this instance is easily demonstrated. I don't even think it's a close call because there was no other testimony about that meeting. And don't forget, the prosecutor stood up in the closing and they mentioned all the things about what they believe Mrs. Crumbley could have and should have done and how she was despondent or disinterested during the meeting. So obviously it was important to them because they elevated it to the point of putting it in their closing argument. I'm sorry I've wandered around. My colleague, Mr. Brochet, told me to stop. I teach and I move all around the classroom all the time, so I can't help myself. He told me to stop, though, Judge, just so you know. All right. If you have any other questions for me, I'm happy to answer them, but I believe that
I don't think I do. I mean, anything else, prosecutor?
Just very briefly, I'll keep it very quick. You've been very patient. I appreciate that, Judge. Now, I just want to, again, hit the point that Sean Hopkins or Nick Ejak's perception of what is odd is simply meaningless, Judge, simply meaningless. Jennifer Crumbley knew the background. Jennifer Crumbley knew what that drawing meant. Jennifer Crumbley had the opportunity to take her son home. She chose not to. Jennifer Crumbley should have gone home and looked for the gun. She should have looked in the backpack. She should have put the pieces together. The objective, uncontested evidence is why this verdict is worthy of confidence, Judge. And regarding the proffer statement, again, I just want the court to follow the plain language of the law. That is the law in the state of Michigan. Sanford v. State. For testimony is the operative phrase. There wasn't like there was some roundtable discussion to hide evidence, Judge. It didn't fit the definition, and we never revisited it because it just doesn't fit the definition of disclosure. Okay? I don't want there to be any sort of allegation of malfeasance on behalf of the prosecution. And I know the court already indicated that, but I want that to be abundantly clear. Thank you, Judge.
All right, anything else?
Not from the people.
Well, you told me I can't talk about the other things I wanted to talk about, so.
Because it doesn't have anything to do with today.
Well,
It might be of interest in the future, but the prosecutor, for one thing, the prosecutor it wasn't in your brief initially, and the prosecutor wasn't permitted to respond. And I don't know how hiring someone to field questions from the press or PR or any kind of press videotape could impact the decision with regard to the motion that you filed. I'm not saying it might be relevant in the future. I don't know that. But I guess I would say that your job, Mr. Desi, as you know, is to represent your client, persuade me that her position is consistent with the law. And I guess what I'm saying is that information about a PR firm or media coverage won't help me, as I believe it's irrelevant to the current motion.
Right? Just for the record, I just want to point, it's not a PR firm, okay? Again, fundamental misconception, not a PR firm.
I mean, they were social media influencers, Your Honor. Social media influencers. And their own websites they tell us in their own words.
The county hired this.
You guys can't help it, right?
No, I can't.
Oh my gosh. You could talk to the press about it outside. I know they're very interested in it. I don't think it helps me resolve the motion, so it's not up to me. All right.
Thank you, Judge.
So with regard to the defendant's motion for bond pending appeal, a ruling on this motion is obviously impactful. Therefore, a rule on the motion for bond pending appeal contemporaneous with a written opinion on the motion for acquittal and/or new trial.
All right, fair.
Thank you, Judge.
All right.
Would you be bringing us back then for any?
I haven't decided yet.
Okay.
That's all I could do to get to this point, Mr. Desi.
I cut my brief down, Your Honor, as much as I could.
All right. So I would like to ask that everyone remain seated while the defendant is removed from the courtroom. All right.
Off the record, just will the court cancel her writ?
Cancel her writ? Oh, yes, they'll put somebody by the way. Okay. Maybe that. Oh, this one says take 1 2 days.
Understood.
I just actually will do it.
And that was the end of it. So, anyway, that's where we were with that one. I was looking at some other stuff while that was going on because I wanted to see what you had said about Sarah Boone, and I did find this. Let me see this. So Sarah Boone sent a letter to the clerk of courts wanting to know what was going on with her appellate attorney. And they sent her one back and said that Joshua Adams has been appointed to represent you for an appeal. However, at this time, no notice of appeal is on file. Now, it has been 30 days, but my problem is I don't know what the date of the clock starts. Like, I don't know if we're, how do I put this? When does that 30-day clock start? Because he's got to be assigned to it. And it looks like he was assigned on, based upon this, he was assigned on the 18th day of December, which is well beyond 30 days. But isn't he given some amount of time to do? I don't know. So, I don't know. I just wanted to bring that up to you guys because She's probably having a fit over this. But then they extended it to December the 23rd, which again, we're still 30 days away from that. So I don't know, y'all. I don't know what's going on. But you know that she's having a dad blasted fit over it all. I stopped following Sarah after she got convicted. In that last video we did, everybody was so nasty about everything. I got out of it. But yeah. And says Sarah Boone refused to sign a document statement in the jail saying there will be no movies about the trial for monetary reasons. She refused to sign a document statement. Yeah, because there's going to be, her attorney is going to make the money on that. Her attorney's going to be the one that gets sent in on that. Because that's kind of how they ended up, that was their deal, remember? I mean, that's what everybody suggests. So, yippers. Remember the prosecution brought it up too. Yeah. They were trying to have a private meeting with the judge about that, and it never happened. I kept waiting for something to happen. I was like, up until even whenever she was convicted, I'm like, are they going to have that meeting in chambers or what? Yeah, if she, well, she can't make any money from the crime, but yeah, that would be cool if it went to her son. Honestly, I just don't think, I don't know. I'd rather it go to her son than the attorneys that represented her. I mean, as far as I'm concerned, if it goes to the attorneys that represented her, it's no different than going to her because she would have used it for her defense anyway, you know? If we have time, let me pull up my emails and show you guys the images that y'all were sending me here recently. Here's Michelle's foster kitties. Oh my gosh. That's the color of Huckleberry. He's orange like that. They're so cute. Look at those. Do they all have green eyes? They're brown or blue. Aren't they so precious? My goodness. So sweet. Are they driving you nuts? I bet they are. I bet they are into everything. So precious. Okay, and then somebody else sent me an email with a picture. Hang on. Baby pics. Oh my goodness. This is from This is a dapple dachshund. Shy guy. His name's Maddox. Oh, wait, hang on. Did it not? Here, I'll just share this scrub. Isn't he cute? He's pretty. Oh, Dapple, that is so pretty. Look at those little eyes. Oh, he's a shy one. Now, whose dog is this? I don't know who sent me this. It just says Blondie. Am I muted? Are y'all even paying attention to me? Y'all are just talking. I'm like, hey. Yes, they get into everything. Oh, I bet they do. I remember I had curtains at the time when I was fostering back in the day. I had blackout curtains in my bedroom. Those little boogers would crawl up. They would climb up those curtains. It's craziness. I know I'm not muted. I'm just kidding. Whose Dapple is this? He's adorable. I love him. He's a dachshund, you guys. Okay, hang on. I got another one. Just to let you guys know, still waiting on Law and Crime. No trial. No trial yet. There's some movement in the courtroom, but we haven't had any feed. Let's see. That is a beautiful little baby. And then Shelly sent me the one she puppy sits. Oh my goodness. What a cutie pie. It's so sweet. I love beagles.
Is here for the state counsel. Lieutenant Weger of the court security has something to report, and then I'll ask you how you want it addressed.
Good afternoon. We had 2 jurors have a situation at separate times with allied staff members at the entrance. One stated that the allied staff member made a comment to the effect of, I'm not verbatim, but luckily you're not in the trial with the kid that killed his mom. And then another juror had apparently the same individual said, yeah, you guys are in that mock trial, right? It's already going on. But she didn't understand what he meant, and I don't either. But either way, there were 2 comments made to 2 different jurors.
Mr. Levine?
I don't request anything, Your Honor.
Ms. Thornhill?
Based on what Lieutenant Weger has said, it sounds like it's nothing additional from what they already know. I guess we could ask the jurors exactly what they heard and if it affected how they felt about the case.
Which jurors are in Mr. Hurtel, do you know? Right, if you could get their names and then just frame the first one in.
Allied. Was it Allied Security? Who said it?
This is off the record. See, and here I was, but that's okay. Here I was feeling confident that we'd made it past the possible mistrial.
I'm still confident. That's it. Went no further than that.
Yeah, it sounds okay, but I don't know why.
I can let you know that individual will not be working at the courthouse at any point from this point forward. So I can tell you, and all of the other allied staff are being given very strict reminders. They have already been trained that they are not to discuss, but we are reminding all of them and doing strict. But that individual person will not be working at the courthouse anymore going forward.
Thank you for that reassurance.
I mean, it could have been it could have been somebody who worked at the cafeteria. I don't know. I say allied. It could be a security company. It could be the cooks in the kitchen, the ones that are responsible for doing everything at the cafeteria. You know what I mean? Like, 'cause they outsource all that. But it definitely sounds like somebody, like what she just said, they're associated with the courthouse. Did they say he was a security officer? Okay. What a moron. Yeah, we'll pull up this other one.
Could you cut the audio feed, please?
Allied is the security used in the court. How did y'all know that? And I did not know that. I thought they had their own deputies they used. You would think they'd do, but you think that'd be like the first thing they tell them. Yeah, now what the oh, they're cutting the audio because they want to ask the jurors what they heard and if it's okay. If they let's jump over to Michelle's picture real quick before we do this. Look, oh, that's Shelly's picture, sorry. Look at Boo Boo with his tongue out. What's his name? This is Shelly's grandbaby. Look at that sweet baby. Oh my goodness gracious. I'm telling y'all. I like dogs better than people. I'm sorry, I can't help it. Gamora. I love that. Gamora. Nah, I don't think anything's going to come of this. Because he didn't say anything. It didn't sound like he gave any information that, like she said, they didn't already know. They're trying the kid that murdered his mom. Well, that's the fact that he said the M word. That's kind of bad, but because he's just assuming that it was. But yeah. Yeah, they would have at least one alternate. I don't know if they've had two. That would be my question. Is usually they have, like, let's say it's a 6-person jury. They have what, 2 to 3 different extras they'd have there? But like I know on Sarah's trial, man, they had what? How many did they have? 8? They had like 8 backups or something crazy. Oh, Laura says that most governments use allied as well as separate officers. I know that because Eric's her boo works in a government building and they are used there and many other facilities associated with Northrop Grumman. I didn't know that. I know they did a lot of trials for, or they did a lot of community associations. Like condos associations. Yeah, if they were smart, they didn't say anything and walked away. They probably just said to find out exactly what was said, and they just had to pull just those 2 jurors out. Then they're going to turn around and call the rest of the jury in. So, yeah, that's what we're waiting on.
All right. The bailiff has indicated that you might have been exposed.
Oh, they just got in the room, the 2 jurors that they have questions about. Okay, Nana sent a cat pic. You guys are killing me. Y'all are sending me all your babies. I love it, though. Uh-oh, Nana. There wasn't a picture attached. You're going to have to resend that, Nana. I don't know if YouTube or Google cut it out or what, but if you send it as a copy and paste, try sending it as an attachment. It's Friday, you guys. So glad it's Friday. I don't have it yet. It takes a minute. All right, come on, y'all. Oh, there it is. Oh, okay. I got it, Nana. Okay, everybody, find the kitty. I found him, but can you find him? We're not missing anything. I got the feed pulled up. I can hear when they come back on. Right now, they are not allowing us to hear anything. That's him right there. His little head's right there. Isn't he cute? She got a black kitty. I was driving up to the casino the other night, and a black cat went by. And I was like, oh, I don't know if that's good luck or not. And then when I was leaving, I saw him again, and he's all white underneath. And I thought, oh, goodness, thanks. But it's really like it's a tiny cat, and it was really cold. It was that week that it was super duper cold. And I was like, oh, I hope that baby has a place to get in and get warm. I guess that's why it's around the casino area. It might be getting up in people's cars and stuff to stay warm. It was so cute. But when they're like that and they're skittish and stuff, you can't get them to come to you or anything. But now I'm tempted, though, to take some food with me when I go to the casino. And if he's out there, I'm going to put it out there for him. Y'all can't see it, but the chat and Law and Crime, somebody's fighting in there. See, this is why we don't like to do chats like that. That's why we like staying right here, because we don't like to get into those fights. Roasted chicken? I bet so. You know what I learned recently, though, is that you have to be super duper careful with anything that has any type of spices on it, like any type of seasoning. And I knew onion was bad, but I didn't know about how. But we had a dog get sick over seasoning. No, it's at the casino. The casino's not near my house. It's a good 30-minute drive, so I can still feed them. It's gonna be at the casino. And maybe I bet nobody could catch it, And it could be one of those instances where they catch and release, where they neuter it, spay it, and then release it again.
Welcome back. I hope you had a nice long lunch. I want to ask before.
Oh, for goodness sakes. He's bringing up that thing again with the other jurors, I guess. Did any of you hear anything? Usually they don't. Y'all, this judge is a little bit. He might be the reason why we can't see these photos and stuff. It might not be because the TV's too close to the jurors. Yeah, I see cats every time I go to the casino. What does that mean? Is that a sign?
Yeah, Christopher Ellis. Yeah, Your Honor, may we bring audio?
Oh, yes, of course.
swear to? And you raise your right hand and report this one.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and
Good afternoon. Remain quiet.
All right. Good afternoon, Dr. Ellis. Are you a doctor? All right. Deputy Ellis, could you please introduce yourself to the jury?
I'm Deputy Ellis, Charlotte County Sheriff's Office.
And how long have you been employed in law enforcement?
I've been involved in law enforcement for 9 years. I worked for Charlotte County for 2.
Could you give us your first name?
Oh, sorry, Christopher Ellis.
Thank you.
And what are the different divisions you've worked in, or units that you've worked in?
I'm sorry, say it one more time.
What are the different units that you've worked in law enforcement?
I worked in Louisville, Kentucky for Louisville Metro Police Department. Worked in for 5 years. With them, I did a little bit of the division level task force team, apprehending subjects and drug traffickers. Moved to Florida, worked for Bradenton Police Department, and then now work for Charlotte County.
All right, Deputy Ellis, I want to direct your attention to a specific date. On November 14th of 2023 in the morning time, did you respond to an address, a residence in Port Charlotte, based upon a report you received that the defendant made statements that if deputies made him get in the car with his mom, he would kill her?
Yes.
And where was that statement made? Where was the defendant when he made that statement?
At the Charlotte County Jail.
And was that on the day prior to you responding to the residence?
Yes.
The morning of November 14th, describe to the jury the reason for you responding to their residence.
I received my sergeant received a call and stated that the defendant had made a statement that he was going to kill his mom if he was forced to get into the car with her. We went to the residence, the defendant's residence, spoke with him, ultimately placing him under a Baker Act.
And what was the reason that you placed him under a Baker Act?
From the statement saying that he was going to kill his mom at the jail and just speaking with him not knowing what he was going to do while he was at the home with his mom.
Now, were you wearing a body cam when you interacted with the defendant and his mom at their residence?
Yes.
And was Corporal Joey Shaw also with you?
Yes.
And did your body cam capture some footage of your interaction and Corporal Shaw speaking to the defendant?
Yes.
Did you have an opportunity to see State Exhibit 194 briefly before court today?
Yes.
Your Honor, at this time, the state would move State 194 into evidence.
Any objection?
No objection.
Is received.
And with the court's permission, if I may publish that, Your Honor?
You may.
Thank you. John, there should be a volume.
Catherine Ann Griffith of 202 Victoria Avenue for Ellis 39 for 2571.
Hey, somebody's moving.
Hello.
Hello.
Hey, how you guys doing?
Good. Is Collin home?
Yeah, you guys can come on in. He's doing standing marches. He's not a happy camper right now. You can pick your marching bells on.
What's up, man? What are you doing?
He's doing standing marches as a form of discipline ever since he got home. I have that right there recording it, so you can see everything. I'm sorry? Do what? Just so you know, it's being recorded, because as soon as he got home, I had him start doing standing marches.
Is that working?
I mean, he beat the shit out of me last night, so
Right.
this is his form of discipline for.
That's something for a judge to decide.
Okay. Can we,
we'll go
just gonna talk to him a little, okay? Just, I wanna talk to him, we'll just figure out what happened.
Yes.
So what's going on, man?
Last night, me and my mom got into a physical altercation. I got arrested for domestic battery, but when it comes to judge today, I have right to public defender and see how that goes.
Okay. So how is the situation with you and mom right now? Things calm down?
No,
you guys
no,
everybody
sir.
get along? Where are we at?
No, sir, it's not good. She thinks that I do shit out of her. I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her. I want to kill her. That I want to beat the shit out of her.
Do you?
No, sir.
Okay.
I don't want to hurt anyone, let alone my mom. Even despite this happening, but I'm not gonna take what I consider abuse when someone's attacking me. And
how is she attacking you?
when she attacked me, when she threw a punch at me and grabbed onto me, I grabbed onto her back. I got her off of me. She hit the ground, and then I fled and called Rentis, and then he sent someone out.
You called who?
Rentis, Detective Rentis.
Okay. So basically what we came back is when the jail was releasing you to your mom this morning, was there anything said then?
Yeah, I said that I didn't really feel safe there with myself and with her, and that I didn't know what was going to happen. I still don't know what's going to happen.
As far as what?
Her attacking me or her doing something to herself or me.
Okay, what about you doing something to her? Are you able to control yourself?
I'm in a constant state of fight or flight, and I don't know. If I think she's going to do something, even if she's not, I might act. I'm not going to go crazy or anything, but I'm not sure, honestly. Okay. You're not sure if you're going to hurt your mom? Only if she tries to hurt me. Okay. Did you make any statements saying that you were going to kill your mom if you got in the car with her? No,
I'm trying to figure out why we would have a corporal at the jail that took you out, that dropped you off with your mom and telling us that you said, don't put me in the car with her, I'm going to kill her.
Yeah.
Was that said?
I did not say I was going to kill her. I did not say kill. I don't know why he sent me back here. I asked him not to, but he said he didn't like my attitude and that I had to just walk. He sent me that. But his words, not mine.
Okay. What we're trying to figure out, we just want to make sure we do everything we can to prevent anything happening.
Sir, given the situation, I don't think that we should be in the same house at all.
Everybody else, at the conclusion of your interaction with the defendant, did you Baker act him on that same shortly thereafter?
Yes.
I have no further questions.
Ms. Thornhill?
Ellis.
That's right.
How long had Collin been home from the jail when you all arrived at the house?
I have no idea.
You don't know when the sergeant from the jail called to make this report?
No, ma'am. I just received the information from my sergeant.
So he could have been home for hours by the time you got there.
Possible.
Possible? When you first walked in to the home, Collin was standing with 2 weights over his head and doing marching in place, correct?
Just one.
Just 1 weight?
Yes, ma'am.
Okay, sorry, 1 weight. And Kathy Griffith had indicated to you that she had been making him do that since he got home from the jail, right?
Yes, ma'am.
If Collin had wanted to kill her, unprovoked, unattacked, he could have hit her in the head with that weight that he was holding over his head, couldn't he?
It's possible.
He could have done something while they were driving home in the car together, right?
Possible.
But he didn't do any of those things that you're aware of.
Yes, ma'am.
And he told you repeatedly that he didn't want to do anything to his mom, but that if she attacked him or if she came at him, that he would do something in response to her attacking him, right?
Yes, ma'am.
Redirect.
Deputy Ellis, would it be smart to murder someone in a house that's got video cameras in every room?
No.
I don't have anything further here.
Is the witness released?
Yes, sir.
Ms. Thornhill?
Yes.
Thank you, sir.
Sir.
Next witness.
Your Honor, the state calls Detective Danny Peters with the Polk County Sheriff's Office.
Oh, we get to watch more. Well, we get to listen to more ring camera footage that we can't see. I'm so glad they played that video, you guys. I think that him talking just makes himself look more guilty. You can tell how he's trying to gaslight everything, make his mom sound crazy. Exactly.
Hello, sir.
Sue Joy.
Mr. Levine.
Detective Peters, we left off with your portion of the testimony yesterday afternoon. We concluded with the ring video footage from September 7th, 2024, which was a Saturday. Is that correct?
Correct.
And at that point that the defendant had left the house and Kathy was in the house by herself, correct?
Correct.
Is there also an exhibit in the form of 198 that captures some clips from Sunday, September 8th?
There is.
Was that the day that Kathy died?
Yes.
Later that day?
Yes.
Your Honor, at this time, the state would move state 198 into evidence and ask that it be played for the jury.
Any objection?
No objection.
It is received. You may publish.
Thank you. Is this clip at least from the early morning hours of Sunday, September 8th?
Yes.
No, you told me you were calling him. You told me you were gonna get your neighbor over there, or I'm sending the police. Do you want the police to go? Then you'd rather have the police come. Okay, that's fine. That's the only answer I needed. I will not take a call from you after this ever again. If Colin's not here by 10 o'clock, I'm dead to you. Do you understand me? Do you understand me? Do you understand me? Do you understand me? Yes or no? I need a yes or no. Yes or no? Do you understand me? Okay. You don't understand. And on your little thing, you want a copy of the pink piece of paper that shows it? Call Monique. Call Detective Lacey. Call them. So are you returning home or no? Look at the pictures. Okay, it doesn't matter. You were knowing with me, and you lied to me while we were here. I said, do you have him? You said no, and I don't know where he is. You said that to me. Okay, it doesn't matter. It doesn't matter because you still don't have eyes on him. He's talked to you. No, he's already talked to you because I can see where you guys have been talking. So if he's not here by 10 o'clock, I'm sending the cops. Oh, it is. It is. We're all losing our jobs, and he's losing everything. That's why I signed the car over to myself. I need the money. So I'm taking the car. I'm taking everything. So I'm about to go up there and go and get the car because the car is mine. I have it in my name. The mobile notary came. I don't have to send you copies. I already sent you the title. I already sent you a picture of the title, and you already saw what it looked like, so I'm not going to sit here. Okay, then you need to go back through the pictures, because you also said you don't have the pink picture that shows it. You also said that you don't show the call records, and that you believe Collin, even though he's there at your house. So you're illegally the wall. Tell him your house, and then he has to go back home. Is that correct? No, I'm asking you a specific question. Have you told him he needs to go back to his house? No. Did you tell him he needs to be back home to this house by 10 a.m.? And he needs to vacate your house. He does not have permission to be at your home. No.
That's what I told him.
Okay.
That's what I told you.
Okay, and that's not what he did. He called me and he said, he completely blocked me and he's completely removed himself from his Apple ID so that he cannot be tracked. So, right on that. No, his phone is off. His phone is off now. I told you that. I said if he didn't get in the car and come home, that was what was going to happen. And you said I will make sure he is there by 10 a.m. I told you I was going to if you didn't do this. No, that's not what I said. His phone is still on right now. His service is working. He's not going to answer. He's not going to answer. I showed you. Oh, stop. Will you listen to me? Do you see the call log? He did not try to call Monique at all yesterday. He is lying to you. I sent you his entire call log. That's from AT&T. That's not from his iCloud account. That's from AT&T. That's not what the court order said. It said he specifically has to leave a voicemail. But it doesn't matter because if he doesn't, that's fine. But I'm telling you right now, I have held everybody off. I said it's a private family matter. I'm sure he'll be back home. And everybody said, we'll give him 24 hours. That is until 10 o'clock today, Mom. That's why I said he had until 10 a.m. today. Mom, it doesn't matter. They gave me until 10 a.m. The police. I'm not speaking to you anymore. Either my son is in my driveway at 10 a.m. or we're not talking anymore. Okay, that's fine. You don't want to talk to me? That's fine. Goodbye. Computer, and I said, fine, come and get it. I told him to be back after work. It's on the fucking camera! I don't give a shit. I don't give a flying fuck. Did I tell you to let him stay at your house? Did I tell you to let him stay at your house? Have I or have I not told you multiple times in the past that he is never to stay at your house ever again? Not without my consent. And I have not consented. Do you hear me? Yeah, Collin. Answer to me. Answer me. Do you understand that you do not have my consent to have Collin? Do you understand that? No, answer my question. Do you understand? No, I didn't. I never threw him out, and it's on the ring camera. Never threw him out. Never threw him out. Never threw him out. for him, he meets immediately. If neither of those things happen, and I find out that he is still in your custody, I am standing in front of my ring camera having this conversation with you on speakerphone. I expect Collin to be here back at my house. And if he's not back by 10 a.m., I'm going to take it if you are holding him hostage and not giving him back to me. Thank you. I hope you have a great day. Goodbye.
Oh no, I hope that wasn't the last conversation that she had with her daughter. Well, if mom's trying to discipline him and then grandmother's, going behind her back and saying, "Oh, just come to my house."
I'll do it with you. And I can drive your car or you can drive the other Jetta and I'll just follow you. And I was like, okay. So his aunt lives there. I tried to go in, looked, it's not, his car isn't there. So I don't know where he parked it, where he put it. I don't know because I sent a text that said, hey, I'm selling your car. He decided to drive off with it. That was stupid because I'm signing this over to them and they said that they'll just report it stolen. So if he's caught, excuse me. So also in order for him to have a driver's license, I have to give my consent. Okay, otherwise they have to wait until they're 18. The fact that his name is on the title is there.
That's a good point, Laura. He was probably supposed to stay in the county because that was outside of her county.
Come on, Cass. Come on, Cass.
So the mom goes to grandmother's to get him, and that's where it happens. So I think right now he's technically breaking his probation by being over at grandmother's house because it is in a different county. He's not supposed to be over there. I think. I'm not 100% sure.
Hi, this is Catherine Griffith. I'm actually Collin Griffith's mom. I was just calling to confirm, did Collin quit yesterday? Collin Griffith, yeah, when he called in, I know he didn't show up to work yesterday. Did he quit yesterday as well? I just need to know. Is there a way to find out for me? This is his mom, because he hasn't come home. So we're trying to find him. Yeah. Yeah, I talked Fred. He's talked to me. I'm gonna call me back. Okay. Yeah, I just need to know Collin told him that he's quitting or what he said. Collin is missing and hasn't been home in almost 24 hours. Okay, thank you. Thank you. Also, did that ring my phone? This phone turned on. But you won't, and that's the problem. He's had it turned on do not disturb. He called me at 7:32 this morning and talked to me for 56 seconds and told me I was a crazy psychotic bitch and he wasn't leaving and that he was gonna stay there with mama and that that's not a violation of his probation. I sent him a picture. Like, if he's sending you all these things, did he send you the pink picture that I sent to him that shows specifically, like, the pink sheet of paper they gave me that says he can leave the county to go visit his grandma? But it doesn't say he can leave the county to go visit his grandma, and that's what he thinks it means. And he thinks it means without my permission, he can just leave and go and do that. Oh, yeah, everything that's it. No, it doesn't, because I specifically said, how are you gonna live on your own? No, I even told Dr. Wilson, no, I'm not leaving when I turn 18. You and I both know. Yes, I'm to leave. This is all. I guess this is my seat. You tell me, just sit back and stay with your mom. You'll sit and eat. There you go. Piece of shit that drives me crazy, or not. So he wants to do this. He wants to go to court. That's what he wants. He wants this. That's what he wants. I didn't change my phone. No, I changed the voicemail to say that nobody could call me. That was all I did. No, Mom, you're a fucking moron. My phone was never disconnected because if you would have tried to send a text, it would have showed you that it would have gone through. I went onto YouTube, pressed play for the violated the Wilson house. We already showed, he didn't show up to work yesterday, and it said, want to know where he went? The movies. I'll show you the receipt. He went to the movie theater. And you know what he's been doing all day while he's at your house? Because it's showing up every time he takes a screenshot of it on his iPad account. He's playing video games killing people. And I send those screenshots to you. So tell me how he's better off at your house where he's killing people. Pretend and making fun of it. And kidnapping them and having them tied to little chairs while he tortures them and kills them with other people in this little game scenario that he has. I sent you pictures of the screenshots where they're I'm telling you right now. No, you're not! Because I'm driving up there. Listen to me. I'm gonna be there before you. So it's gonna go down before you even get there. I don't know what to tell you. I guess you can call Collin and tell him to run, or try to run, because I'm coming up there, I'm getting the car is sold. He can either get in the car with me and come back home, or he can call me. Then you better tell him that he needs to give me a goddamn phone call in 10 minutes. He has 10 minutes. Because he's answering your calls, he's not answering mine. He's answering Lacey's, not answering mine. He has me blocked. Are you gonna call my son and tell him what I just told you? Call him and call me back.
Thanks for calling. State your name, number, and then play call, and I'll be back. At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options.
Hi, Collin, this is your mom. you because I know you talked to Detective Lacey. She told you that you needed to be home today, and apparently you said, no, you're not coming home. And so I guess you were explaining the situation, and that if you don't come home, you are going to be charged with violating your probation. So I'm just warning you, I am on my way to you to pick you up because you're not allowed to stay away from me like this. You're not allowed to be a mama's house, and I have every right to come and pick you up. So I'm coming to pick you up. Get in the car, or not get in the car. Run away. Up to you.
Okay, yeah, all right, back. Your call has been forwarded to automatic.
I threw him out and told him to come back when we got his shit together. Yes, I did. Okay, it doesn't matter. Check your text. Okay, because it never said that via text. So how fucking fun is it? I'm on my way. Oh, you need to get coder or no? Do I need to wait for the police to get there? Okay, we'll see. We'll see. Where's that mean? It actually is less. Go ahead. He has work from 4:30 to 8 today. 4:30 to 8:30. So. You have 9 minutes to call and tell me that. I mean, I'm getting in the car right now. I mean, then I'm getting back in the car and I'm going to pick him up. And if once I'm in the car, you haven't called me and told me anything. But that's not how it works, because he still has to go see Monique, and he sent Monique an email saying that he knows he violated his probation. You have, and it's 2:53. It's less than 7 minutes. Goodbye. He's not there. He hung it up. He won't answer when I call, so good luck. Tell him to do this three-way. Tell him to do this. I thought he was going to work. No. I don't throw him out all the time. That's a lie. So you plan on going to there and telling them that I throw him out all the time?
Was the last video that the jury saw the last video that captured Kathy alive?
Yes.
And did she leave the house in the clothes that she would die in?
Yes.
And did she have the brownish, yellowish Kate Spade backpack purse kind of over her shoulder?
She did.
And did you see that at the crime scene?
I did.
Was it soaked in blood?
It had blood on it, yes.
Now, let's switch subject matter for a moment now. Done with the videos, going to text messages. I believe you mentioned yesterday the basic process of getting forensic downloads and information off the cell phones. Were you able to, from those cell phones, something called a Cellbrite extraction report, generate a Cellbrite extraction report that detailed text messages on September 7th and September 8th?
Yes.
Describe to the jury a little bit. What does that mean, a Cellbrite extraction report?
It's just a report that's generated from the program that's used to download the phones through our computer crimes division.
From that, were you able to basically see all of the text messages between Kathy and the defendant on those last 2 days, the Saturday, September 7th and Sunday, September 8th?
Yes.
Were you also able to see the text messages between Kathy and her mom, Susan?
Yes.
And as the timeline kind of continues, and we'll focus obviously on those 2 days, would there be periodically photographs or pictures or attachments that Kathy would send to either her mom and or her son?
Yes.
And then some of those, were you able to kind of click on and print out?
Yes, I was.
Some of them, for some reason, is the pixelation such that you can't really see what it is for whatever reason?
Right. So some of the photographs, when you try to enhance them, they wouldn't enhance like through high definition. It would be completely pixelated and you wouldn't be able to tell what was in the photograph.
As far as you can tell, though, was there anything of major importance that you weren't able to see?
No.
Now, have you had an opportunity to see State Exhibit 188, which is the Cellbrite reports containing text messages and some photos from September 7th through September 8th between Kathy and her son?
Yes.
And were those obtained off of the defendant's cell phone?
Yes.
So is it a fair statement, even though that it was not possible to get a download from Kathy's phone, you were still able to see the content of the conversation because defendant's phone was able to be downloaded?
Yes.
At this time, Your Honor, the state would move State Exhibit 188 into evidence.
Any objection?
No objection.
It is received.
And then 196, Detective Peters, is that a similar exhibit but from Susan Detman's phone?
Yes.
And does that show text message conversations between Kathy and Susan?
Yes, it does.
Your Honor, at this time, the state would move State Exhibit 196 in evidence.
Any objection?
No objection.
It is received.
And for the record, that includes the text messages from September 8th between the two ladies, correct?
Correct.
Now,
from watching the videos, is it a fair statement that sometimes you can actually see Kathy sending texts or taking photos and then sending them to her mom or to the defendant?
It appears that she's texting and sending photos to someone in that moment.
And conversation-wise, are you able to see some things that Kathy refers to her mom, text messages that she sent as well, and subject matter that she was sending off to her son, the defendant?
Yes.
Now, did you come across, or did one of your expert computer crimes detectives come across a text message of note that was brought to your attention about an additional motive that the defendant had to kill his mom?
Yes.
Tell the jury just briefly, how did that come to your attention?
So early morning on the 9th of September, I received a phone call from our computer crimes detective who was going through the download and explained to me they found an interesting text message that I needed to be aware of.
After reviewing that, were you able to create an exhibit within an exhibit, so to say, meaning you isolated that specific text message and it was able to show the date and the time?
I did.
All right, we'll start with that, and then we'll backtrack to the text message conversations between Kathy and her son and Kathy and her mom.
Okay.
And for the record, this is a composite 188. I'll bring this to you so you can read it to the jury, but for their benefit, just so they can see visually what it looks like, we'll put it on the Elmo here. All right, this is basically a cover page of the Cellbrite extraction report.
Yes.
And then is that how it generally looks in terms of you can figure out the date, the time, who sent it, who received it, and the content of the text message?
Yes, it does.
And if I may approach, Your Honor?
You may.
Detective Peters, the jury will obviously have the benefit of this in the deliberation room to look at it up close. But if you could please, actually, before I get to that, mirroring that text message, were you able to also get a screenshot? Actually, if I may approach, please, Your Honor. Thank you. And I'm going to show what's also part of the composite 188 so the jury can see, and then you'll be able to explain it further. If you could please, Detective Peters, explain to the jury those 3 screenshots. What are those pictures of?
These screenshots are photographs of conversation between Catherine and Collin.
And at the top of the screen, what's the picture and name?
The picture is of Collin Griffith, and underneath it says Mom.
And whose phone did that come off of?
Collin Griffith's phone.
And how did you actually obtain a picture like that?
These photographs were copied in a screenshot format that was in the photographs.
So you were able to get screenshots of the defendant's phone conversation with his mom, is that correct?
Yes.
And is that the text, the full text conversation regarding another one of the motives the defendant had?
Yes.
All right, if you could please read the full context of the text message.
You want me to read this one or the Cellbrite?
The one in your right hand is the full one.
Okay.
But before you get there, can you tell the jury, according to the Cellbrite report, is that sent by the mom to her son, the defendant?
Yes.
And a time that it was sent and or typed?
Yes.
What's the time?
The time is 12:02 p.m.
And that would be on Sunday, September
Correct.
8th?
September 8th, 2024.
And then on the cell phone, what does it say? The time?
12:29.
All right, so at or between 12:02 and 12:29, the message is sent, typed, received. Is that correct?
Correct.
All right, if you could go ahead and read the full content of the text message.
Okay. Begins, the car isn't there. Not sure what you did, but it's being sold as we speak to CarMax for $15,600. Unless you'd like to reply to my text and tell me you're driving home right now. Period. Didn't think so. It's a felony to drive a stolen car without insurance. And if you wreck it, that's it. How much are you going to lose before you stop, Collin? ? I feel like you were trying to make me like your dad by talking away privileges, but you violated your probation, violated the rules of the house, and now you won't answer me. My mom or the cops, you've left me with no choice. Collin, the recordings of you admitting to killing blank and planning the murder, there are 4 different instances from my Ring camera, are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. Plus the recovered audio from blank's iCloud where you told your blank you hated me and I was an evil bitch are being sent to. My dad is sending his recordings of you telling him how you planned my murder back in February. Audio, video, email, text, and phone recordings are being sent. For the record, no, you cannot have a single one. Your attorney can request them. Good luck hiring a good one. And this goes into the next screenshot. Because the 751 clearly states I have to be medically incapable of caring for you, and I am not. You can keep hiding and running away from me. It is illegal for your grandmother to allow you to stay at an empty house 3 hours away when she was in Summerlin Key, which was on speaker and recorded as saying, I almost had an Amber Alert issued until she admitted after midnight you were in Auburndale, which is why I agreed to give you until 10 a.m. to cool down and come home. But I made it very clear you didn't come home. I legally don't have a choice but to report you as a runaway. Mama complained about you in February. You threatened her in February, but all of a sudden you go back to her and she takes you in, and I'm supposed to just let her steal you when I'm legally responsible and now in trouble for not reporting you as a runaway last night and waiting until this morning. That's not how this works. I'm giving the police your number, Mama's number, and DCF's all numbers now. They also have all 3 addresses. Also, Freddie is not registered in Polk County. And this goes over to the 3rd screenshot. And I have to go down to where it begins. Also, Freddie is not registered in Polk County with a dog tag. That's a fine. And Mama owes taxes on her other trailer she sold in the same neighborhood. Her HOA doesn't like you or her. The police are going to bring you home, or DCFs will take you and eventually bring you home. Either way, you fucked up and list your chance to get off probation by October 5th, 2024. All because you didn't want to help me mount a bookshelf that took under 30 minutes. Weed eat the backyard and clean your room because bugs were in the candy that you had all over. Remember, you chose this. You have 10 minutes to call me and fix this, Collin. I am signing this title and handing over the keys now.
So Detective Peters, that was roughly around 12 and 12:30 in the afternoon, correct?
Correct.
And Kathy would end up dead with a 911 call around 6:14 that same day, correct?
Yes.
So roughly around 6 hours later, is that correct?
Yes.
Now, I want to focus for a minute on the main part of that text. Collin, the recordings of you admitting to killing, you said blank?
Blank.
Did you? Right, but
It's
she mentions the name, correct?
Correct.
And planning the murder, there are 4 different instances from my Ring camera are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. So is she threatening him to expose him for him admitting to her that the killing previously was actually a planned murder?
That's what the text message indicates, yes.
And then was she also planning on sending recordings of the defendant calling her an evil bitch?
Yes.
Was she also threatening that her dad would be sending his recordings of the defendant telling him, that the dad, meaning the grandpa, that the defendant planned his mom's murder back in February?
Yes.
Now, was it clear from your review of everything that on the September 7th, or more so on the September 8th date, I guess, but that the defendant was having much more contact, like speaking to his grandma, than with his mom?
Yes.
And was Kathy hopeful that her mom would like pass on information that Kathy wanted Collin to know?
Yes.
With the hope of what was Kathy's hope stated over and over? What was she trying to accomplish?
Objection, Judge. She doesn't know what her hope was.
Did Kathy say on multiple occasions that she wanted or demanded that Collin return home by 10 a.m. on Sunday?
Yes.
Did she make any threats whatsoever of physical violence to the defendant in any of the text messages or phone calls?
No, not that I read.
Did she make a bunch of threats that doesn't appear she followed through on, such as canceling his phone service or shutting it down?
Yeah, it appeared she made threats to close it down permanently, but it was on and off sporadically.
Did she make threats to cancel his car insurance?
Yes.
Did she make threats to sell his car?
Yes.
Did she make threats at some point to like take him out of school or disenroll him?
Yes.
Now, turning to State 196, did she also send a similar text message to Susan, explaining to Susan, her mom, that she was going to be turning over videos of the defendant admitting to killing the person and planning the murder from the year prior?
Yeah, she wasn't getting the response from the defendant, so she texted the same text message, just advising her to tell him the same text that I read.
And I'm going to approach with State Exhibit 196. But before I do that, we'll stay just to be able to show the jury visually what it looks like. A cover page is at the Cellbrite report, where basically it goes in chronological order: date, time, who sent the message, who received the message, and the content of the message.
Yes.
And of course, this exhibit I referenced is the text messages on September 8th between Kathy and Susan. Is that correct?
Correct.
So as the day progresses, I'm going to direct your attention specifically to page 25 for purposes of the record. So correct me if I'm wrong, but if you could look at page 1 first, does that appear that text message conversation begins at roughly 3:50 a.m. on early Sunday morning, September 8th?
Yes, it does.
And continues obviously throughout the day. Look at page 25, which I also
Separated.
handed to you.
Yes.
What time on Sunday, September 8th, is that text message sent?
This text message is sent at 3:49 p.m.
So that would be roughly three or more hours after Kathy sent the text message that she would expose the defendant for the murder the year previously. The message that she sent the defendant.
Yes.
Now, if you could please read to the jury, what is it that Kathy texts her mom that pertains to the motive text?
I think I need glasses now after reading. It says, "Tell Collin the recordings of him admitting to killing blank and planning the murder. There are 4 from my Ring camera and are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today, period. Plus the recorded audio from Blank's iCloud account where Collin told his dad he hated me and I was an evil bitch are being sent to. Dad is sending me his recordings of Collin telling him how he planned my murder back in February. Audio, video, email, texts, and phone records are all being sent. For the record, no, you cannot have a single one. Your attorney can request them. So can Collins. Good luck hiring one because the 751 clearly states I have to be medically incapable of caring for Collin, and I'm not. You can't keep him from me. You can't hide him. He can't allow him to stay at an empty house 3 hours away when he blew up my microwave. You complained about him. He threatened you in February, but all of a sudden you take him in and I'm supposed to just let you steal my son. That's not how this works. Have your attorney call Eric Reyes on Monday so they can coordinate. I know you won't return Collin, and I know he is hiding because the car is not there at your house. I'm giving the police your number and DCF's your number now. They also have all 3 addresses. Also, your dog Freddie is not registered in Polk County with a dog tag. That's a fine. And you owe taxes on your other trailer you sold in the same neighborhood, and the HOA doesn't like you.
So is it a fair statement that Kathy told both the defendant and Kathy told her mom that she was aware of the way Collin had told Mr. Wantis he was going to murder her?
Yes.
So that wasn't just known by Robert Wantis, but Kathy knew that, correct?
Sustained.
Is one of the last things that was heard on the Ring footage that Kathy was giving the defendant two options, either get in the car with her, or 3 options: get in the car with her, follow her in his own car, or she would call the police.
Objection, Judge, I think that's a mischaracterization. That was between her and Susan. That phone call.
Do you recall similar text message things about that?
Yes.
Now, I mentioned earlier about some of the photographs that would be attached to certain text messages that would be sent between Kathy and her mom, and Kathy and the defendant. Going back to 188 to publish some of those photographs. Do you recall from yesterday, Detective Peters, the chores that the mom was unhappy with Collin not doing?
Yes.
Did Kathy end up doing the chores herself?
Yes, she did.
And did she send text messages to her son where she showed him how easy it was for her to complete the chores?
Yes, with photographs of the areas that she cleaned.
And it's now publishing for the jury's benefit from 188. Is that I don't know if that's a video or a screenshot of a video, but from the living room of her working?
Yes, that's a screenshot from the Ring camera in the living room.
That would have been on Saturday, 3:37, is that correct?
Yes.
After the defendant already left the house?
Yes.
Tell the jury about what Kathy's doing in her backyard there.
That's the backyard of their residence, and she appears to be rolling up some extension cord connected to what I would say is a weed eater.
And what day, time on Saturday, September 7th, did she do that?
6:20 p.m.
What can you tell us about that?
That's a Ring camera connected to the front of the residence. Appears she's taking out garbage.
What time on Saturday?
4:47 p.m.
What can you tell us about the time and what she's doing in that photograph, if you can tell?
Appears that she's cleaning like was observed in the video yesterday, and that's at 3:37 p.m. from the living room Ring camera.
And then a photo, what was in that? What subject matter was that in reference to?
That's the call log in reference to her attempting to contact Collin.
Now, of course, there's many pages of text messages. Does the subject matter stay pretty consistent between Kathy and Collin?
It does.
Now, finishing up the Cellbrite report, going to 196, some of the photographs, correct me if I'm wrong, but some of the attachments / photographs that were accompanied by text message that Kathy sent Susan. We'll begin with a certain one. What can you tell us about that, Detective Peters?
It appears to be a screenshot of a conversation between Catherine and Collin.
And help explain at the top of the screen, what does it say and whose phone would this be?
It says collin.griffith@icloud.com. That'd be Collin's phone.
And read to the jury, if you would, what the conversation between Kathy and her son was.
It says, Mom, believe coming from Collin. She's, Collin, what's going on? He says, you told me to leave. She says, I told you to leave because you were scaring me. You hurt me, Collin. He writes, I'm not doing this with you. And then a continuing text message says, Collin, you need to stop before this gets way worse. If you don't come home soon, you're going to face charges, serious ones. Just stop. This same thing a year later. Why? You just have to stop, Collin.
Now this one, there's a little different icon at the top. Can you tell the jury what that is?
That's an icon of the defendant with his name underneath of it as a contact.
And what does this message say?
From where it starts is you want to throw your, and I'm assuming that says life away like this and hurt me. I'll let everyone see you for who you are. All the comments and admissions made on Ring camera. You chose Collin now, or you choose Collin now. Respond that you will be home by 10 a.m. today. That's in 2.5 hours. Or don't respond and go back to court. You choose as always. And that's the last read you get at 7:28 a.m. Remember that you chose not to respond and instead just read the text.
Another photo of screenshots?
Screenshots appears to be a photograph, maybe of some court documents. And then the bottom says, you do not have my permission and you did not call Monique yesterday and notify her. You would be going, and it doesn't matter because you have to have my permission to, which you don't, and you've read my messages and called me and still refused to come home. Probation violations out the ass. You have until 10 a.m. That's it.
And then what is that?
That is the phone log. That appears to be a screenshot of a voicemail.
And was the subject matter between Kathy sent to Susan, was it largely revolving around Kathy trying to get Collin to come back home?
Yes.
Did Kathy make any threats to Susan in the text message that she was going to do physical harm to Collin?
No.
I might have a brief moment, Your Honor. I don't have any further questions right now, Your Honor.
Thoughts?
Judge, can we take our mid-afternoon break first? Thanks.
All right, folks, we'll take 15 minutes. Please leave your notepads in your chairs.
All right, please.
Wonder if she's wanting to talk with Collin before she does the questioning. Or maybe she's just got to pee. I don't know. Anne says this jury will 100% know he unalived his father when he is not here to testify, especially if they bring everybody but the father up to testify. You know, if you think about it, if the prosecution wanted to, they could bring up tons of family members, right? And then the father not be there, and they'd be like, why didn't he testify too if everybody else did? That could have been something that they could have done that they wouldn't even have to talk about. And you're the brother. That's the other thing too. The brother, Christopher, is he going to be called up? I mean, he was an adult by the time all this happened. So it's not like he's underage or anything, or was underage during any of it. I would love his take on what he thinks about Collin and the relationship with his mother. Because to me, that would be powerful. Like, if my sister got up and said, yeah, my mom could be this or that sometimes, you know, but at the end of the day, Carrie did this, you know, Carrie was wrong here, or Carrie was wrong there. You guys remember when we watched the Chandler Halderson case and his older brother got up and testified? To me, it just gave a lot of information to the jury that it was the parents couldn't speak. This was the gentleman who unalived his parents because they found out that he was a loser, didn't have a job, and was at home playing video games all day. And he wasn't in college either. But it just seems to me like hearing from a sibling really does kind of, like, you want to know what were the dynamics of the family. You can hear what others say. You can hear what an immediate relative says or something, but to hear from inside that family, from that was in there on a regular basis, that's very strong. Shelley said it's hard to believe the grandmother would be in the kid's defense knowing he planned to do this. You know, you got to figure the grandmother was probably trying to do the right thing by both of them because she wouldn't want to hurt her. You could tell they still had a good relationship to where the mother wouldn't want to purposely hurt her daughter. So maybe her intervening was trying to help some, but it didn't seem to be helping. Louise, I'm not going to read that, but that's funny. Collin. Oh yeah, Collin had seen that the self-defense worked in his dad's case, so he thinks it would work on his mom's case too. But they're not saying self-defense though. That's just it. The defense isn't on this case. They're not using the self-defense case. I have no idea. That's why I said the only thing they could do if they weren't going to do that was come in and paint mom to be a loon. Like she was so crazy and all over him that he was. I mean, technically, I guess it does kind of lean towards self-defense, but it wasn't. It was more of, I don't know. What the heck are they doing? Now that I'm saying all this out loud, what is the defense doing exactly other than victim bashing? Because that's all they've done since they've gotten up there is victim bash. And yeah, Hub, somebody else called that out too. I think it was Name. He never would have unalived her in front of the cameras. That's how you know that it was, number one, premeditated. Because if he'd have done it at the house, he would have had to do it away from the house, or else it would have been seen on camera. So he knew he couldn't do it there. And you guys, if you think about it, maybe that's why mom had all the cameras everywhere. Maybe maybe it wasn't to watch him, but maybe it was for her own protection. See, that's why I don't like that judge said that early on about he thought it was a bit, what was the word that he used? He thought it was a bit excess or impeding on his privacy that she would actually put Ring cameras up. Well, number one, the only Ring cameras that we've heard or seen from have got to be in the kitchen or the living room because we could not hear anything from anybody's bedroom. And somebody else had said it wasn't in the bedroom. It was just in the main living areas. So I feel like that's why. Cass is worried. He says, I know that I'm rooting for guilty, but I think I know how the defense attorney will use this audio tapes to trash. And she's going to try to say mom was just going crazy. Yeah. But I don't. Again, I'd never heard mom before I started listening to this trial. Like I'd never heard her say anything before. And I've not gotten that. I've gotten, does she get a little hyped up a little bit, stronger than others sometimes in some places? Yeah. But I have not heard anything that's made me think that she was like a bad person or a bad parent. Like many of you guys listening, what I've heard is a parent who's doing everything she can to discipline her child and to keep him out of trouble. And yet he keeps fighting her on it. She wanted to be his mom. She did everything. He didn't respect her at all. So she was at her last straw. She's like, okay, you don't want to respect me? You don't want to respect what I've put together for you to live here and be with me? Then that's it. Was it right of her to... I don't think she was blackmailing him to come home. I don't think that at all. Because we know that's what the defense attorney is going to come in and say, that it was all blackmail. But do you guys feel that it was blackmail? Sue Joy says, listening to all evidence, this is tragedy is so predictable. Obviously, it was inevitable, premeditated. He wanted to study law, right? No, mom sounds good yelling at her teenage son. Yeah. How many moms don't yell at their teenage sons? My gosh. Boys are horrible, aren't they? Like sometimes you got to yell just to get their attention. Because they just don't, men have a way of tuning women out. And I know boys do it to their moms. Hubgrass, defense is going with, Shelly said, the defense is going with self-defense because they said the mom attacked Collin. They can't say that, though, if they've got two witnesses that have already said that she was trying to leave the house. He grabbed her by the hair and pulled her back into the home. That's the part that keeps that. So, see, I feel like there's more holes on the defense side than there is on the prosecution side. Even though we've not been able to share everything with the jury, I still think that the jury is going to look at that and go, but yeah, you can't say that if he pulled her back in the house. Like she was getting ready to leave, but he didn't want her to leave. He pulled her back in. Let's see. Happy no one heard me yell while Bama says she's so happy no one heard her yelling at her son when he was a teenager. The first time charges were dismissed by prosecutor because they said Collin was abused and trapped. Right. That's the story that he told, but we don't know how much they investigated that story. So I'm interested to know more about that story. And I think that's why mom's be able to say what she can, because she knows truly that he wasn't trapped and he probably wasn't abused. He was probably kept from contacting her, but he wasn't kept from the rest of the world. I don't think. You guys, if he goes into trial in Oklahoma, we've got to watch it. Please tell me that they're not going to. Does Oklahoma stream trials? I don't know if they do. And said, cannot be blackmail. She was trying to help him. Louise says she used what she could to get him to listen to her. Unfortunately, he knew she was bluffing most of the time. Up until now, he didn't know she was bluffing about that. I feel like she pushed the button. Like, he just was waiting for that time. He was geared up for it. And remember what he said in front of grandmother? He was like, oh, we're going to do this now. Let's go, or whatever. Let's do this. He was waiting for that moment. He was waiting for the time that it was all going to go down. Clearly doing it at grandma's with no cameras. Perfect opportunity. Oklahoma, wake up. Do you think that do you think he lured mom there, or do you think it just all fell into place for him that she came there? Because he was answering grandmother's calls and everybody else's calls, but he wasn't answering mom's. Name said I would have been tossed out so fast. I know. My mama would have already kicked me out. A lot of people today think it's abusive if you take things from a child or make them do things around the house. Yeah, it's like you're not allowed to teach your children how to work for what they earn or earn what they get, and how to be not just that, respecting adults. I've noticed lately that it seems like there's more and more younger people that are less respectful of their elders. Now, there used to be a time, and I know I'm not that old, but there was a time when if an elder was speaking, you listened to them, and whether you agreed with them or not, you just smiled and shook your head, and that was it. There was just an automatic respect there. That also comes with anyone that was in law enforcement. So the fact that in today's world, the kids don't even view it that way, it blows my mind. They're not even scared of cops anymore. Hub thinks he did lure her. I would think that if they retried it, that yes, everybody would want to go back because then it would be like a real big story, right? But I don't know. It's still up to the court. It's up to the judge. Could be a state thing. I don't know if I've ever. Have you guys ever watched a trial out of Oklahoma before? I need to go over to this Mobile thing and see what's going on with this trial with this girl that unalived her boyfriend. It's just an automatic growing up respecting adults, yeah. The other lawyer, I do feel, and they were going to call him this morning. They were going to call him in, and they ended up having to cancel it because the judge decided that they weren't going to bring those text messages in with him. But that other lawyer seemed a little shady to me, the way he was responding back to Collin. Almost like he was telling him what to do and what not to do in order to make it look like it was self-defense.
Work yesterday. I have a couple of things to take care of while we wait for Mr. Levine.
And I can tell Your Honor that they're working on, I think, some further redactions because there were some words. I'll wait till Mr. Levine gets that.
Thank you, Janie. Is it Janie? Yeah, thank you, Janie. I was trying to think. I don't know if I've ever seen one streamed. Ambush. That's a good word to use. See, it's words like that I wish the prosecution would kind of throw into their dictionary here when they're describing things. Maybe he'll put it in his closing. Janie, you're not related to that other attorney, are you? Wasn't that his last name? Oh, Patrick. We are not going to bring you up play by play. It is too late in the day for that. You haven't missed much. What I can tell you is that the trial really didn't get started until later this morning. So you have less time to watch to get caught up. But you got to go back and watch Granddad's testimony. That was huge. And then the testimony that we just heard from the detective, it was mom calling grandmother and Collin. It was all on video. You need to go back and watch that. And you probably need to watch the medical examiner too that came on today because, so yeah, pretty much the rest of it. You got all weekend though to catch up. Yeah, Lauren said there was another case that came out where a man had been accused of something, another homicide, and then it wasn't tried. And then when he got convicted of a different set of people, there was homicide involved. He was tried for the previous one. Another one that comes up look at Daybell. Look at we were just talking about him the other day, Drew Peterson, the cop who had all the ex-wives that were missing. Oh, and wasn't it the other one too? The real famous guy? I can't remember his name. That unalived neighbor and some other people. Hub, watch your words. The K word is frowned upon in YouTube land. You feel like the defense attorney is trying to get some stuff in place right now? Do you think that's why there's a delay? I feel like she's a little nervous after all that last little go around there. It's the first time she gets to watch the jury as they're hearing all this stuff, and I bet she saw some expressions on their face where they were like, I can imagine that you can watch the jury and get some information from what you think they're going to do. Wouldn't that be interesting? There are actually people that have those jobs. That's all they do is watch the juries. See how they respond. It's okay, Hubgrass. I'm just telling you so you'll know. The Kentucky trial where the sheriff undid the judge. I would like to. I didn't get a lot of people watch when I did a thing on that, but I might, because I've kind of been watching that one. I feel like it's kind of scandalous. It's kind of like, it's almost like the Murdaugh stuff. There's a lot of behind the scenes stuff that's going to end up coming out in all this. I don't know if the man that was the victim was, in that case, necessarily all that innocent. There's a lot of bad goings on in there. Small town secrecy. Oh, you know what? Talking about the kid or whatever. I guess she didn't want to turn off his cell phone because in case of an emergency or something, but that would have been the next thing she could have done, was just turned off his cell phone. I just have to see when that goes to trial and if what else is going to trial around the same time. I really haven't sat down and looked at the dates of everything that's coming up lately. I know that, like, Corey Richens, I think, is in March. But yeah, I would like to do some more. I'm enjoying doing this trials. Are you guys enjoying being here? Wouldn't mind doing some for a bit. Definitely want to do Courtney Clenny, but I don't know how far out we are from that. All right. Turn your mic on, Judge. Have you guys tried Snickers with almonds yet? Oh my goodness, they're so good. I'm hungry. I just ate a grilled cheese, so I'm still hungry. Does he realize that he's muted? Or are we still waiting on the defense to get herself together? Because obviously that's what it was. That's why she wanted to go on break. And conveniently, he's giving her that extra time. Yeah, we'll try to do as many as we can. It's just, the only thing is, like, if I know a little bit, at least a decent amount about the trial, I'm good with going into it. It's just the ones that I haven't followed at all. I feel weird watching those with you guys because I have nothing to give to I have nothing to bring to the table as far as what happened. She's trying to redact something. Okay, let me ask you. So she's trying to go back and say something that the witness just said she wants it taken off the record. You can't unhear the stuff, though. Yeah, Marcella Chidester. Yeah, we've been following her. Is hers on the 3rd? Oh, yeah, we're definitely going into that one. I'm hoping they're going to show it. I think they will. But yeah, we've been following that one, so we should be able to. Oh, the comedy trials. I know, Cass, but see, here's the problem. There's never going to be another Brooks, like the comedy stuff that we were able to put together on that was like a 1 in a million thing. You don't get that out of the normal trials these days. You just don't, you just can't, it just doesn't happen. That was a very different and unusual circumstance. You know what's funny, y'all? My Daryl Brooks videos to this day are still getting tons of views. Is that not crazy? People just can't get enough. And then I have some of you guys that'll come in and you'll even know you're like, I'm just coming in for my fix just for the week. Watch one of them, leave me a comment at the bottom. Yeah, it was just, and now moving forward, like, I don't know if I could do that again. Now that I've been on YouTube for a little bit, I don't know if I could do, I don't know. I guess Brooks was just insane. He made it a circus. Can't speak for anyone else, but this kid scares me to no end. Oh, yeah. If this kid, that's what we keep saying. If he gets out, everybody's in danger. Oh, nice, Anna. Well, we're glad you're here. Hubgrass says the jury's onto it, especially when the lawyers are trying to hide so much. Yeah. Why didn't she object when she heard something? That part I don't know. She's trying to redact. She probably went back to his quarters again. Hey, Vicky Ann. We're glad to have you. She's trying to redact. Okay. Brooks wants to peel himself again. Oh. I know, but I think Sarah Boone's trial would not have been as amusing without James Owens. Because he just didn't, he added to her. She would have just slowed it down. It would have been a bore fest, I think. So I'm telling you, these guys are friends. They go back. The defense, I do notice this. I noticed that the prosecution he doesn't seem overly welcoming. So he's probably doesn't have that same friendship with all of them. Yeah, we might do Lori Vallow if it doesn't conflict. That is one that I have not followed though, Lori Vallow.
Please be seated. Storehill Cross.
Yes, thank you. Detective Peters, I wanted to flesh out some of the things that you mentioned on your direct testimony. And that was included in the ring videos and the text messages.
Okay.
In the ring video from September 8th, where Kathy is talking about, and you know what he's doing at your house? This is with Susan. He's playing video games where he's murdering and torturing people. Do you remember that?
Yes.
And her conversation implied that she sent some screenshots of that video game to Susan to prove her point.
Yes.
Right? And you've looked through the phone downloads?
Yes.
Okay, I'm going to approach and show you what's been marked as Defense Exhibit 1 and Defense Exhibit 2 and see if you recognize them.
Yes.
Okay. And do those appear to be the screenshots that accompanied the text regarding the video games that Collin was playing?
Yes.
Judge, I move this Defense Exhibit 1 and 2.
Any objection despite it's your case right now?
Oh, well,
No, Judge, that's not.
I should have asked about doing things out of order.
They are received.
So this is Defense Exhibit 1. Take a minute.
And do you know anything about this video game that's shown in the screenshot?
I do.
It's a Roblox game, correct?
Correct.
Rated for kids, like as young
All
as
ages
10,
up
all
up to
ages.
adults play it.
Right. But it's not limited to, say, adults only because of its violent nature or anything.
Correct.
And I'll show what's been admitted as Defense Exhibit 2. Same video game.
Yes.
So not quite as Kathy described it.
Yes.
Okay. I'm going to jump around a little bit. Going back to the house at 77 Hewlett Drive. You said that it did not appear that there had been a long, drawn-out fight throughout the house.
Correct.
But by the same token, if someone is being dragged throughout a house by their hair, wouldn't you expect they would be struggling against that?
Would I expect there to be struggling? Yes.
Unless they were going willingly with the person in
Sure.
throughout the house. Right.
That's the other option, yes.
Right. So if somebody is being dragged unwillingly, and they are struggling, so let's assume that too,
Mhm.
you would expect items in the house to be disturbed.
Possibly.
The blood that was on the backpack that Kathy was seen wearing as she's leaving her house on September 8th. I want to talk a little bit about that. You do know that Collin's phone was found in his car,
Yes.
right? And the 911 call came from Kathy's phone, right?
Yes.
And that means that Collin had to use Kathy's phone to call 911
Yes.
because he was the caller.
Correct.
And it's possible that Kathy's phone was in her backpack, and that Collin had to go into the backpack to find the phone to be able to make the phone call to 911.
It's possible.
The Ring cameras, you said that there were cameras in the 5 different cameras, one an outdoor, one on the doorbell area,
Yes.
right? Then one in the living room,
Correct.
one in the kitchen,
Correct.
and then one in each of Collin and Kathy's bedrooms.
Yes.
And the Ring videos we've seen are from the kitchen Ring video.
Yes.
Camera, rather. All right, so before we get to more about those Ring videos, you could hear Kathy tell Collin to get out and not come home, correct, on September 7th?
Yes.
And she told him not to come back even if he was bawling his eyes out, right?
Yes.
And she made him or told him to give her his house keys, right?
Give her keys.
Give her the house keys
Yes.
and leave them there.
Yes.
And then from the living room video camera, you can actually see her locking the door behind Collin after he goes outside, correct?
Yes.
So he would not have been able to get back in that locked door.
Unless there's another key outside that I'm not aware of.
The living room video, the living room camera actually faces towards the kitchen. So it's almost the same view, but from the opposite direction.
Right.
There was a point where Kathy was waving her hand in front of, it looked like the TV, but it would also have been in front of the Ring camera.
Yes.
Right before she says, and it's all being recorded on my Ring video.
Yes.
Okay. So she clearly knows how to make sure that some things are captured on that Ring camera.
Yes.
Now, the clips that were shown to the jury both yesterday and today, those aren't everything that happened from September 7th and September 8th, are they?
No.
I'll get to those in a minute. I'm sorry I'm not being very organized here, but before I get to those Ring videos, I want to talk a little bit about the text messages. Okay, so this is sort of a different version of the text messages between Kathy and Collin.
It's been marked as Defense Exhibit 3. I'm gonna approach and see if you recognize it. It's just in a little bit more readable format. Thank you.
Yes, I recognize this. Yes.
And even though it's not my case, I'd like to admit into evidence Defense Exhibit 3.
Any objection?
No objection.
It is received.
All right. I'm going to talk about some of the things that Kathy told to Collin over text message. Okay, so can you see it on your monitor as well?
I can.
Okay,
It's
so
easier to read on this one.
on the bottom one from September 7th at 7:01 p.m., she talks about wanting him to return the cell phone and the MacBook that were purchased for his education. Then she said you don't have permission to be at work, which is a probation violation because you refused to do your chores for the day. Are you aware of any probation condition that required him to not be at work?
No.
Okay. So obviously not an accurate statement, right? Then she says you violated your probation by having physical contact with me. It implies that that happened right before he left, but there was no physical contact that you saw in any Ring video that you've reviewed, right?
No.
I'm in fear for my safety and the safety of the vehicle which you took in, which is in my name. I am canceling the car insurance policy until you are 18. You may not drive the Jetta as long as my name is on the title insurance. So right there, she's telling him it's illegal for him to drive his car, right?
Right.
But then she turns around and says, drive home right now or you're going to be in trouble.
Yes.
Do you know if she ever did cancel his insurance?
I do not have proof that she canceled his insurance, no.
Do you know anything about the title to the car, whose name it was in, anything like that?
I believe it was in Mom's name, and I think Colin's name was on it as well.
So both people's.
Yes.
You are being withdrawn from college as you have shown yourself to be capable of to be capable of taking care of chores around the house, and then she lists them. So she was going to prevent him from continuing his college education over chores. At least that's what she claimed.
It appears that way in text.
Okay, that was it on that one. Here it says that it's 8:28. I'm reporting the Jetta stolen. You can't drive the car without insurance and without parental consent. Do you know if she ever reported the Jetta stolen?
I don't have proof of that, no.
And was it even stolen?
No.
Because his name's on the title. And then she talks about communicating with Detective Lacey. You're aware that he had been communicating with Detective Lacey Zanoniani and that she encouraged him to stay at Susan's house.
Yes, through text message.
And Kathy actually talked with Detective Lacey by phone on the 8th before she went to Auburndale, right?
Yes.
And Detective Zanoniani told her to stay home. You don't need to go up there. Let Collin stay with Susan.
I don't know if it's those exact words, but something of that context, yes.
Then right here, Kathy is threatening to close his Bank of America account so he doesn't have access to save money to put gas in his car, right?
Well, I don't know the reason, but it is saying I am closing your bank account since it's tied to my name.
Okay.
The top message talks about how Colin's probation paperwork says he cannot leave the county without her unless it's for school. There was a screenshot of the pink paper that we talked about that specifically says he can leave the county to visit his grandmother, Susan Detman, right?
Yes.
Okay. And you're aware of the 751 plan that existed between Susan and Kathy, where each could have custody of him and it would be perfectly legal?
Yes, I'm aware of it.
I'm going to approach and show you what's been marked as Defense Exhibit 6, 7, 8, and 9. You may not recognize them, but take a look. See if you do.
Thank you. So this would be the 751. This is the first time I'm seeing it, but I'm aware of it. Yes, ma'am.
Judge would like to admit into evidence those that I just mentioned. It's the signed paperwork filed with the Charlotte County Clerk of Court, so I think you could take judicial notice of them as well.
Any objection?
No objection.
They are received.
Okay, I'm going to publish them then. So the first document is a co-petition to establish temporary custody of minor children by extended family. And you would agree that it was signed and notarized by several people, right?
Yes.
Including Catherine Griffith and Susan Detman.
Correct.
The next document is entitled Agreement and Consent to a Petition under 751. Also signed by Catherine Griffith and Susan Detman, along with attorney Jeffrey Rapkin.
Yes.
And that was Defense Exhibit 7. Defense Exhibit 9 is the acknowledgement of service of these documents signed by Catherine Griffith.
Yes.
Okay, and that was December 10th of 2023?
Yes.
And then the final document, which is Defense Exhibit 8, so out of order. It's an order granting the joint petition. Signed by Judge Mary Evans on, let's say, what was filed. I thought it said it on here.
I think it's under the signature.
Okay. It is. I can't read it.
January something of 2024, I believe.
Yeah, thank you, everyone. January in 2024. Okay, suffice it to say that everybody was on board with both Susan and Kathy being able to make decisions for Collin and have custody of him.
It appeared so, yes.
Oh, yes, the pink paper with the permission to be out of county to visit the grandmother. It says that we'll notify Monique. You're aware that Collin did in fact notify his probation officer by email
Yes.
that he was going to Susan's.
Yes.
It was a weekend, so she wouldn't have answered the phone at her
There
office.
there wasn't a response.
And then Kathy says that she's going to call the police and send them. She didn't ever call the police that you know of to send them to pick Collin up.
Not to my knowledge, no.
Nope, she was just doing what normal parents do, throwing threats out to get him to mind. So you have nothing. Miss Attorney, you have nothing. I'm sorry you're having ads, but every time you have an ad, I get paid.
Okay.
It's part of the gig.
Then there's some texts about selling his car, and it's right here. Is that where it was? Okay, here we go. Second one, where she claims she had gone up to Auburndale, tried to get into the community. The gates wouldn't let her in. She's at the dealership in Lakeland. All this elaborate explanation of how she's going to get rid of his car, but none of that was true either, was it?
No, not that I'm aware of.
Well, we see her on Ring Video at
Correct.
all hours up until mid to late afternoon on the 8th,
Right,
right?
and that was at 10:54 a.m.
I agree, Bama. It's time to call it a day, Miss Defense Attorney. If she ever had to deal with a child that was hard to deal with, she probably wouldn't know how to do it.
She talks about Epic Towing. So she even comes up with the name of a tow company that's going to go pick up the car, and a specific amount of time within which they'll be there. That wasn't true either, was it?
I don't have proof that she called a towing company, no.
Or that a towing company showed up
No.
in Auburndale.
I don't have proof of that, no.
So suffice it to say, a lot of the things that Kathy claimed were just simply untrue.
Threats, yeah.
Are you aware of some texts between Kathy and Collin in late August of 2024 where she tells him that she's feeling down again and is maybe going to go into a facility for a while?
Yes.
Okay, so I'm going to approach and show you what's been marked as defense exhibits 4 and 5.
Yes, I'm aware of that. Yes. Yes.
And they appear to be the texts from Kathy to Collin.
Yes, it does.
Like to admit into evidence defense exhibit 4 and 5.
Any objection?
No, Your Honor.
They are received.
I'll publish them real quickly. So down here on 7/24, no, that's not the one. Oh, that was the one. So it wasn't a week or so before. It was over a month before. But she's telling her son, just so you know, I'm not doing so good. I just had a long conversation with my mom, and she was basically my mom. She told me that she has stage 3 cancer. She's in Georgia, and she's not going to help me with DVC. Do you know what DVC is? It's a Disney Vacation Club.
Oh, I know what that is, but I didn't know the abbreviation for it.
And that she could care less. And so in response, I got really upset and quit my job. And sorry, so this was not related to her mental health. It was about her quitting her job. Are you aware that she actually quit her job or did not quit her job?
I'm not aware. I don't have proof she quit her job.
And then also on July 24th, Kathy talks about how she sold the house and that this story about how somebody has assumed the mortgage and she was going to move out. Any proof that any of that was true?
No, ma'am.
And on Defense Exhibit 5, she says that she spoke with Dr. Goldstein today, and Dr. Goldstein wanted Kathy to go to an inpatient facility for some time, and that she was thinking about doing that. So that's what we were talking about Kathy communicating her mental health issues with her son.
Intensive therapy, it says, yes.
But inpatient for 72 hours or so.
Yes.
The Ring videos that were played, you already said they didn't include everything that happened that day. There are actually some parts that I wanted to see if you remember seeing. One is from September 7th, where Kathy is trying to get a lid off a cup. Do you remember that part?
Vaguely.
And she then starts yelling at Collin and blaming him for cutting her hand.
Vaguely.
Okay.
I'd have to see it again.
Okay, well, that's what I'm hoping to do. Is this Defense Exhibit 10? Do you have any objection to it?
No, it's fine.
Judge, I'm going to
You're
publish
offering it?
yes, I'm offering it into evidence. Defense Exhibit 10. It's a portion of the Ring video from September 7th, 2024.
You have no objection.
I don't object.
It is received.
And I'm only going to play a portion of it because a lot of it duplicates what has already been shown.
Okay, definitely not Collin did. Wow, I can't even open it. Collin, don't ever close my cups that fucking tight. I can't even get the fucking lid off. I just cut my hand. Jesus Christ. I'm a full-blown sweat from trying to open a fucking cup.
In that clip, does it appear that Kathy actually cut her hand?
Doesn't appear so.
And then finally on September 8th, we saw a lot of clips of Kathy on the phone with a variety of people, right?
Yes.
Do you remember a portion that was left out of the exhibit that was already entered into evidence where Kathy says it's not about to be a threat, it's about to be real shortly before she leaves the house?
I think that was played. I think that was played from the kitchen. There's two areas that you can get that same audio from, the living room and the kitchen. I think that was played.
Okay. Well, I'm going to play it again just in case.
Yes, ma'am.
But this is Defense Exhibit 11 from September 8th. I would like to offer it into evidence and just play a portion of it.
Any objection?
That's fine.
It is received, excuse me.
Thank you. 2130.
how he's better off at your house where he's killing people, pretend, and making fun of it, and kidnapping them and having them tied to little chairs while he tortures them and kills them with other people in this same story that I sent you the pictures.
It's 21:30. That's okay. That's good.
It's not about to be a threat, it's about to be real.
And I apologize if that had already been played.
Yeah, it was played on the other one.
Detective Peters, when you were shown pictures of Kathy and Collin on various trips, you said that they appeared happy. In some of these clips and in some of the text messages that the jury's seen today, Kathy appears quite angry, correct?
Yeah, she appears frustrated. Yeah, angry.
Angry. And it was in that state that she left her house and went to Auburndale against advice from several people, right?
I don't know who the several people are, but she did leave at that time to go to Auburndale, yes.
And she was yelling on her way out the door.
Yes.
But you're aware that several people told her not to go to Susan's house and to let Collin stay there.
Detective Lacey, yes.
And Susan.
Susan,
Yeah. So at least two people,
yes.
but she ignored them.
Yes.
I don't have any other questions, I don't think. If I could have one. Nothing else?
Redirect,
Nothing further, Judge.
is the witness release?
Yes, sir.
For
today.
For today.
All right, if you're needed back, you'll get a call.
Yes, sir. Thank you.
I think that's it for the day, y'all. Unless they have something they want to discuss.
Or that will conclude the witnesses for today.
Ladies and gentlemen, we're going to break for the weekend. Remember not to start to think about how you might decide the case. Again, not talk about the case or anything else. Remember to be careful with the news. Enjoy your weekend, and we will see you Monday morning at 8:30.
All rise, please. Okay, be seated.
Anything before the weekend recess?
No, Your Honor.
No, sir.
All right, everybody, enjoy your weekend.
Thank you.
Two.
All right, everyone. So put a 1 in the chat if you feel like, not you, but if you feel like the jury is leaning towards guilty. Put nothing in the chat if you don't feel like, just put nothing in the chat if you don't feel like they're leaning guilty. I feel like that last video was really damning to the defense. I don't think they're having an affair. I think they're just been friends too long, and it's like the prosecutor is like he's like an outsider. You know, it's they're cliquish together. That's the word I'm looking for. Blanco says he doesn't know, but Blanco, you haven't been here all day today either, though. So, oh, and then you put a 1. You're undecided, Blanco. I don't like that indecision. Yeah, I don't know, guys. I think it's going well. I think it's a lot better than it was earlier. Let's just, if we'd have left on this note, that we left yesterday on Friday, I would have been mad. You know? I want to thank y'all for being here. I'm going to try to put some random videos out for y'all this weekend. But in the meantime, I do have a video link to this at the end that will lead you over to Monday's morning's stream for this trial when they pick back up. So, actually, I'm not going to close. Yeah, I am going to end the stream. So y'all have a great weekend. If I don't talk to you, stay safe. And again, thank you so much for being here. I appreciate your support, and I appreciate you hitting that like button if you've enjoyed being here. Thank you so much.